we ask everyone to enter the hall, take the seat. We will get introductions and we'll immediately start in the next 3 to 4 minutes. Akho ngxaki apha, asinangxaki. Kusegqibeka. So those are the words that when you go back to Limpopo, when you go back to Venda, when you go to the Western Cape, at least you must have pick up. Without wasting much time, we will now call upon the Judge President of the Eastern Cape, Justice Mbenenge, to welcome you to his division. Justice Mbenenge will call you to the podium.
Program Director, Mr. Nochesi, distinguished guests, Justice Madlanga, if I had known that you would be attending this gathering, I would certainly have deferred to you, especially by reason thereof that you come from the Eastern Cape. You are one of those who make us very proud, and keep up the good work that you are doing at the Constitutional Court. You can raise your hand so that bakbone, khatel. Ladies and gentlemen, may you all be greeted this morning. It was on 17 March 2018 that I was commissioned to officially open NADEL's 31st National Conference and AGM at Southern Sun Hemingways, East London. That's not so long ago. Ndiyabona ke uba nibetha nibuyelela okwezulu laseMthatha eMpuma Koloni. In other words, the Eastern Cape is frequently visited, as does the stormy weather in Umtata. The reason for this is not far to seek. The Eastern Cape is not only home to legends, it has natural beauty that makes it the precious jewel that it is. The choice of the friendly city and the gateway to the adventure of the Eastern Cape put the crown on everything that you thought of. And that friendliness at Gqeberha must have welcomed you to this occasion. But I must do my part. And it is indeed a great pleasure for me to take part in this august occasion. I do not doubt that much thought has been given to the choice of the theme for the weekend. We have all had to navigate unprecedented and uncharted waters. 3 deadly COVID-19 waves have resulted in some of us becoming seriously ill and losing friends, family members, or colleagues who have succumbed to the virus. And at this point, my thoughts are with the family and friends of the late Comrade Patrick Judge, the first judge to fall victim to the first COVID-19 wave. We live in perilous times. The 4th wave, Omicron, is upon us. Already in medical circles, there is talk of P, Sigma, Tau, Upsilon, Chi, Omega, and so on. Now, these predictions take us right into the year 2023. It does not look like we will resume a COVID-19-free society anytime soon. I would like to congratulate the organizers of this gathering for the relevant theme they have chosen, and indeed, much vigor is needed to create a future very different from our past. The uncharted waters which we navigated taught us many a lesson. During this period, consultations, conferences, and the like were held differently. There was a time when the marketplace was empty and courtroom debates ceased. In our division, the directions for the management of the High Court during the national state of disaster were promulgated on 12 May 2020. These directions recognize the right of everyone to have any dispute that can be resolved through the application of law decided in a fair public hearing in a court of law. In terms of the directions, it is in the public interest that persons exercising their right of access to a court do so in light of the risk of the rapid spread of COVID-19 and its impact on public health and welfare. We have come to know of pre-trial conferences held by participants located at different venues. And until quite recently, it was inconceivable that courts could operate virtually. Some of our colleagues have not seen a courtroom for the past 18 months, but they have continued operating. As far as I have been able to ascertain, the Constitutional Court and the Supreme Court of Appeal are still holding virtual hearings. Despite all this, the development of our jurisprudence has not grinded to a halt. Law reports are abounding with cases enunciating profound legal principles delivered during the period under discussion. Landmark judgments such as the Electoral Commission versus the Minister of Cooperative Governance and Traditional Affairs and others, which involved a quest for the postponement of the elections, were handed down during this tumultuous period. It was during lockdown when the SCA handed down judgment in Lungisa versus the state, a judgment penned in isiXhosa and English. The various high courts and other courts of the land did their part in granting access to the courts to those who with justiciable disputes during the hardest of times. But how has this benefited the constituency that we serve as the legal fraternity? Depending on how you look at it, I believe litigation costs have been rendered affordable and courts of law more accessible. Members of the bench and practitioners found different modes of maintaining collegiality. I'm talking about those WhatsApp groups that we have opened and other modes of interaction. We've been able to lift one another during this dreadful period. And due to uncertainty that beset all of us, heads of court have had to recognize that the best system for case management is one that reevaluates court roles weekly rather than on a quarterly basis. There is no doubt in my mind that we will carry some of these practices into the future. NADEL upholds democracy. Ladies and gentlemen, in your quest to shape the future, you will need to ensure that a balance is struck between might and right. What do I mean by this? I mean that the power of the state must be limited so that there is no abuse of power. A balance must be struck between rights and responsibility so that while citizens expect the government to do things for them, such as protection, health services, education and housing, they bear the correlative duty to obey laws and pay tax. I'm talking about striking a balance between the right of the majority and the protection to be afforded the minorities. Remember, democracy involves a greater balance in society so that there is greater equality for all at all times. It is within the context of these tenets that we must ask ourselves the question, how do we become relevant in these changing times? There is no doubt that what lies ahead is very different from the past to which we are accustomed. We all have to move with the times. The medical field has learned lessons from the COVID-19 pandemic for improving hospital care and healthcare delivery, and these are preparedness for unexpected increases in demand for services, emotional support given to healthcare workers, the use of technology to connect families near and far, maintenance of caches of supplies and diversity supply chains, and finally, the reduction of the benefit of unnecessary documentation, let me say, to mention but a few. Some, if not all, of those lessons are worth emulating. Digital courts, video conferencing, and case lines are going to be the order of the day. In this regard, paragraph 65 of the Eastern Cape Disaster Management Directions is of relevance. It states that case lines allows litigants to file pleadings and all relevant court processes digitally. The case file is available for use by the parties and the presiding judge during case presentation at trial, or in the case of applications and appeals during argument. Now, these modes of operation will cast a heavy onus on professional bodies such as NADEL. It is going to be incumbent on them to train their members to be relevant and move with the times. I'm not sure how far we can go in creating a different future, but I'm certain that NADEL will conscientize its members about the changes that are shaping the future and create an environment that gives effect to its mandate as enshrined in its constitution. Changes are taking place at a very fast pace. We cannot afford to be passive, and I think that is what the theme of this conference seeks to achieve. Intention on the part of NADEL and its members, engagement, involvement, and the like. Before I resume my seat, allow me to also congratulate the organizers of this conference for making the late former Chief Justice Langa central to this weekend's proceedings. I'm reminded of what he once said, and I quote, "I am impatient with the rate of change. There is a trickle of black counsel coming to the Constitutional Court. The majority are still white, but I don't wield the power yet." On another occasion, he said, I quote, "The difference between the past and the present is that individual freedom and security no longer fall to be protected solely through the vehicle of common law maxims and presumptions, which may be altered or repealed by statute, but are now protected by entrenched constitutional provisions which neither the legislature nor the executive may abridge. It would accordingly be improper for us to hold constitutional a system which, as Sachs J. has noted, confers on creditors the power to consign the person of an impecunious debtor to prison at will and without the interposition at the crucial time of a judicial officer," unquote. You will see that he was an advocate of change, and that is why we are gathered here this morning. I trust that we will all benefit from tomorrow night's memorial lecture, and I wish you well as you deliberate with each other at this conference. I thank you.
Thank you very much, JP. Now we will proceed to the messages of support. But before that, I must acknowledge some of the dignitaries, guests that have joined us. I ought to have done that anyway. But we will acknowledge guests as they come. Firstly, you are all important. That's one important thing to understand. So if we don't acknowledge you, which is something we always avoid, to acknowledge individuals, because we forget others. Somebody will think that he was not important. We are all. In fact, this is a conference of delegates, voting and non-voting. We have been joined by the Judge of the Constitutional Court, Justice Matlanga. I've seen his name in that list of other candidates. I've seen he's one of them there. There is, maybe you are sitting here with a potential Chief Justice. That's how this conference is so important and would be memorable to us. Thank you, Justice Matlanga, for joining us. Justice Beneng, I've just already introduced. We have also been joined by Mr. Mabunda. Mr. Mabunda is the former president of the Black Lawyers Association, a member of the JSC. He is now in the LPC. There will be change in the LPC. They will not charge us more money. Mr. Mabunda is there. He cannot allow that, I know. Mr. Mabunda don't allow them. And we are, in our midst, she will be addressing us shortly. The chairperson herself of the LPC. I mean, the LPC has started had a good start. The first chairperson of the LPC was a woman, Ms. Lepo. Now again is a woman, Janine Maybeck. So the LPC is doing well. She's an activist by her right. You know, she's part of the women group that have been very committed to transformation. Well, I know we have worked in the Law Society of the Cape some years ago. She is a committed driver of transformation. We'll explain those concepts later. We have the president of the Law Society of South Africa, Mr. Mr. Van Rensburg. He's a friend of mine, personal friend, but he often raised certain things with me that he cannot be a friend to me because I'm too much younger. But when we look between us, you know, man, when we come closer, you can't say who is young exactly. So there's Mr. Van Rensburg. He's a friend of mine for some time. Yeah, and we have other guests whose name from time to time we will mention, but I have not picked up. I just highlight those. At this stage, one person, I'm not too sure whether I should include in the list of guests. I was trying to avoid this, but unfortunately I cannot. The former president of NADEL, the current president of SATLA, the advisor to former President Mbeki, the CEO of the foundation, I don't know. I mean, the lifetime member and honorary member, I'm sure he will be given one day, honorary member of NADEL, Comrade Max. He is with us. He's not been with us for quite some time, but he is here. Comrade Max, we are happy to have you. There is also here our stalwart, the Commissioner for Human Rights, one of the founding members of NADEL, and a combatant. He's a combatant, a former member of Parliament, currently the member of the Human Rights. He is also our election officer. He's a permanent election officer here. Comrade J.P. Sibanyan is one of those few comrades who understand really what it meant to be a black lawyer in the 70s, 80s, where you have to go and practice at your own home in township. You cannot be allowed to practice in town. He suffered for that. He gives some stories that if you can listen to, you must be thankful to these comrades. Thank you, Comrade JP, for your commitment in the revolution. Some of them were selling even at that time. I still do. There are those who sell us even now. Those, you may think that the sellouts of that time are different from this. No, these ones are extremely difficult because they are selling the wealth. They are not selling anything. They are selling the entire nation. Now, at this stage, I will call Comrade Buki, the chairperson of the branch, that is of the Gqeberha branch, who will then deal with this session as we receive messages of support from various organizations and ambassadors.
Thank you very much, my President. Comrade, esteemed guest, we welcome you. And without delaying us and in introducing our guest speakers, as you know, we have a hybrid system in place, which is both virtual and obviously face-to-face. Please permit me to welcome and introduce the representative from NADEL, International Association of Democratic Lawyers. And if we will just welcome him, please welcome Mr. Edre Olalia to the scene.
Can I speak now? Hello? Can you hear me well? Okay. So it's my turn now, okay? All right. Mr. Mibusu Nagyetsi, NADEL President, Mr. Lawrence Manye, Vice President, Ms. Nolita Jolly, Secretary General, and other office bearers of NADEL, eminent keynote speakers and other distinguished guest speakers, and of course, Max, Krish, and Pazo, and sisters and brothers in the struggle. Good afternoon. From the other side of the world, Manila. As transitional president of the International Association of Democratic Lawyers, it is with extreme pleasure and honor to have been asked to give our message of support and solidarity to your national conference and annual general meeting with a theme that is both inspirational and aspirational, much vigor needed to create a future very different from our past. The topics of your AGM are not only very interesting, but concern very concrete, grounded, and practical questions and issues, both at strategic and practical levels, within the framework of promoting and defending the constitutional order to ensure access to justice and the realization of civil, political, and socio-economic rights. Your AGM team is a continuing clarion call, not only for NADEL, but also for IADL and other peoples of the world that continue to struggle for equality and justice. The very motto of NADEL that has been its North Star since its inception, and which is the very close and tight link that binds us all together. Indeed, when NADEL was formed in 1987 as a collective response from progressive formations within the legal profession to advance the struggle for democracy and freedom in South Africa, it has, as IADL's national affiliate, actively, selflessly, and valuably lent its support to issues and campaigns of international human rights concern. We appreciate NADEL's profound voice and studied views articulated by your outstanding representatives in IADL's Bureau and Council on issues concerning the legal profession, human rights advancement, and the attainment of an equal and just society, voices and views that reverberate and transcend both within and outside South Africa. It is in this correct spirit of this collective human and political kinship that we send our warmest greetings to you all. As a worldwide body of democratic lawyers and jurists from over 90 countries and territories with UN ECOSOC consultative status, we, in IDL, together with its vibrant national associations like NADEL, will continue to contribute to the development of international law, engage in campaigns that would lead to progressive changes in international humanitarian law, like the universal acceptance of the importance of the right to self-determination and the protection of national human rights before UN bodies and international courts. Through the efforts of our illustrious pioneers, IADL helped to establish fundamental concepts of international and domestic law, including of upper and the recognized legal right of peoples to self-determination. South Africa, as you know, is very close to the heart of IADL. For it was 25 years ago, in 1996, when IADL held its 14th Congress and 50th anniversary in Cape Town. It was the Congress which celebrated 2 years of a free South Africa and which was attended and greeted by President Nelson Mandela, who was elected IADL President Emeritus. Prior to this, IADL acted as observers at political trials of Mandela and numerous members of ANC. We would have held our 19th IADL Congress there in South Africa after the last one in Brussels in 2014, were we not overcome by the ongoing pandemic, which sadly continues to rear its vicious head and now lamentably threatening us anew with new variants. In fact, we were in Joburg and we visited Soweto as an advanced and preparatory team last January 2020, where we saw firsthand your past and your present, including its contradictions, and where we witnessed your admirable competence, commitment, and comradeship. And this virus has made socio-political situations more complicated, and the defense, promotion, and protection of individual and, more importantly, collective or people's rights more challenging. But with renewed vigor from you and from all of us, these are not insurmountable, and we shall contribute in creating a future very different from our past. So, from South Africa to Palestine, from Venezuela to the Philippines, from Turkey to Western Sahara, from India to the United States, we shall overcome all these challenges for a better and more equitable and just future for humankind. We shall be there, in the ports, in our offices, in the farms, in the factories, in the communities, in fora, and in the streets, to march and sing the same songs of the struggles against the violations of human rights of groups and individuals and threats to international peace and security. And we shall continue to protest racism, colonialism, and economic and political injustice and all forms of reaction until all the exploited and oppressed peoples of the world are able to dance in the streets. Until then, please accept our heartfelt greetings of comradeship and international solidarity. Long live international solidarity. Mabuhay kayo sa NADEL. Thank you very much.
Thank you very much, Mr. Andre Olalaye. We really appreciate that message, and your relationship is obviously, we value it a lot, and we look forward to better and even improved relationship in the future. Thank you very much. For the next guest that we're going to have, it's home-based, but not with us. I'm going to go to to introduce to us a representative with a message of support from PABASA, the African Bar Association of South Africa, and to give and deliver the message will be Advocate Rajab Bodlender. Okay.
President Nochesi, NADEL NEC, Justice Madlanga, Judge President Lenenge, Chairperson of the LPC, honored guests, colleagues. Good morning, Molweni. I'm delighted to be invited to offer a few words today at this important event in the NADEL calendar. NADEL and PABASA have had a very close working relationship with many of our members individually over the years, and certainly from the inception of PABASA, which is the first bar established post-democracy in South Africa, with the sole focus of transforming the legal profession. Now, on behalf of PABASA, I wish to express my sincere and enduring gratitude to NADEL for supporting the Pius Langa School of Advocacy when it started in 2019, and for your ongoing support. We could not have established our school without NADEL's clear commitment and support from its inception. The funding which NADEL gave to the Pius Langa School allowed us to construct our premises and to start operating. We are very grateful for the confidence and support that NADEL had for our vision of a different way of educating legal practitioners and focusing particularly on Black legal practitioners. Now, we live in challenging times. Judge President Menenge alluded to this in during his welcome, and he highlighted for us the impact this has had on our courts and the challenges that it brings to balance the rights and interests of all South Africans. As a country, we have been challenged by the implications of state capture, by excessively high rates of unemployment, a weak economy, hollowed out institutions, and aging infrastructure. The impact of this on the poorest and the most vulnerable South Africans is dire. And on top of that, none of us could have predicted what the last 2 years threw at us through this unprecedented global pandemic. In the global South, we have again been reminded of the reality of double standards through vaccine apartheid, the closing of borders to African nations. As in virtually every other social condition, the richer nations of the world have largely managed to overcome the economic impact of COVID-19, and the poorer nations will suffer the consequences for a generation or more to come. It is to this challenge that we as lawyers and as South Africans must rise. It struck me in preparing this address that NADEL itself was established during a period in our history of a country which was also challenging, a period of political suppression, where there was a need for a progressive body of lawyers to mobilize their skills in the law to fight against the brutality of the apartheid state. And NADEL's legacy as an organization has certainly been true to its initial aims. And I congratulate NADEL for leading the profession for so many years with such integrity and such foresight. The theme of this conference, Much Vigor Needed to Create a Future Very Different from Our Past, is an apt description of where we all stand today. As legal practitioners, more than ever, we are required to use our skills to serve humanity. The pandemic itself has forced us not just to become tech savvy, not just to learn how to use Zoom and MS Teams, but also to think differently about how we practice, where we practice, how we best continue to offer our services, and to assist those most in need of those services. We know that many of our colleagues have succumbed either to COVID-19 or to the economic consequences of the last few years. So many small firms have battled to stay open, and so many counsel, particularly Black women counsel, have battled to keep their practices alive. We have all been challenged. From a professional regulatory perspective, the last few years have brought a new regulatory body in the form of the Legal Practice Council. And we congratulate Ms. Myberg on her recent election as chair of the LPC. We have been very grateful for the work that the LPC has done to try and ensure transformation of the profession on so many fronts. And we have full confidence that the new LPC chair will take us further in this fight. The Pius Langa School of Advocacy was formed in the year before the pandemic began. It is the first of its kind in South Africa. It's the first in Africa and perhaps even in the world. The vision for the school came from our own experiences attempting to enter the profession. Experiences which were often very alienating and very disempowering. We experienced a culture which sought to teach by breaking down rather than by building a confidence, building ability. These are the things which we wanted to change by starting the Pius Langa School. Justice Pius Langa was a mentor to many of us, was an elder to us. He led us by example as a lawyer, as a judge, and as a human being. NADEL was centrally involved in our decision to name the school after Pius Langa. And with each passing year, as we see his name on our door, we are reminded that we need to live up to that legacy. When we started the school, we spent a lot of time developing our curriculum and our teaching methods in order to address what we saw as obstacles that were in the way of Black professionals faced, in their way in entering the profession, particularly during pupillage. We now have a school board in place, which is chaired by retired judge of the Constitutional Court, Justice Bessen Kabinde. I'm also happy to tell you that President Notjesi also sits on our board as a representative of NADEL. In the last 3 years, we've focused on getting our curriculum accredited with the LPC, and I'm happy to report that the LPC has just accredited us once again, this time for a further 3 years. We've tried during our short existence to work closely with the LPC in sharing our curriculum and our exam models, because at the Pius Langa School, we believe we're not a commercial enterprise, but we are an enterprise focused on improving legal education across the board for Black practitioners particularly. One of the common areas of focus we share with NADEL is that of training. We are accredited to train pupil advocates and have been doing that for the past 3 years. Now that our pupillage program is properly established, we can now look to the next phase in what the school can offer. And in 2022, the school hopes to collaborate more with NADEL in various areas. This includes expanding our training offering. We're planning on focusing on the role we can play in providing advocacy and litigation training, not just to advocates, but also to attorneys. And I hope we can work closely with NADEL in that next phase. This year, NADEL has used our training venues to conduct some of its own training, and we're happy to continue to share our facilities in that way. A core part of what we want to do in the next few years is provide ongoing training to legal practitioners across the board. I am reminded, for example, every time I act in the High Court, that what we need as practitioners who act in the High Courts is better and more training for acting judges, so that when we are thrown into dealing with matters in areas where we may not have practiced, acting judges feel suitably empowered to tackle the issues before them. And this is an area I hope NADEL and Pabasa can collaborate with the judiciary and to improve the training that we provide to acting judges. In addition, practitioners require ongoing training so that they are kept abreast of developments in the law. NADEL does a lot of this training, and we look forward to working closely with NADEL in the future to assist where we can. Pabasa may be an association of advocates, but we see our role as integrally connected to our attorney colleagues. The idea that there is a hierarchy between the branches of this profession must be dismantled. As legal practitioners, our primary purpose is to use our skills and our knowledge of the law to serve the interests of our clients and to transform society through the law. We can only do this if both branches of this profession work together. If we are able to work together, we will be better placed to assist those most vulnerable and most in need of effective and accessible legal representation. With that said, let me take this opportunity to congratulate NADEL on its 33rd National Conference. I wish you well in your deliberations over the course of this weekend. May NADEL continue to lead the profession with integrity and conviction as it has done for so many years. Thank you very much.
Thank you very much, Advocate Blinder. We really appreciate the message. It comes with a wonderful challenge and a beautiful hope for the future. We're still going to have more messages of support, and the next that I'm going to introduce is one that is to be delivered on behalf of the Pan-African Lawyers Union, PALU, and to do so is Mr. Emeka Obegolu.
Thank you, and good morning, Mr. President and the Executive Committee. I bring you greetings from the Pan-African Lawyers Union. Mr. President, it's good to see you again. Congratulations on the conference. I would like to thank you for inviting me to deliver a message of support during the 33rd National Conference and Annual General Meeting of the National Association of Democratic Lawyers, aptly themed Much Vigor Needed to Create a Future Very Different from Our Past. The Pan-African Lawyers Union, as we know, is a premier continental membership forum for and on behalf of African individual lawyers and lawyers associations in Africa. We were founded in 2002 by African bar leaders and eminent lawyers to reflect the aspirations and concerns of the African people and to promote and defend their shared interests. Our membership comprises the continent's over 5 regional lawyers associations, over 54 national lawyers associations, and so many individual lawyers spread across Africa and in the diaspora, working together to advance the rule of law and the legal profession, good governance, human and people's rights, and socio-economic development of the African continent. To realize a just and prosperous Africa built on the rule of law and good governance, PALU has adopted 3 core areas of thematic focus, namely institutional development, development of the legal profession, and rule of law and good governance. The strategic goal of our institutional development theme is to build a modern, well-resourced, and sustainable Pan-African membership organization with optimum institutional capacity to deliver on our mandate. Our organizational development programs are designed to build a Pan-African organization with the requisite corporate governance ethos, systems, and structures to provide leadership on the African continent for lawyer-led initiatives that contribute towards the AU, the African Union Agenda 2063, and the United Nations Sustainable Development Goals. The strategic goal of the development of the legal profession is to develop a competent, effective, and independent legal profession in Africa. Here, we design and implement programs that enhance the professional capacity of individual lawyers, which includes in-house lawyers, law firms, and lawyers associations like NADEL, to boost our capacity and ability to contribute to development of the African polity, economy, and society. These include enhancement of professional ethics and integrity in the practice of the legal profession, preparing the African legal profession for the 21st century and beyond, and of course, building the capacity of regional and national lawyers associations to serve your members as well as the public interest. The strategic goal of the rule of law and good governance is to strengthen the standards of adherence to the just rule of law and good governance in Africa. Here, Palo design and implement programs that catalyze the development and practice of African international law. We build a practice around law, peace, and security in Africa, promotion and protection of human and people's rights in Africa, democracy, elections, governance in Africa, and that increase the levels of integrity in Africa's economic governance. The legal profession, as we all know, is a dynamic field, and as practitioners, we must constantly evolve to meet new trends and adapt to new laws and policies in order to offer our clients optimal service and representation. Thomas S. Monsoon said, "The past is behind, learn from it. The future is ahead, prepare for it. The present is here, live it." It is imperative that as we reflect on the past, not solely to change it, but to learn from it, propose new initiatives, spearhead new policies and legislation, and arm ourselves with the knowledge and skills needed to engage in emerging areas of practice. Most importantly, as the year winds down, we must begin today to study the current landscape, develop ourselves accordingly, and prepare for a sustainable future. I wish you a successful event and fruitful deliberations, which I believe will thoroughly interrogate the theme and put in the minds of all present a roadmap to the future. Thank you, and God bless you.
Thank you very much, Mr. President. We appreciate your message, and we look forward to continuous relationship as we progress to the new year. Thank you very much. We have had 2 virtual messages of support. I think it is necessary for us to have another face-to-face message, and it gives me great pleasure to welcome for a message of support from our brothers, the Black Lawyers Association, and to deliver the message of support, please permit me to invite the former president of BLA, Ma Bunda, to the podium.
Thank you, Chair, for this purpose, and I think Provincial Chair of NADEL, or Branch Leader. My comrade and President of the National Association of Democratic Lawyers, Mvuso Nochesi. I believe I'm very good in pronouncing Nochesi. A lot of people battle in that regard, and I've mastered the art of pronouncing my dear comrade. And thank you for this standing invitation. Safe to say that it's a well wish for NADEL in this conference on behalf of the Black Lawyers Association. Even if that were not the case, I believe that as a long-standing friend of NADEL, you would have possibly made an opportunity for me to wish NADEL well in this August conference. Indeed, so the relationship with the
National Association of Democratic Lawyers with the Black Lawyers Association is historical, and it has what I would call an unseverable umbilical cord, which inherently and without any equivocation need continued sustenance, and without which we are going to suffer a lot going forward in terms of making sure that there is progress and progressive realization of what we have always, as the majority in terms of population, demography-wise, wanted things to be. Now, indeed, I must, without fail, do acknowledge the presence of Justice Madlanga. Ironically and interestingly, when he went to the Concord, I was getting in, and I was part of the JSC, which interviewed him to find himself at I won't go beyond that. I was just making a statement of fact. The same applies to now Judge President Mbenenge, but when he entered into the judiciary before he could become a JP, I was part of that particular interview, and I'm very happy to be in their midst today. And the chairperson of the Legal Practice Council, you are welcome, and you have already been welcome, but I have to acknowledge your presence also. Now, the other comrades, Max, we always meet, we continue to meet. Krish, Janse, we always meet in the profession. But the relationship of NADEL and the Black Lawyers Association is very, very important, especially when you look at the frontal way in which the relationship becomes harnessed. I have been following, and I've been acutely, with zeal and interest, following your relationship, you know, about the release of the Cuban Five, the tenacity with which you have been fighting for that release, and hence I noted with interest your continued relationship with the Cuban ambassador. You have them as NADEL in history on how you have been and in solidarity with them. So that is very, very interesting. And then I am equally noting the fraternal relationship and the position which you are taking with respect to the wars and the rights, especially, you know, of the Western Sahara, and the position which you are taking in that. So I do know that you start with the wars for rights, which may seem small at the beginning, but when the fruits ultimately come, even if it may be after a decade or so, your name as NADEL always go down in history for those who care to know. Now, obviously, at a personal level, I'm aware that you have always put me on the lion's den when it comes to certain issues which you believe you should be taking in head on, and I am able to melt the ice. And then when you come in, you come with the vigor and tenacity which is expected of you as human rights lawyers. Now, the continued relationship between the BLA and NADEL is and should be beyond question and should be sustained. And I'm looking forward to your participation, and the JP has, in my view, eloquently put his views, which I share unreservedly, regarding how you chose the theme and his views about the future when looking at the theme which you have chosen. And I am, as usual, looking forward to my contribution on your conference, as well as the themes which you will be taking forward. And on behalf of the BLA, we wish you the best in this conference. Thank you very much.
Thank you so much for your message of support. We appreciate it. I will call on Comrade Misa to please deliver our gift to our guest speaker. We are still busy with messages of support, and I'm going to invite to the podium to deliver the next message of support on behalf of the Law Society of South Africa, in the person of the President, Mr. Jan van Rensburg.
I always have to adjust because they build these podiums for dwarfs. Mr. President, Justice Mhlanga, JP, honored guests and fellow practitioners, I wish to express my appreciation to NADEL for the invitation to attend the AGM at this very impressive venue. It's wonderful to see faces again and to hear voices around you. For occasions like this, lazy presidents like myself always pass the ball to our CEO, Tony Pillay, to prepare a short address, which is politically correct. And without even asking, Tony did send me a message. However, only last night I decided that I'm not going to make use thereof. So I changed from a message from the head to a message from the heart. Recently, I think 2 weeks ago, I attended BLA's AGM with the theme, the relevance of BLA during and after COVID, its influence on members and the legal profession. The JP also there delivered the welcoming address, and he challenged them to consider the influence and success they have achieved in the past as a starting point to their deliberations. Their president then responded by reciting the names of many past and current members of BLA who have achieved great success, mostly because of their appointment to the bench or other senior or influential positions. Now, surely, one cannot deny those achievements. But it set me thinking, is this the real test for the transformation that we all are looking for? I note your theme to create a future very different from the past. In my humble opinion, Mr. Kutama missed what I considered one of the most important achievements, and not only for the BLA, but also of your organization. Allow me, at the end of a career of some 25 years in the organized profession, to illustrate what I mean with reference to my own experience. When I attended my very first council meeting at the Law Society of the Northern Provinces, I was nervous and frankly very scared. I was then, as I am now, a single practitioner from a small town, and all the people around that table were veterans of the profession. Those people you always fear for striking you. I think the president saw my fear and then addressed me in fluent Afrikaans, welcoming me and inviting me to participate in their discussions. That settled the nerves. And his name was Nanu Matlalu. Later, I served with him as an examiner, and we often did the oral exams of candidate attorneys together. His clear thinking, sharp legal mind, friendly, calm attitude, and incredible ability to address candidates in some 8 of our official languages still fascinates me. Excellence is always the best way to impress and influence people. This was followed by many others that mentored me and shaped my views, changed my perceptions on many issues, and influenced my thinking in many ways. I can tell you about my interactions with Mohamed Hussein, Norman Mohabi, Max Bukwana, Busani Mabunda, Krish Govender, Mfana Gwalu, and the late Lieutenant Sigogu, to mention just a few names. Before the LPA came into operation, the LSSA went on a roadshow through our country to inform and sensitize our members to the implications of the new Act. I always made it a point to be on Lutendo's team. I have yet to meet someone who knows the LPA better than he did. He never referred to the Act without quoting the applicable section. May his soul rest in peace. Well, not all these people teach you that is necessary good. This morning, when I dressed, I was uncertain whether I had to put on a suit. Then I recalled that Krish Governor will be here, and in the 10 years that I know him, I've never seen him dressed in a suit. So here I am without my suit. For the past 3 years, I also had the privilege to work closely with a certain Mavuzu Nochezi, which I assume you all know. He has become a valued friend of mine, despite his tender age. I must confess that I was not aware of his dancing skills, which he displayed so elegantly this morning. Mr. Mabunda, even I can pronounce his surname. The point I'm trying to make is this. One can win a war by force, but every battlefield leaves people with scars, pain, and sometimes disillusioned. So much more can be achieved by hard work. Excellence always pays off. Respect, patience, a friendly, positive attitude, and integrity. This achieves much more than aggression and force, and the results gained in this way are permanent of nature. As the good book teaches us, be quick to listen, slow to speak, and slow to anger. The last 2 years were not easy, and the profession has to face many challenges. The LSSA has been impacted by the same financial, health, social, and environmental challenges, and are working hard with its constituents to address and minimize the effect thereof on our members. We are well aware of the fact that many of our members are under great financial pressure and have assisted to put measures in place to support them. I am grateful to the Legal Practice Council for their assistance in this regard. COVID has also hindered our timelines to finalize the establishment of our provincial societies, but we are still hopeful that it would be in place by the time of our next AGM. Let us hope that this fourth wave is the last one of its sort to hit us. I would also like to express my appreciation on behalf of the LSSA to your leadership and all your members who serve on the various committees and structures of the LSSA. Your contributions are invaluable and a great benefit to our profession. You are certainly helping to achieve a future very different from the past. I thank you for this opportunity and wish you well with your deliberations.
Thank you so much, President Jan Respect, for the message of support and for appreciating the dancing steps. You can join. I will call on, again, my comrade, Minister, to please extend our gift to our guest speaker. Thank you. Please, our next speaker, please permit me. She is the, thank you. Thank you. Our guest speaker is the newest president of the Legal Practice Council, and I think I can call her my sister. If you see her, you will know why. Please permit me to deliver the message of support from the Legal Practice Council, Ms. Janine Myburn. I said so.
Thank you. Midgets Jan was referring to. President Nochesi, the Executive Committee of NADEL, Justice Mtlanga, JP Menenge, legal practitioners, distinguished guests, especially the gentlemen, many of the gentlemen in the front row who I've had the opportunity to serve with, members of NADEL, delegates of the conference, colleagues, friends in the legal profession, and ladies and gentlemen, good morning. On behalf of the Legal Practice Council, I'm here today to convey a message of support to you on this most momentous occasion of your 33rd annual conference. As an organization that has been in existence for over 3 decades, you remain one of the major pillars of the legal profession. Your resilience, staying power, and relevance over your many years of existence is truly an inspiration to us all. For us, at the Legal Practice Council, we respect and appreciate your role as one of the key stakeholders in the legal profession. Your theme this year aptly states that much vigor needed to create a future very different from our past. Personally, I appreciate the efficacy of the word vigor, as it denotes much needed effort and enthusiasm. One may even take it a bit further and bring the words like drive, passion, and immense determination. The theme resonates with me in that much vigor is needed to address the many challenges within the legal sector. I believe that much vigor is required to foster the collaborations that will take us all to a future that is different from our past. I believe that it is through vigor that challenges and obstacles can be addressed for the good of the entire profession as well as the public. As most of you are aware and may have heard this morning, that we are a new Legal Practice Council that came into office on the 1st of November this year for a period of 3 years. We're also privileged to have your Secretary General, Nolita Jali, on our council. And as you've heard, we've also have Busani Mabunda on our council, who serves on our executive committee. Busani, when I spoke to him this week about attending the conference, was very proud, as he did this morning, to ensure that I understood that he had a standing invite to the NADEL conference, and he ensured that I was aware of that. I was also very pleased that the national anthem was sang this morning, because in all the time that I've worked with Pisani in the LSSA as well, it's the first time I've seen him without his hat. So thank you for that opportunity. And the instance that was meant that our fees will not escalate, Pisani represents the fund, so I don't want to place any pressure on him, and I can see his eyes change, but Pisani will be responsible to ensure that our allocation from the fund is sufficient. Thanks, Pisani. Ladies and gentlemen, as chairperson of the Legal Practice Council, I can assure you that the members of the council are competent and driven individuals. We are all filled with vigor. They may not all be young, but filled with vigor, drive, passion, and determination to do what it takes to build a greater future for the profession, the public, and to ensure that we regulate, that we have a different future. The LPC looks forward to continuous and frank engagements with NADEL, and I hope through my presence here on behalf of the LPC, it is accepted as a sign of our commitment to transparent and open interactions with you as a critical stakeholder in the legal profession. As the LPC, we accredited NADEL to do training in 2020 and 21 as well, and we congratulate you once again as being accredited just as recently as last Saturday, and not only for 1 year to do the training, but the accreditation this time is for 3 years. We're also happy to be able to support you from a funding perspective as best we can, depending on the funding available for the legal profession. As you spend many hours deliberating and making resolutions, we bear in mind your stature and the powerfully inspiring history, the role you continue to play in the developing of a bright future for the legal profession. I wish to assure you that the Council will continue to fulfill its mandate. The Council is still very relatively new. This is the second Council that's been elected, and there are a few items that I'd like to mention that we are very proud of. We are proud that we are continuously working to fulfill our core functions, which include the enrollment of legal practitioners, coordinating and managing admissions, conveyancing exams and notarial exams. The issue of conveyancing exams and notarial exams, or not necessarily notarial exams, do need to be addressed because the pass mark is horrendous. The registration of practical vocational training, contracts, handling of the disciplinary matters. We are also looking at potentially streamlining it or making it easier, because the disciplinary process is lengthy and very cumbersome. At the LPC, we brought in the Code of Conduct, published and gazetted it. We arranged the LPF's board's election as recently as October last year. And what we are exceptionally proud of is to have facilitated the development of the Legal Sector Code, which is now with the Department of Justice, and we are looking forward to it being gazetted this year. We are also engaging with the CETA to relook at its programs to include funding training for the legal practitioners. But I am painfully aware that there are many challenges that need to be addressed by the LPC. And I intend to ensure that we do that. We are looking at potentially just even looking at the practical things, like I'm also aware that it's very difficult to get the LPC to answer the telephone. So at our last council meeting, we arranged that the EO was instructed to look at a new telephone system so that at least practitioners and the public can get through to the LPC. We're looking at practically launching an electronic legal practitioner's identification card, so you don't need to walk around with your documents anymore, and that is potentially to be rolled out in February. For me, it's important that we have practical initiatives. Going forward, we will continue assisting where we can, especially in the time of COVID. We will continue assisting with the establishment of the Ombudsman's Office. We will assist where possible with funding of 19 law clinics, especially considering the important role they play in the lives of ordinary members of the public and the training of graduates. Ladies and gentlemen, and I assure you that each activity that the LPC undertakes will amplify your vigor and commitment to create a bright future for the profession different from the past. We will remain committed to our mandate of transforming the legal profession, ensuring access to the profession and access to justice. For me, the proof is in the pudding. I intend putting words and facts to these words. It is also a sign of flattery or a compliment if someone copies you or emulates you. And I'd like to say that today that the LPC will be taking on your mantra to make work with much vigor needed to create a future very different from the past. I look forward to a strong partnership and engagements with NADEL, and I wish you, on behalf of the LPC, a very successful AGM and conference. I thank you for your time.
Thank you very much, Ms. Bevel, for the wonderful message. As a practitioner, I'm very excited about what you laid out. I see the future is quite bright. Thank you. I will invite my Secretary General to please deliver the gift. Ladies and gentlemen, whilst we wait, and we will adjourn shortly, but please do permit me to still deal with 2 more messages. And the next one, I have the honor of inviting, it will be virtual, Excellency from the Ambassador of Venezuela. You will know from previous conferences, she's always graced our conferences, but this time she will be delivering a message virtually to us. Ambassador Marin Merida from Venezuela. You see, I'm an attorney, and I believe time is money. While we're waiting for the technical to sort it out, I don't know how long we're going to take. Perhaps you will permit me to please introduce the next face-to-face guest that we have here. I cannot actually introduce him better than my president did earlier. He is from our branch, and I can say that he's not a stranger. He doesn't want me to introduce him. Please welcome from SADC.
Colleagues, friends and comrades, it is for me with very, very heavy heart that I'm sitting in a conference knowing that Butsai will never be with us again. I'm sitting in a conference knowing that Patrick Jaji will never be with us again. There had never been conferences that have not been graced by these comrades. But Comrade Nokesi, you're right. In terms of this topic, our country is at a crossroads. It depends on collectives like this, whether this country falls into complete abyss or it's on the threshold of being reconstructed. In 1997, when NADEL was still very poor, we always met at a hotel in Durban called Tropicana because that's the cheapest hotel we could afford. So in 1997, we were meeting at Tropicana. We had to deal with 3 topics. These are the topics that Dala Omar raised because we were celebrating the conclusion of the new constitution. And we were beating ourselves as NADEL in terms of the role of putting together the new constitution. So when we met in Durban, Dala Omar asked a question: what then is going to be the role of NADEL? Are you going to be the lapdogs of government? Or are you going to be the watchdogs of government? What will be the role of NADEL in international solidarity? So I'm here, Comrade Nokesi, to respond on the last point, because the first 2 points, Justice Mbenenge is here. I had no imagination that in this division you will have a judge president other than Kane Meyer. I had no imagination that in this division you will have a judge president other than Zitzman. Now, when I see Judge Mbenenge here, I'm able to say from that time, we've made progress. Here, Comrade Chief Justice Madlanga, we speak the truth without apologizing. The threats to the independence of the judiciary are many. Those come from the executive, those come from capital. But the greatest threat to the independence of the judiciary is the judiciary itself. We are sitting in a position, Justice Madlanga, that there's a possibility that our judiciary is a threat to its own independence. In the past few years, we have seen the shallowness of the judgment that comes from our courts. We have seen disturbing scenes of judgments delivered by show of hands. What we have lacked is the intellectual depth of creating a progressive jurisprudence. That responsibility we throw on your shoulders. Whether you continue as Chief Justice or as an important cog of that court, from us, it's critical that we deepen the progressive jurisprudence, and for that we rely on you. And that's possible, the reason that this congregation here will be behind you as we try to achieve that objective. Comrades, I met Comrade Edre in 2000. Comrade Edre was the Secretary General of the National Union of People's Lawyers in Philippines. We were going to a meeting together and he had 4 colleagues. When he got to that meeting, he was alone because 3 of his colleagues were shot as they were trying to come to the meeting. And this is what, to us, it's about international solidarity. And I traveled with Comrade Edre in 2013. Many of you will know something called the Pillar of Cloud in 2012, when many of the Palestinians were killed. We traveled to Gaza. We drove through Sinai, through Rafah border. to represent many of those victims in Palestine. I was with Comrade Edre, and these are committed comrades from all over the world who understood that injustice here is injustice everywhere. It was Comrade Edre and ourselves that put together the trial to test the veracity of the laws upon which the Cuban Five were arrested. We had the former Chief Justice of France and former Chief Justice of India and former Justice of the Constitutional Court, Zek Yacoub, to lead that tribunal. On the 17th of December 2015, we were preparing a march to the White House to present the result of that tribunal. But 2 days before, on the 15th of December, President Barack Obama announced the release of the Cuban Five. So it's correct what Comrade Mabunda was talking about, the important role this organization is playing. I'm answering the question of the importance of international solidarity. But from that conference in Durban, we had a visitor from Swaziland, Comrade Aaron Shaw, who unfortunately died in a car accident, and may his soul rest in peace. Comrade Aaron Shaw reminded us in that conference that Angola has no organized legal profession, that Mozambique has no organized legal profession, that the DRC has no organized legal profession, that South Africa has a highly divided legal profession. And to be able to respond to these things, we need the collective wisdom of all of us in this region of 15 countries. And that's why then in 1999, we went to Mozambique to set up the SADC Lawyers Association. The idea of setting up the SADC Lawyers Association was to strengthen the bars and the law societies within each one of the countries that we are operating in, so that we can undertake at least 3 assignments. The first assignment is the harmonization of laws in our region. Because if we are saying the poor is able to cross the borders, the animals are able to cross the borders, it's important that trade must happen across the borders, and lawyers are central into that. And the second issue that we needed to undertake is this idea of lawyer mobility, so that lawyers here can be able to appear with ease in Namibia. Lawyers are able to appear anywhere in the region. When Advocate Ngugai Toby went to Namibia at the beginning of the year or late last year, because he was representing a certain people that are unwanted by government, we were immediately to get an SOS that Comrade Ngugai Toby is going to be detained in Namibia. But because of our networks, we were able to get him out of Namibia as soon as possible before any such thing happens. So it's important that we encourage this issue of lawyer mobility in our region. But Comrade Nokesi, you will understand that our main task as the SADC Lawyers Association is this idea of promoting, maintaining, and advancing human rights in our region. Many colleagues will understand the amount of work we have done in Lesotho, which now is culminating into the National Reforms Program. Colleagues will understand the work we've been doing in Zimbabwe, which has been disturbed in many instances by the manner in which that regime behaves, and unfortunately sometimes in cooperation with senior judges, like just the extension of judges' terms when they have come to an end because there are particular cases that are coming. So, but we've been quite seized with the work that is happening in Zimbabwe. We were able to lead a charge in Angola where both the regime and the police had developed a tendency where the accused got arrested together with their lawyers. So whatever you say in respect of defending your client, you are immediately linked as part of that criminal syndicate. So we had to be there face to face, deal with the authorities in Angola to respond to this. I was glad last month when I attended the trial of Baqede Mabuza and Mthandeni Dube in Swaziland. These are the members of parliament that are now in detention for just doing their work as members of parliament. So whilst we were sitting in that court, doing your work as a member of parliament in Swaziland is called treason. Because they've been charged for treason and a number of things happened and many people were killed in Swaziland, those murder charges are imposed on two of these members of parliament. So lawyers in Swaziland feel very, very isolated. They need our help. And I'm saying I'm glad that when I attended that trial, I found Mr. Mabunda there. And it was a great encouragement to the lawyers of Swaziland to say to them, even in this hour, they are not alone. So that's the role, Mr. President, that we need to report about today. I'm not here to pass any message of support. You don't need the support from us. But we need to account for the number of things that you had asked us to do. But let me report, Mr. President, that in April next year, we will be having the conference of SADC lawyers in Johannesburg. And really, all the colleagues that are here are implored to attend that conference. It's a very critical conference, not critical because I'm retiring formally from the politics of the profession. But there's quite a number of reports that are critical that we report to you about. That we have created a model law for family violence and gender-based violence in our region. That we have created a model law on this very troubling subject of the criminalization of the poor. And we have seen this in great deal in Cape Town, where being homeless is equated to criminality. And we have to work in terms of designing the laws as to how the countries must respond to this. We had designed, Chair, the model law in terms of the arbitration in the region, because we need to center the role of lawyers in this whole idea of Africa Free Trade Agreement, because the $3 trillion trade that is going to take place in terms of that agreement, it's central that the lawyers play an important role there. So in the end, Chair, as we do these reflections today, it's important that this idea of international solidarity, the regional solidarity, is part of our assignment. All I can say is good luck for your deliberation, and we are looking forward to learning from them to be able to answer the question, can we prevent our country from dipping into a brink? Thank you very much.
Ladies and gentlemen, I do not think there's anything I can say on top of that other than to acknowledge it with gratitude and to appreciate him being our former branch chair and obviously former president. You have been wonderful and the messages have been fantastic, but I think it is necessary to have a tea break and for us to mingle and to socialize. But if you would just permit me, he's made reference to two stalwarts of our branch, and as you rise, if I may request it, that we just observe a moment of silence for them. Okay, perhaps when we come back, we will do that. But let's go for tea. Ladies and gentlemen, please, just so that we can keep to time, I want to please appeal to you to let us please reconvene exactly at 10 past 11, please. Have a cup of tea and let's come back quickly for time purposes. Thank you. Technical. Thank you. Thank you. Ushers, can you please arrange for our comrades to please come in? Please, let's settle down. Ushers, please usher in our comrades. Ladies and gentlemen, can we all please be seated? Thank you. I'm sure we are all refreshed and you've had time to stretch your legs. I'm sure you will still be properly recognized. I want to recognize and welcome Advocate Darlene Pofu. You're welcome. Before we adjourned for tea, I'd indicated that we were to receive the message of support from Her Excellency, the Ambassador of Venezuela. I am informed that she is now available to give a message of support. So if I can just have technical, please let's link to her to deliver the message of support on behalf of Venezuela. I'm going to introduce Her Excellency Ms. Myrin Merida.
Hello. I don't know if you can hear me.
We can hear you clearly, Ambassador, and welcome. The floor is now yours. You may proceed. Thank you, Ambassador.
Okay, thank you. Thank you very much. Good morning to all of you. Thank you once again for the invitation. For me, always is a pleasure to share with you. But as you know, for us, NADEL We are part of the family of NADEL here, and we feel part of the family of NADEL. And I would like to thank to the president of the institution and all the members of NADEL to permit us to share with you today. No? And on behalf of the Embassy of the Bolivarian Republic of Venezuela and the government of my country, no, I want to extend my sincere congratulations to NADEL for celebrating the third National Conference and Annual General Meeting, and also for the achievement and for keeping up the struggle for an egalitarian society, promoting and defending the constitutional order to guarantee justice amongst many other things. And I also want to thank highly the support of NADEL to the Bolivarian Revolution, to the Bolivarian Republic of Venezuela, that for several years has been under threat and permanent attacks by the empire. And it's very important for me to tell you that we have a provincial election also in Venezuela last week, and a new political map emerged in Venezuela after that regional and municipal election that was of November 21st, when the parties of the Great Patriotic Pole Coalition reaffirmed themselves as the main political force in the country, with 19 of 22 governorships and 211 of 335 municipalities. And on January 9th, the remaining governorship to be renewed corresponded to the state of Barinas, it's a province close to my province, and in the western part of the country will be elected. Likewise, the sector group in so-called Democratic Alliance, in Spanish Alianza Democrática, are emerging as a new opposition right wings, axis that equal in votes de facto registered in the self-styled Democratic Unity Roundtable, which concentrate extremist group. In light of this new situation, the President of the Republic, Nicolás Maduro, began working meeting this week, yesterday, with all the elected governors or premiers in order to provide solution to the need of the people who are facing the effects of the blockade imposed by the government of U.S. And after the provincial election last week, it's important that you know also, the government of U.S. renews the restriction on Venezuelan oil sectors. This will only allow them, the company, to maintain administrative activities, but no operations that involve the commercialization of Venezuelan oil. This is the condition of 5 companies, American companies, established in our countries, according to license 8L of the United States Department of Treasury, renewed on November 24. And with this action, the U.S. insists on damaging the Venezuelan oil industry, affected since 2017 by unilateral coercive measures, which have caused a 99% drop in the nation's income and gross domestic products. This action, contrary to international law, also involves the seizure of Venezuelan assets abroad, such as Citgo, a PDVSA subsidiary that operates in the United States. The case of Venezuela can become a case for study in the legal environment, since the Venezuelan opposition, the government of the United States and its allies have flagrantly violated the Constitution of the Bolivarian Republic of Venezuela, the international law, the United Nations Charter, and all laws that have stood in their ways, with the sole objective of overthrowing the government of President Nicolás Maduro and seize all the natural resources of our country. This wish of the opposition, backed by the United States government, is to achieve control and power in Venezuela, to overthrow a constitutional government democratically elected by the popular wills, is taking ruthless and terrorist action against the people to the extreme. And also, it is very important that you know, the last election was number 26 in the last 25 years of the revolution. This is, we can say that we have a democratic revolution in Venezuela. But despite this, they will continue, they look for other ways, more sanctions, financial blockade, millions in fines to the Venezuelan state, electrical sabotage, amongst others. In view of the policy argument, it is necessary that the governments of the world ponder and demand the respect to international law as a guarantee of the peace and the future of the new generations. The Venezuelan people, along with the government led by Constitutional President Nicolás Maduro, reiterates its call to the countries of the world not to contribute but an armed intervention in Venezuela, to promote the dialogue within the framework of the Constitution of the Bolivarian Republic of Venezuela, and to stop the criminal economic blockade that prevent the normal supply of food and medicine to the Venezuelans. The problem of the Venezuelans must be solved by the Venezuelans without external pressures, control and impositions. Venezuela is a country of peace. We only demand respect for the principle of international relations, international law, and the United Nations Charter. Once again, my dear comrades and friends, we appreciate NADEL's support and solidarity with our country. And we also express our support and solidarity with this institution, guarantor of the law and respect for human rights. Thank you very much. Thank you very much.
Thank you very much, Your Excellency Ambassador Merida. We really appreciate your message and look forward to future time when you can visit with us in person. Thank you. Ladies and gentlemen and esteemed guests, that brings to an end the messages of support. Now, immediately we go, and I have the pleasure of inviting my president, the president of NADEL, Mr. Mvuso Notjesi, to the podium to present the report.
The Deputy President of NADEL, Mr. Manye, Secretary General, National Executive Committee, Justice Madlanga, the President of the Eastern Cape, Justice Mbenenge, Justice of the High Court, Minister of Justice, Members of Parliament, Chair of the LPC, President of the LSSA, Ambassador of Venezuela, representatives of PAPASA, our alliance partner, Advocate Nazreen, SC Partlander, representative of NADEL, comrades, delegates. In 2018, an elective conference was held in East London. A year later, in 2019, we had a successful policy conference at Kipton Park, Gauteng province. In each of the two conferences, delegates from all walks of NADEL gathered together with a sole determination to shape and direct the organization towards the fulfillment of struggle objectives. The delegates were aware and conscious of the fact that we are in a long walk to our true freedom and total liberation, which our founding fathers had sacrificed so much for. In the revolution, the only demand is freedom and total liberation. The struggle for liberation is love for everything. Love for land, love for culture, justice, dignity, economic reform, freedom, sharing of wealth, and universal freedoms. It is a love and unshakable conviction, so potent that it overwhelms even the most primordial and is therefore the most powerful of all instincts with which humans are equipped, the instinct for self-preservation. This must explain why generations after generation, in spite of all the setbacks, the black people and Africans in particular have continued fearlessly sacrificing their lives from the first skirmishes with Dutch settlers in 1658 to the last days of resistance. These are the observations, comrades, that in her book, Christine Kunda also makes. The book is titled, Why We Are Not a Nation. Surely each of us must answer the question that Christine sharply raised, why we are not a nation. This conference offers the opportunity to answer that question. Despite the imminent threats to our lives and potential exposure of our families, we are gathered here today to once again shape the direction that this organization should follow. We need to chart the way forward in the midst of confusion, anxiety, helplessness, continued economic inequality, regression of our revolutionary gains, injustices, health issues, and stress. The COVID-19 pandemic is ravaging the world. We have lost those whom we loved most. Our lives have suddenly changed. The revolution is under a serious threat of being hijacked by the powerful. We live under daily infiltration, growing populist narratives, and constant emergence of black right-wing groups. This black right-wing group exploit the commitments made towards the transformation of South Africa. They manipulate the policies aimed at transforming the country. This they do on the basis of things that are so deep into our hearts, gender transformation and broad transformation. It is easy these days to meet with a colleague who demand for a position, not because of any reason, but because he or she says, I am black, or just because she says, I am part of gender transformation. We must be vigilant. We call for vigilance at this time. Transformation is a revolutionary agenda, not an incident of careerism or self-possessed entitlements. We need characters of selfless servants and humble citizens. This conference had been delayed by a year due to the pandemic. We lost many of our comrades due to COVID-19. It's still pains all of us that we lost our former Secretary General and a young jurist, Patrick Judge. He was a visionary and had great ideas about the promised society. He was concerned by a number of issues affecting the society: the resurgence of control by the capital group, by the corporate, the moral decay and loss of values in our society. He had asked all of us, where are the cadres of NADEL that resemble the character of the late Chief Justice Pius Langa, Dula Oma, Silas Kanun, and many other comrades of NADEL? We'll always remember him as a freedom fighter, a young female activist and prominent member of NADEL from the Pretoria branch, Ms. Vananga, also departed during the COVID-19. Indeed, COVID has robbed us of our giants and committed struggling comrades. Very recently, on 6 November 2021, we had marked the 57th anniversary of the passing of one of the first recruits and combatants of Umkhonto weSizwe, an Eastern Cape MK High Command member, a trade unionist, a treason trial defendant, and one of the first African National Congress leaders to be brutally executed by the fascist apartheid regime with his comrades, Wilson Kanyinga and Zanekile Mkaba. The sentence to death sparked the international outcry from the non-allied states and the United Nations. Comrades Vuyisile Mini, Wilson Kanyinga, and Zanekile Mkaba were hanged in the Pretoria Central Prison on 6 November 1964. The late Mini went to the gallows singing freedom songs, some he had composed. In a spirit of defiance, Comrade Mini made a death row statement in which he promised that soon there shall be a free South Africa where all will enjoy freedom. Little did he know that 27 years after the birth of democracy, our people are still complaining about basic needs of life, water, shelter, access to education, health, and so forth. As this conference, we must ask ourselves why it is so. These gallant fighters had a vision of a free South Africa in which all enjoy universal freedom, underpinned by justice for all. It is disappointing that we gather in this conference still faced with the demands by masses of our people for dignity, equality, and justice. The journey and march to freedom is not only taking long, but we are at the risk of the masses losing their patience. The total collapse of the state is an imminent and real threat. We must be vigilant. The arrogance of the capital and corporate is what provoke our masses on a daily basis. What should we do? This is a question that the delegates must answer. As we reflect, the recent local government election reflects low voter turnout in every corner of the country. The growing apathy and lack of confidence by the masses to our leaders cannot be denied. What is wrong? These are the questions we must all answer in this conference. Corruption is pandemic. The masses are despondent with the state of affairs. The allegations of abuse of state machinery is refusing to disappear. There is a lack of confidence towards the institutions that are entrusted to support constitutional democracy. The recent judgments from our courts have been subject of a public debate. That is understandable. However, if the debate are about perceived lack of independence of the judiciary and fairness in adjudication, that is a real concern. We must ask ourselves, what do progressive lawyers need to do? This is what the conference must critically discuss. Indeed, the statement is true that the judiciary is our last line of defense in a constitutional democracy. There must never be a suspicion that the judiciary is captured or likely to be captured. We remain concerned about the delay of delivery of judgments, in particular from the Constitutional Court. The recent cases involving former President Zuma were all brought on an urgent basis, only for judgment to be excessively delayed. That had put the country under stress. It was also a concern of every South African citizen that the Constitutional Court allowed a contempt of court proceedings to be directly filed to the court when the Commission ought to have approached the police to deal with the matter. These are all matters that must concern NADEL members and progressive lawyers. The jurisprudence of South Africa must be well settled and cases must receive same treatment. There must be no law meant for certain classes. We still ask if the Constitutional Court would have allowed no Wombile from Manzimtoti to a direct access in circumstances of contempt of court proceedings. The levels of unemployment, inequality, poverty, and human suffering is what is about to become a norm. We need more court pronouncements that seek for the redress of these injustices. That is what NADEL's founding fathers agreed to achieve in a supposedly liberated South Africa. One of the undertakings by the founders of the NADEL was to one of the undertakings by the founders of NADEL was to build a truly transformed South Africa in which all enjoy universal freedoms and equalities. This appears to be slowly becoming a dream deferred. We must not allow the betrayal of the revolution. It is a task of this generation that we fulfill our own mission to honor those before us and their sacrifices. We need a cadre of NADEL that must reinforce all of us and pick up the spears, for we cannot give up. We have come a long way. Our vision has always been clear and our objectives firm. The struggle objectives must be achieved without fail. It is the lawyers of NADEL and other progressive forces who will collectively hold the leaders to account. The hope of our people lies with the lawyers of NADEL. The recently retired Chief Justice Mogoeng once said in a unanimous judgment, we quote, "The preamble to our Constitution is characteristically terse but profound recordal of where we come from, what aspiration we espouse, and how we seek to realize them. Our public representatives are thus required never to forget the role of this vision as both the vehicle and directional points desperately needed for the successful navigation of the way towards the fulfillment of their constitutional obligations." There is work to be done. Our people are still living in inhuman conditions. We still have our brothers and sisters who are called homeless people. We still have children referred to as street kids. State resources are squandered in corrupt activities with no accountability. Where are the cadres of NADEL? We need to strengthen our constitutional democracy. Our activism will help to shape the country towards the right direction. Presently, the country is searching for a new Chief Justice. The appointment of the new Chief Justice is one of the most important appointments. The Chief Justice is the head of the judiciary. He must intellectually lead, unite, and maintain the independence of the judiciary. That must adjudicate societal disputes fairly and without recourse to public opinions and views of the powerful or business. Whilst we may ignore allegations emanating from social media suggesting capturing of the judiciary, those allegations, if well-founded, are a threat to our constitutional democracy. We need a judiciary that enjoys the confidence of the masses. When the President, in an unprecedented approach, called for members of the public and civil society to nominate fit and proper persons for consideration to the Chief Justice position, the branches of NADEL had heeded that call, and in that regard have nominated well-deserving and capable candidates. Our demand, therefore, is to those tasked with the final selection of the Chief Justice, which is that we need an intellectual jurist. The Chief Justice must lead the judiciary through judgment writings and the unflinching integrity. A Chief Justice is not an administrator nor a manager. Judges can be united through well-written and carefully thought judgments. That is the demand from the perspective of NADEL as though the country is searching for a Chief Justice, that we need an intellectual jurist who must lead the judiciary intellectually. The Chief Justice would have to bring together at least 11 judges of the Constitutional Court. This must be considered at the back of the recent tendency that is coming out of dissent within the judgment writing in the Constitutional Court. That shows, in some way, the lack of leadership. And this is what we hope the Judicial Services Commission, when interviewing the candidates, will take into consideration, that the country is not looking for is not looking for an administrator, but is looking for an intellectual who must unite the judges of the Constitutional Court, by extension the judiciary, through a settled jurisprudence in our country. In relation to the current affairs, our state-owned enterprises are in a state of mess. The collapse of the state-owned enterprises is a serious indictment to democracy. The economy will collapse. The net effect is further loss of jobs and growth of unemployment. ESCOM is in a state of chaos. We have been blindfolded by concepts such as state capture. We have been defocused on the identification of the real corrupt. The events at ESCOM and the state of the SOEs have proved us wrong. The ongoing load shedding, which brings about disorder, is a serious threat to the economy. We have no doubt that load shedding has already devastated our economy and the livelihoods of the household. What should we do as NADEL cadres? It seems as if all of us have resigned to accept the events at ESCOM as normal. The time for blaming everything on the former President Jacob Zuma must now come to an end. Former President Jacob Zuma has left almost 4 years ago. What is happening now, and what is supposed to be our reaction? The outbreak of violence and looting shortly after the detention of former President Zuma has always been a ticking time bomb. The reality is that our people are unemployed and poverty levels are high. That is what was at the center of the recent looting. The arrest of former President Zuma merely provided an opportunity on what was always coming. The period also exposed the racial division that continued to exist within our communities. We are not prepared to engage directly with these realities. We simply adopt shortcut route, which is to blame everything on former President Jacob Zuma. By so doing, we deprive ourselves an opportunity to objectively analyze the current challenges facing the society and provide direct solutions. This must not be viewed as a suggestion that former President Zuma has nothing to be blamed. He has a lot. But we need to be objective and deal with the facts as they appear before us. Turning on the events within our own profession, we have recently held the elections of the LPC. The results show the dominance of the big firms, and we fear that this may lead to resurgence of some conservatives. Although in these elections, we are happy that the election produced mainly women. There are more women that have been elected and seasoned members of the profession. We are also happy that out of NADEL's candidates, our Secretary General was retained in the council. The 3 BLA candidates were also elected. There is what that NADEL needs to do. We need an analysis of the pattern in the elections. We must ask ourselves questions on whether our alliance with the BLA is effective insofar as the elections are concerned. Insofar as our previous resolution, this matter has been dealt with extensively by the Secretary General in her report. Suffice to say, insofar as International Front is concerned, we remain committed in our solidarity with our international friends. We continue to support the oppressed masses of the world. We align ourselves with the struggles by the people of Palestine, Western Sahara, Swaziland, Venezuela, and Cuba. It is on those bases that we invited ambassadors in the respective countries to be part of this conference. The alliance with international progressive forces and commitment to the oppressed masses of the world is not a mere formalistic paper alliance. We will encourage our sister organization in this regard to be part of us as we engage in the international space, and we continue to be a member of the ITL, of which we express our voice in respect of the international matters of concerns at that level. We have an alliance with the newly established Pan-Africanist Bar Association, PAPASA. This is a progressive formation of lawyers who share our vision and ideology. The aim is to ensure access to the profession. We did provide support during their launch and agreed with them that the school will be named after our former president, Comrade Pius Langa, and we are grateful that PAPASA has accepted that. We do encourage our members to train with PAPASA. This is a formation that shares the vision of NADEL. It is the first of its own kind, an organization that is motivated by the ideology of Pan-Africanism. The LSSA as a professional interest organization will continue to exist. That is pursuant to the resolution of NADEL conferences in East London and Captain Park. We have achieved shortly the combination of examination through through monitoring by the LPC. The LSSA has established provincial structures. NADEL is a constituent member in those provincial structures. We are satisfied with the LSSA as a professional interest organization and encourage our members and our branches to participate in the provincial associations of the LSSA. NADEL has been vocal on the issues pertaining to the independence of the judiciary. We issued several statements on incidents that seek to undermine the integrity and independence of the judiciary. We're upfront in demanding for evidence in relation to the allegations of judges alleged to be in the CR17 campaign. We found those allegations as offensive and objectionable. No one was able to produce evidence. Hence, we're able to accept that there were no such, those allegations were not founded. So in our criticism of the judiciary must not be viewed as in any way an attack, but is rather a constructive engagement. We have been vocal as well on professional interest of lawyers. We have been vocal on matters of professional interest. However, as NADEL, we are a public interest organization, which is more concerned with human rights and the public protection. We do observe with keen interest the litigation in areas such as medical negligence and road accident fund. The attitude emanating from this litigation, both from the state and the court judgment, is not really pleasing. The real problem of which no one is prepared to address is maladministration in hospitals and health sector. The failing system in our hospital is nothing else but an affront to the Constitution, and that must not be protected by court judgments which seeks to look on a narrow perspective of the issue. The citizens do have a right to health care, and lawyers must, as a matter of constitution, assert those rights through court litigation. There is a public demand for service delivery. Now, the lawyers must litigate to enforce service delivery, including suing of the state where it fails to discharge its constitutional obligation. We will, as a matter of giving effect to this, we will establish, or we must consider establishing our own litigation section to advance public litigation on constitutional issues. This is in line with our previous resolutions. We will need more funding to realize this resolution. We are happy to report that NADEL is in a stable financial position. However, it remains a going concern. We have no doubt that it will continue. We have no doubt that we will continue our relations with the LPC, LPFF, and other regulatory bodies so as to ensure that we carry out our educational program. We need to enhance support for the young lawyers and students. We must ensure access to the profession and practice of law. This conference must take decisive resolutions in this regard. There is an urgent need to support the young lawyers, women, and the disabled persons who seek to practice law. The conference must find ways on how we can assist in ensuring that this goal is realized. As we resume with this conference, Shell is conducting an oil and gas exploration survey searching for oil in Port St. John's. That will result in a serious detrimental impact on the environment, infringing our right to a safe environment enshrined in Section 24 of the Constitution. The destruction of nature in the process is eminently threatening. Various environmental groups and communities have voiced their concerns and are lobbying the government to stop the environmental destruction. As NADEL, we stand in solidarity with the communities and urge that the decision in this regard must be carefully considered. I just have learned that out of litigation in that matter, the court has just given a judgment. Unfortunately, we have not yet seen the judgment. Comrades, that's a brief report that I presented to this conference. I hope that we will continue with a conference that must come with resolutions that must strengthen our organization and give directions. Thank you very much.
Thank you very much, President. At this moment, I will introduce our keynote guest speaker, Mr. Brian Kagoro, who is joining us virtually. He is a human rights activist and constitutional lawyer. He was instrumental in the formation of Crisis in Zimbabwe Coalition. He has served as a consultant for several regional organizations, including the African Union Commission, NEPAD, and the United Nations Economic Commission for Africa. He is also an academic who has published a number of articles on Zimbabwean and world politics. Kagoro holds a Bachelor of Laws, LLB honors from the University of Zimbabwe, and a Master's in Law in International Economic Relations, Constitutional Law from the University of Warwick. He was a Yale World Fellow in 2003. Kagoro practiced law as a partner at Cantor and Imamem, one of the leading law firms in Zimbabwe. He was instrumental in the formation of several civil society groups, including the National Constitution Assembly, the NGO Human Rights Forum, Crisis in Zimbabwe Coalition, and the Center for Citizen Participation in the African Union. He is a founding member of the National Constitutional Assembly, which drafted a new constitution designed to better articulate and protect the rights of all sectors of the Zimbabwean society. He is also a founder of the Crisis in Zimbabwe Coalition, where he served as a spokesperson and national coordinator, respectively. Kagoro is a former student leader at the University of Zimbabwe, an Amani Trust Board member, and also legal advisor to the Zimbabwe Congress of Trade Unions. He is a former board secretary for the Zimbabwean National Students Union and a frequent commentator on human rights, constitutional reform, and political affairs. He has served on boards of both private sector and civil society groups, including National Foods Limited, Workers' Trust, Amani Trust, Action Aid International Ghana, and Zimbabwe Lawyers for Human Rights. In 2002, he became the founding member of Crisis in Zimbabwe Coalition and was subsequently elected as chairperson of the Crisis Coalition. In 2005, Kagoro was appointed Pan-African Policy Manager for Action Aid International, an international anti-poverty development strategy agency headquartered in Johannesburg, South Africa. Brian has served as a consultant for several regional organizations, including the African Union, NEPAD, Planning Coordination Agency, and United Nations Commission for Africa. I got it, Brian. Now I am handing over to you. Thank you.
Thank you so much. There is a saying in Nigeria that when the introduction is long, it means that the substance is low. I couldn't recognize the CV, but let me start with saluting you, my sister, and thank you for the introduction, and also Mr. President for that impassioned brief report, as well as all the outstanding jurists, learned colleagues that are in the room, as well as friends of NADEL. Happy 33rd. I wish to start off by referencing two young men who are key in South Africa's history and in any conversation about democracy. Robert Sobukwe suggested that let me plead with you, lovers of my Africa, to carry with you into the world the vision of a new Africa. Sobukwe also suggested that the philosophy of Africanism holds out the hope of a genuine democracy beyond the stormy sea of struggle. And so he opined that I wish to make it clear again that we are not anti-anybody, we are pro-Africa. We breathe, we dream, we live Africa, because Africa and humanity are inseparable. The other young man is Tembisile Chris Hani. Chris Hani said, if you want peace, then you must struggle for social justice. He said, what I fear is that liberators emerge as elitists who drive around in Mercedes-Benz. I think if Comrade Chris had lived long enough, he would have added Porsche, a Bentley, and other cars. He says, what I fear is that liberators emerge as elitists who drive around in Mercedes-Benz and use the resources of this country to live in palaces and to gather riches. And his one passion was that we need to create the pathways to give hope to our youth, that they can have the opportunity through education and hard work to escape the trap of poverty. I want to suggest, colleagues, that there were 7 matrices of colonial power, if you call it the colonial power matrix. The one was the control of the economy, which is whether it's through your land appropriation or expropriation, exploitation of labor, control of natural resources. The second was the control of authority, which is the coercive arms of state, such as the institutions, security, prosecution. This idea that the matrix of colonial power was the resort instinctively to violence, to discipline, and to punishment. The third was the control of culture, of custom, and education. A knowledge imperialism and epistemic violence that sought to impose, whether it's in the practice or in the legal education fraternity, only one knowledge, and that knowledge being Western knowledge. And then, of course, there's the control of spirituality. The colonial project sought to control the here and now, as well as the afterlife. And this was done through either institutionalized faith or criminalization of particular types of African beliefs. And the third was the control of welfare, well-being, and livelihoods by building the dependence of not just African individuals, but whole communities on what was seen as the benevolence of the colonial apparatus or the colonial institutions, including a white supremacist view that black folk who prior to colonization had been independent, able to be self-sufficient, were through the imposition of tax and other laws made dependent. They were only permitted in certain areas if they served the interest of the ruling class at the time. And clearly, the next was the control of technology. That in essence, we were not colonized because we were culturally inferior. We were colonized because of two primary reasons: because we were divided, and second, because those who sought to colonize us had technological supremacy over us. And the last was the control of gender, and you could add to that sexuality, but the control of family, of clan, of tribe, the confinement of our people into what became known as tribal trust lands was a very key issue. I say this as an introduction to a conversation that says, as Africans, we waste most of our socially necessary labor time to produce and often useless products for export. Yet our export earnings are not enough to sustain our economies, even for a country as big as South Africa. And the reality of the continent at the moment is Africa puts more time or puts more into the global market than it gets out of it, which means that whether you are dealing with mining or natural resources or agriculture or any endeavor, Africa experiences net losses in its interface with the global market. So clearly, there are social, economic, political, and other consequences, or what you would call a penalty for this splendid wastage of socially necessary labor time. And this penalty is environmental degradation. This penalty is poverty. This penalty is inequality. This penalty is unemployment, it's hunger, and the outrage that we see from young people, especially across the region, the continent. Today, in seeking to reinvigorate, in order to create futures that are better or different from the past, we need to recreate, we can't recreate history. We, unlike the West, don't have countries that we can go to and colonize so that we can do our primitive accumulation that enables our industrialization. And we have learned from the bit that is recorded that export of primary commodities to the developed world or even to the developing world, such as China, will not get us where we need to go to. So in essence, we need a different outlook to both economic policy and development. We need an epistemic paradigm and practice shift. There are two key framing ideas that will help you understand some of the remarks that I wish to make. The first is that external causes are only a condition of change. External causes are only a condition of change. And internal conditions are the basis of change. And if we appreciate that external causes are only a condition of change, and the internal conditions are the basis of change, it is possible for us to imagine futures where self-reliant growth, mutuality, interdependence, and Pan-Africanism can be made real in our lifetime. I'm talking to lawyers, and in talking to lawyers, often one has to start with a dissertation, and this is it. The Mande Charter that the Mandika people formulated for themselves as early as 1222 talks of two concepts that are key to South Africa, two concepts that are key to Africa and the creation of futures that are different from our past. The first is the notion of internal healing. We have a lot of wounded people and wounded leaders, as Nomfundo Mohapi once suggested. What we as Africans have to do is to figure out ways to repair ourselves, to repair our communities, to repair our own psyche. But that internal repair question is linked to the question at hand, the question of transformation. The oppressed can only be emancipated by themselves, by assuming a measure of mandate, a measure of agency, a measure of identity consciousness, a set of liberatory ideas, a voice, and a consciousness. But there is another end, which is the external repair, which pertains to what is done to us by others, what is owed to us by others, and this struggle to create a global cognitive justice where there is a right to know, and a right to be, a right to become, and a right to belong. And I want to suggest that in reparations, and when you look at the Mande Charter that I referred to, which is an Afrocentric way of looking at reparations, is we need to raise up certain things which were ruined, not just by the colonial project, but which have been ruined by our own political elite, social and economic elite. Number two, we need to repair that which is damaged, right? Number three, we need to put back together that which is severed, or to reconnect that which is disconnected. We need to replenish that which is depleted, including the earth, including our culture, including our consciousness. And we need to strengthen that which is weakened. And a lot of things have been weakened in our society, not just ethics, not just institutions, but our ideological awareness of the complexity of the world and the complexity of power. We need to right the wrongs. We need to cause to flourish or to prosper that which is insecure or underdeveloped. But we need to heal the wounded. Above all, though, and this was implicit in my brother Max Botwane's presentation and the president's presentation, we need to rehumanize the dehumanized. And that could actually be all of us in this room and in this conference. And in rehumanizing the dehumanized, we're dealing with those who are excluded as a base because they are poor, excluded on the basis of their gender, excluded on the basis of their ethnicity, excluded on the basis of their race, excluded on the basis of their class. They are stigmatized, they are criminalized, and this criminalization of poverty is part of what I call the colonial matrix of power. And you cannot get to this without a knowledge foundation, because all liberation is first knowledge, and all struggle is anchored in cultural consciousness. Rebellion and resistance are part of creation. They are part of co-creation. They are part of recreation. So this global cognitive justice that I'm talking about says that there's a diversity of knowledge. Why am I saying those things? Speaking to lawyers. Our constitutions across the continent, and in particular the glorious and beautiful South African Constitution, rests on a foundation of contradictory and sometimes impure motives. When the negotiation process for the new South Africa was happening, white supremacist interests sought to defend certain things dear to them. Radical economic and political transformation advocates sought to include in the Constitution things that they thought would enable them to transact the radical economic and political transformation. Conservatives and liberals sought to exclude violence and self-help by simply ensuring that there was order. All these are reflected in the Constitution, and in particular, protection of private property and the aspiration to do forms of compensation. So in politics, and in particular, the transition of South Africa to democracy, there was no immaculate conception. Mr. President, the transition of this glorious South African nation to democracy was not an immaculate conception. In the transition to democracy, there were all sorts of motives and all sorts of trade-offs. This generation of leaders, this generation of lawyers is faced with the consequences of the trade-offs and is faced with the vagaries of the motives which were hidden in the expression of what were espoused at the time as common good or public interest. And some of those were clear, depending on where one sat, certainly not contrary to the private status, the class interests, and the biases and prejudices of those who were negotiating. The distinction between the school of 1994 to 96 with the present leadership is not just a commitment to constitutionalism, but rather the approach of the leadership then to international, to continental, and national political, economic, and military and other policy issues was fundamentally different. In this context, in the context of transition of South Africa, the political formations and civil society had a universe of discourse, a conceptual common denominator, such that the Rainbow Nation ideology and an internationalist ideology or globalist approach to life enabled them to imagine transformation in ways that were not parochial and not steeped in self-interest and revisionism, but a revision of policy, of institutions, of leadership, anchored on South Africa assuming its rightful place in international arena. and South Africa's ability to survive in a very complex global political economy, and at the same time assert its national sovereignty, as well as be democratic, requires that we acknowledge the following. And this was implied in the address by the president of the SADC Lawyers Association, and also the address by the president of NADEL, that liberal democracy globally is facing serious challenges. The historical struggles in the heyday of liberal democracy, where there were bad boys or bad guys and good guys, where military rulers, dictators, white supremacists, and if you were sitting in the West saw some of those of us in this room who are on the left as the bad people. They had a struggle against communism, against Arabs. So their democracy was xenophobic, but their democracy was also ideologically anchored. So this notion of democracy as regime typology, based on good and bad people, based on a tick box, is facing fundamental crisis. We now have elected authoritarianism, and we now actually have possibilities in the entire Western Hemisphere of that liberal democracy in its current expression is not necessarily use of society. The populism that we saw in France, the populism that we saw under the Trump moment in America, the populism that we're seeing in Europe under the Brexit moment, has come with it a politics of otherization, new forms of discrimination, new forms of identity contestation, Islamophobia, anti-migrants, and anti-anything that is different. It has had a nationalist and religious flavor, a conservatism. But why is this populism thriving, you might ask? Well, it is the failure of neoliberal development orthodoxies, the failure of neoliberal economic approaches, the failure of liberal democracy to deliver development dividends, but also the hypocrisy of the West in the application of the so-called democracy standards. So the ability of populists and authoritarians to capture states, to capture the hearts and minds of citizens through money, through media, through messaging and narratives, essentially means democracy can now be hired. Democracy can now be purchased. Democracy is now subject to the highest bidder. So this capture of institutions has, for us lawyers, led to what the Ugandan judge referred to the judicialization of politics and the politicization of the judiciary. But if it had ended at that, it has also led to the capture of electoral management bodies, the media, social media, troll factories, malign influence, but also a sense in which citizens now turn to militaries as salvation against elected authoritarian leaders. I think in this context, and the context is a lot more complex, we need to ask ourselves, are the traditional tools, are the ways in which we traditionally asserted democracy, rule of law, and access to justice still as cogent and as potent? I want to suggest that those who came through the legal profession in the 80s and 90s and 2000 will know that strategic litigation, public interest litigation was a magic word. But these days, elites in power ignore judgments with impunity. Or if they are unhappy with judgments, they will simply go to the publics and castigate the judgment as lacking or an attempt to undermine, if you like, a radical agenda. Electoralism, which was seen in the, after the collapse of the Iron Curtain as the panacea, where we elected leaders, and it was seen as an exercise of choice. Many in South Africa, when they voted in their first elections, saw this as emancipatory. Today, it has become a dirty word because we have choiceless democracies. We have militaries, we have rich boys and girls who can capture elections in political parties, capture primary elections, and capture national elections. And the link, therefore, between poverty, disenfranchisement, and primitive accumulation of wealth essentially means the narratives of civil society, of the political opposition, and of ruling parties, the puritanical positions that some have taken seem to favor regimes and the situation. And it would seem to me that it is high time that we as lawyers sitting in this room realize that as important as ethical leadership is, it is insufficient to deal with the challenges of the moment. Because the emphasis on ethics alone can be ideologically vacuous. The myth of good and bad sometimes is purely that. It does not speak to the subjective and objective conditions of the poor, the unemployed. And within the global context that I described, and the new vigor that we require, we are seeing the return of identity politics, be it based on race, on religion, or ethnicity. This return on identity politics will make a lot of people from the left squirm, because we believed in economic determinism, that the struggle for race, for identity, for gender, whatever, you could solve it by purely ensuring that people had the means or access to the means of production. But it would appear to me that perhaps in that we were limited, and Gramsci was right. So we are also transacting all these traumatic events in the context of a zero history generation. From the moment I began speaking to you up to now, as a result of access to the internet and WhatsApp, you most probably have received so many messages that you've forgotten the first line that I said. This is the generation, the ability to hold on to an issue, to execute and prosecute struggles, to sustain it, the ability of society to cohere around and exercise solidarity sustainably seems to be under threat from a tool that has also enabled us to organize transnationally, the internet and social media. This new power that we have in our hands essentially also means that xenophobia, racism, sexism, and patriarchy can be transmitted almost on steroids in the same way that struggle can be transacted almost on steroids. All of this is happening in the context of COVID-19, where global power has shifted significantly. It is not just the former colonial states and the so-called superpowers and emerging powers, but there's a global plutocracy of bosses of big technological companies, big pharmaceutical companies, big mining companies, who seem to have an abiding and pervasive influence over decisions of government, over decisions of multilateral platforms and bilateral platforms. And within these platforms and this redefined power of technology, power of the global plutocracy, and the historical power of nations that were colonial or imperial powers over Africa, racism and harm thrives. And therefore, it is impossible to do decolonization without doing anti-imperialism. But if we're decolonizing the state, society, knowledge, bodily autonomy, health, if we're dealing with vaccine justice, dealing with climate justice, dealing with this, we need to accept as lawyers that courts are very important. The legal profession is very important, but it is insufficient. That often, because of our enslavement to procedural rigor, our institutions are not sufficiently responsive to a generation that gets information at the speed of light. So our institutions are not responsive to the needs of the local or the national. And our traditional approaches of naming and shaming may not seem to work as effectively. So institutions are not equal to the challenges of today, whether it's unemployment in Soshanguve, whether it's migration or technology, whether it's hunger or poor service delivery. So our old tendencies towards secrecy, towards impunity, towards hypocrisy, and our influence as lawyers that were based on a pristine and status that were occupied in society needs to be traded for what the Mandela generation and the Tambo or our Tambo generation realize. That the struggle will be fought in the boardrooms, in the courtrooms, on the streets, but the struggle will also be fought in the theater of knowledge. We need a radical rethink of legal education. We need a radical rethink of legal practice, not just e-justice, which are the mechanics. And we need a radical rethink on how we approach our influence as a profession beyond the courtrooms, and the law school. How we address diversity, equity, and inclusion, gender, race, culture, and age. How we address transnational power and its local proxies. How we ensure that we move beyond responsibility to accountability for the power that I described. This reinvention, this reimagination is not simply about our objectives and values. These may remain largely the same, but how we do things, where we do things, and when we do things. The tough questions that face us colleagues, especially those of you who teach the law, those of you who teach democracy, is liberal democracy still the panacea? Is bourgeois democracy facing a crisis, an incurable crisis? Is the problem purely one of ethics and poor leadership, or is there a structural problem? Law and the economic security of the poor sometimes, and in particular addressing extreme inequality and poverty, the insufficiency of our traditional narratives on human rights in addressing extreme poverty and economic insecurity of the poor. The insufficiency of our constitutions in dealing with the right to rebel that young people in the Sudan have assumed, that young people in Mali have assumed. The battle of values that we face over the question of climate, where a lot of people are saying, oh, solar is the answer. And we have young students at the University of Cape Town and Witwatersrand at the University of the North saying, well, these solar panels work using lithium batteries. Lithium is mined in ways that dehumanize our people. I want to conclude by saying, Mr. President, honorable colleagues, that we need new institutions, we need new approaches. I can see the need. We all can see the need. Previously, the path was through the courts. Previously, the path was through Parliament. I want to suggest that given the enormity of the challenges and the complexity of the challenges, and the limitations of what Parliament is able to regulate or not regulate, you will know that historically you couldn't sue apartheid companies within South African courts, the international companies that enabled sanctions passing because of the limitations of South African law itself. We must reimagine the tools in the context of failing national institutions and multilateral institutions. We must reimagine a transnationalism of the law and of power that enables us to create the future. But the future cannot be created by a puritanical historical view of the law. The law must subject itself to the sociology of power. The law must subject itself to an understanding of the complexity of the digital age. The law must subject itself in understanding the yearnings and aspirations of the youth. Frantz Fanon was right in saying they took the best of our people. They sent them to the imperial centers to be educated. And when they returned, their kith and kin realized that their sons and daughters had not come back. All that had come back were echoes of the empire. The challenge that I leave you is that in talking about democracy, in talking about global power and transformation, we are not perhaps in the moment of the old binaries. Liberal democracy is insufficient. How we previously characterized global power from the left is insufficient. The diffuse forms of power, the reality of a local comprador elite and an accomplice lumpen element, as well as the resurgence of identity politics not linked necessarily, purely only to poverty. And the growth of a divisive narrative that sees other poor people, people within our own class, as the problem, requires that we fundamentally think, not in cliches, but in very practical terms. The future is only possible if we see the whole. Nobody will give a damn about Africa. Nobody will care about Africans. Nobody owes us a living. We owe ourselves a living. Without unity, we will be conquered again under this new scramble for Africa. Without technological supremacy, we'll be lame ducks. Without reimagining our security in transnational terms and our solidarity, an alliance of all progressive forces, what we will be doing is tinkering on the edges. We'll be victims. I thank you. I hope I've been able to inspire you to remember, we are the surest agent of change. We carry heads with brains. Our brains can either echo the empire or can dare to rebel against what we were taught, what we have always embraced, and imagine our future on the basis of a very independent paradigm of what is it that will make us survive without being victims of global lockdowns. Thank you.
Thank you so much, Brian, for such a thought-provoking presentation. Thank you for making time to join us today. We know you are not in South Africa at the moment, but on your return, we will be in touch. Thank you so much. At this stage, ladies and gentlemen, comrades and friends, I will now go back to the President's report, and I will take questions or comments. The floor is open. Yes, Comrade Makangela. Comrade Makangela, you must come to the mics. Thank you.
Thank you, SG. I thought this mic was going to rove around the conference venue. We are scared to come here when we want to ask questions. But anyway, thank you, Mr. President, for your input. I just want to comment and on a few things that you have highlighted. I think there are about 3. The first one being that NADEL, it's not a members' interest organization, but rather a human rights organization. The voice of NADEL, the silence of NADEL in what happened in KZN, in the massacre, when people were butchered there, is too loud. Can't be speaking in silos. There are commissions. We don't even know what happened in NADEL. There is a family from Lusikisiki, a child who went to Durban for a holiday in June, who, when she went out to buy bread, was confronted with those vigilantes who butchered her. NADEL was silent. We can't be speaking when this incident inconvenienced other races. We know black people were killed in Durban, in their majority. And we can't only be the activists on paper. We must be seen doing something. Human rights violation, a promotion of vigilantism happened during that period. We had the executive giving platform to communities to take laws into their own hands. Please protect your space. How? In terms of what? Because there's SAPS who is duty bound to protect communities. When you say communities protect your own space, with what limits? Hence, we found those people were killed there. So, NADEL must be seen doing something. And that must be one of our issues. Not only with the slogans, the history. We are no longer living in 1987 now. We're in 2021. We must be there. NADEL was there during apartheid. It's not apartheid now. We have to be there. We must be visible. The second issue, NADEL talks, or President remarked about the environmental, there are calls, nature. What does it say to those communities who are living along the coast? Do they really benefit in that nature? If you go along the coast in Willowvale, you go to Tendane, do the people benefit from that environment they live in? Do they enjoy those rights to fish there? Do they enjoy the rights to hunt there, the people in those villages? Are we there as NADEL, or we're just existing in big cities and we speak in big terms? When those are inconvenienced again by Shell, we come and speak for Shell. My point is, whether there is an impact, what does it say to those people there that we claim to represent as NADEL? Because we should be the voice of the voiceless. Are we speaking for them? Do they understand what it means as things stand? Will they understand it tomorrow? Lastly, we again need to raise our voice. Whenever a politician approaches the podium, they want to speak on the issues of medical negligence. The first term, lawyers are parasitic. Parasitic lawyers. Lawyers have no one to represent themselves in these issues. Lawyers are not working in hospitals. Lawyers are in this venue. Government employees are in hospital, are messing up with the lives of the people. Those people tomorrow will come to our offices. We are duty bound to ensure that we hold those ones accountable. But when you take those matters to the courts of laws, we are called names. Again, NADEL must stand up, must raise its voice. Same applies with what we have just seen with the Road Accident Fund, disobedient of the court orders, but rough people, when they have an issue, they run to the same courts they disrespect. If it's not favorable to them, they disobey those court orders. But if they want to extend and do whatever, they run to the same courts. We have to speak in one voice. We have to condemn. The rule of law is the rule of law. You are happy with the outcomes, it's binding you. You are not happy, exhaust the options that are available to you. Thank you very much.
Thank you so much, Mr. Makangela. I'll take one more question before I hand over to the President to respond. No hands. Yeah. Okay. There are no hands, no further questions or comments to the report. I will then close the session. We will now break for an early lunch, and we will resume at 1:30. Thank you very much.
Yeah. Yeah. 1, 2. Yeah. Yeah. 1, 2. Yeah. Check 1. Yeah. 1, 2. Yeah. 1. Yeah.
things. We will have to jungle around our program because some of the speakers, particularly those that are not with us, they have fixed the time, some are international, so we can't change their times around. The minister will be speaking at 2, will be speaking to us at 2. So what is going to happen is that I'm going to hand over to Lizelle now to start introducing the speakers in this program now. But at 2, we will just adjourn and allow the minister to address and come back again to this program. So I will hand over to you, Lizelle.
Oh. Mr. President, NEC Justice Matlanga, Judge President Benenge, honored guests, members, ladies and gentlemen, I have the pleasure of facilitating part of the second session, and mine starts off with an introduction, or introductions. With respect to the first guest, he is a South African lawyer, a member of the Duma Nonkwe Group within the Johannesburg Society of Advocates, a member of the Advocates for Transformation, a PABASA member, a commissioner of the Judicial Service Commission, a seasoned and celebrated member of the legal profession. The South African has named him the most famous lawyer in South Africa and a legal superstar to South Africans. He is also a politician and has occupied several notable positions in South African politics. His participation in politics started in the 1980s with his involvement in, amongst others, the movement against apartheid. Although he left the ANC, he has continued his political engagements with the EFF as its chairperson. As a businessman, he has held several notable positions in several organizations within South Africa. He served as the board chair of Proudly South Africa, Boxing SA, served as chairman at the ICTBE Charter Working Group, Victim SA, Business Against Crime, and held various director positions. From the articles that I've read, they say he moved from East London to ANC to EFF, from SABC boss to South Africa's legal eagle. I am excited to call to the platform a passionate politician, outspoken academic, and a strong advocate, Dali Ngolo, Dali Christopher Mpofu. Then for my second guest, Daily News in 2012, it's mine. Daily News in 2012 stated that he intended to use his role as co-chairperson of the Law Society to push and advance transformation in the legal profession and the judiciary. News 24 famed him for always aspiring to the highest standards of ethics and professionalism. The South African Human Rights Commission nominations 2016 notably stated that his CV details an impressive struggle history and various prestigious appointments to various government bodies and the KwaZulu-Natal Law Society. I therefore only need to highlight that he served on the Council of the Law Society of South Africa, the KwaZulu-Natal Law Society Council, the Legal Practice Council, and the Bureau member of IADL. He was a member of the steering committee that co-founded and launched NADEL with former Justice, Minister, the late Dula Umar, former Justice, Chief Justice, the late Pius Langa. He served as a National Executive Committee for NADEL for many years and has been a Publicity Secretary, a General Secretary, and a Vice President. I understand that he's also known as the longest-serving spokesperson of NADEL. He's also been involved in community, civic, political, and educational bodies as an activist and has served as Vice Chairperson of the Council of the University of Durbanville. It is my pleasure to introduce a long-standing member, NEC member, Akeda comrade, and activist Kirsten, affectionately known as Krish, Govender, to the podium.
Too long.
As indicated by the President, we're first going to start with Dali. If the Minister joins at 2 o'clock, we'll then adjourn, but my guests will be asked to stay on the stage, and thereafter we'll continue with Chris. Thank you.
Shall I go first? Thank you very much, Lazelle, for that generous introduction. Judge President Benenge, I saw Justice Madlanga, I don't know if he's still here, other honored guests, President of NADEL, the leadership of NADEL, and other judges who might be present here. Yes, we've been told that we have to cut down on what we had to say because the minister has to speak at 2 o'clock. So I'm just going to go straight into the issues. I was going to remind Krish, my co-panelist here, that in 1995, both he and I were elected into the national executive of NADEL. In his case, he was being re-elected. In my case, I was being elected for the first time here in Port Elizabeth. And then we also served together in the National Forum, which is closer to the topic that we've been asked to speak about. Now, my involvement with the Legal Practice Act comes back literally from those days of our NADEL involvement. Again, Chris and I were part of the negotiations that resulted in the 50-50 arrangement with BLA in the 90s. But the idea of what we then called fusion, Krish, which was in around about 1996, 97, at a conference in UNISA. That's when NADEL really pushed for this idea of fusion under the ministership of Dala Omar, a stalwart of NADEL. What happened 20 years later, to cut a long story short, was the Legal Practice Act, which I'm afraid did not introduce any fusion, really, but did go some way into unifying the profession. Not in the way that we had envisaged when the process had started, and also because it took too long, quite frankly, to materialize. So I always say this about the Legal Practice Act. It's one of those pieces of legislation which should be much easier to administer and to implement, easier than other legislation, because the preamble to that piece of legislation is so clear as to what it is that is supposed to be achieved. Unlike many other statutes, quite frankly, all you need to read is the preamble in the Legal Practice Act if you wanted to test as to whether things are really happening the way they were intended to. I'd like to invite everyone to have a look at the preamble in your own time, but you will find there references to the provision of a legislative framework for transformation. That's the very first line that you get there. Restructuring of the profession, the representativity in terms of demographics, values embraced in the Constitution, access to justice and legal services, regulation of the legal profession in the public interest, the removal, a very important one, removal of unnecessary barriers to entry, strengthening of independence, and ensuring accountability. So I always say that everything else that follows in that act, particularly the topic that we've been asked to talk about, which about the LPC, which you'll find in sections 5, 6, and 7, most importantly, of the Act, should speak to that preamble. And if you want to gauge as to whether the LPC is working, is achieving governance and access and all these things that are in our topic, then you should gauge it against those sections as to whether the current, any leadership of the LPC should, if they have KPAs, they should gauge them literally around those 6 or 7 issues. So Section 5 of the Act talks about the objects of the Council. Section 6 talks about its powers and functions, and Section 7 talks about its composition. And again, all those 3 components in Section 5, 6, and 7, in theory, should be judged against the preambular list that I've already mentioned. Now, because we don't have time, I think let me cut directly to what I would have built up to as a conclusion. My own impression is that, and fortunately this is an impression of someone who's no longer a leader in the LPC or National Forum and so on. I'm speaking almost as a ground force, just as a practitioner observing what I've observed since the institution of the LPC. My clear impression is that things are, well, if I said the act is not what we envisaged, then I think that even what is happening on the ground is not even that which the act provides for. My own view is that and I'll pick up 3 areas where I've been disappointed with the performance of the council or of the entire system. One is the one that is contained in our topic about admissions into the profession, and then I'll talk about the disciplinary code, the implementation thereof, and then of course linked to Section 7 of the Act, the composition, or let's say maybe more directly the results of the recent elections, which all of those are areas of concern to me, or flashlights, yellow lights, whatever you call it. And I'll be anecdotal just to save time. As far as admissions are concerned, if you accept that one of the objects of the Act is to, as it says in the preamble, remove barriers to entry, unnecessary barriers to entry, then you will have to agree with me that that has not happened, particularly in the space where I'm operating, which is the advocate's profession. I was appalled or shocked or whatever description you can find when I was approached earlier this year by pupils who told me that, to cut a long story short, they were being threatened with having to write 2 examinations. One under the Johannesburg Society of Advocates or whatever bar they were being trained under, and another exam under the LPC. And I thought, that's ridiculous. That's surely, that cannot be what we were trying to do for all these 20 years, to come to a situation where people actually have to write 2 separate examinations for what? And we did a few interventions. Fortunately, again, to cut a long story short, sanity prevailed in the end. And I think people had a choice to either write the bar exam or the LPC exam. something like that. But at least nobody was forced to write 2 exams as it was being threatened. And I think that speaks for itself. I don't have to, an audience of lawyers, you would know how ridiculous it is for someone to actually go through training and then be asked to write 2 separate exams set by 2 different people and so on. So that's an area of concern. Then the other area of concern is in the disciplinary implementation of the disciplinary stakes. So I'll give you some juicy stuff, but it won't be as juicy as it could be. I'm sure all of you know about the famous shut up incident that happened in some commission. We'll talk about it on another day, or whatever your view might be on it. I would be interested to know, especially those people who have practiced in this country for as long as I have, or even longer. But that's not the point. The point is that, and I'm using that as just as an anecdotal way of criticizing this part. Okay, this happened around about February or March of this year. And within a couple of weeks, there were all sorts of complaints and counter-complaints. I lodged complaints, other people lodged complaints against me, and what have you. And literally, these complaints were in the traditional bar system and in the LPC. And I'm sad to say that the ones that were in the bar, normal bar, the old bar system, were processed, I think, by September. And until today, I'm still waiting for the processing of the ones that were in front of the LPC. I would have thought it would have been the other way around. In any event, one of the issues that were raised in one of those things was to say, no, the LPC, because it's a statutory body, must take precedence over some voluntary association. And one would expect that to be the case. But in reality, the LPC process has been overtaken by the voluntary association process. So I'm using that just as an example to illustrate that there clearly are some gremlins and teething problems which will have to be ironed out by those people who might be in the leadership. But from my vantage point as a practitioner, I'm experiencing those 2 areas with a lot of concern. The last one, Chair, is the issue of the elections. The president of NADEL mentioned this, or somebody else did, and that goes to this issue of composition, by the way, in Section 7 of the Act. I'm not sure if we put, Krish, if we put sufficient checks and balances, I think is the right word, to ensure that the profession, while we're trying to transform it, doesn't get captured by conservative elements, or how, at least to make it difficult for that to happen, because it has happened now. I don't want to mention names, but some of the people who are supposed leaders of the profession now should not even be in the profession. But the ease with which those people are able to ascend into crucial leadership positions is something that we're going to have to watch out for. So I think I'll stop it there, but there are many other examples which one can cite, as I say, from an onlooker, and I'm happy to be corrected by those who are in the real thick of things. But from my current vantage point, those are some of the areas of concern, and I think NADEL has a particular role because, as I say, this entire transformation mission was a brainchild of NADEL long in the 90s, when it was pushed at a particular point for a particular reason. And the last thing we'd like to have is to have, yes, a single act, yes, so-called co-governance and, single numbers. We all have our LPC numbers. But if the real objectives that are enshrined in the preamble of the Act, which, as I say, are not even sufficient in themselves, but even those minimum objectives are not met, then it might end up being an exercise in futility. And I think it's something that NADEL must apply its mind specifically to say, okay, we've got the framework, we've got the Act, we've got all these structures, but how do we make sure that it actually delivers to the person that the President was talking about, no Hombile from some other place? Something completely different to what preceded it. When we talk about access to justice, what do we mean by that? Do we mean access to lawyers, to briefs, or do we mean something much wider? Do we mean the issues that Kagoro was talking about, which are the more ideological issues, a seismic shift in how the profession is used as an instrument of change, which, in my unfortunate judgment, is not what is happening. Thank you.
Thank you very much, Advocate Mbofu. Good afternoon, comrades, distinguished guests. Our guest speaker, the Honorable Minister Lamola, is online, and he will. I will now be introducing him. He may have challenges with his camera, but his audio is well on track. The Honorable Minister Ronald Lamola is a member of Parliament, and he was appointed by President Cyril Ramaphosa to form part of the National Executive and Cabinet as the Minister of Justice and Correctional Services of the Republic of South Africa on the 29th of May 2019. He was born in Bushbuck Ridge, Mpumalanga, and matriculated from Machaka Secondary School. He is the former Deputy President of the ANC Youth League. He was elected to the National Executive Committee of the ANC at the December 2017 conference. He is also a member of the National Working Committee of the ANC. He obtained his LLB degree from the University of Venda in 2005. He holds 3 postgraduate certificates in corporate law, telecommunications policy, and banking law. He also has an LLM in corporate law from the University of Pretoria. In addition, he also obtained 2 master's degrees from the University of Pretoria. Lamola's first master's degree was in corporate law, where he explored the regulation of property syndication schemes. His research looked at the roles of regulations in the regulation of taking deposits from the public, the conflation of the Companies Act, Banks Act, and the Reserve Bank Act. Lamola got his second master's degree in extractive law in Africa from the University of Pretoria in 2018. His research focused on corporate social investment by the mining and energy sectors. His research suggests that the Department of Minerals and Energy's Enforcement Unit is inadequately resourced to ensure compliance with the social labor plans by companies in the sector. He is an admitted attorney of the High Court of South Africa. He formerly practiced as a director of private law, which specialized in competition law, litigation, communication law, and banking law. The acting spokesperson of the Mpumalanga Premier from January 2011 to October 2011. He was the director at the office of the MEC for Culture and Sports, Recreation in Mpumalanga in July 2009 until 2011. At this moment, ladies and gentlemen, I will hand over to the Honorable Minister. Thank you.
Thank you very much. Hopefully you can hear me. If you can't see me, you should not be worried. I've got challenges of the camera. I hope you can see me. I hope you can hear me.
Yes, we can hear you.
Okay. Thank you very much, Program Director. The President of the National Association of Democratic Lawyers, Mr. Najisi, the Secretary, Ms. Jali, and the entire leadership of NADEL, judges and the justices of our various courts, who are in attendance, all distinguished guests in this annual general meeting, and the leadership collective of NADEL. I'm honored to be with you virtually as we gather to take stock of this term. I must apologize, I'm not able to join you in person because I've just landed from Nigeria on by a national trip with the president. I would have liked to be in PE with yourselves, but unfortunately it was not to be. But I hope I will still be able to contribute to the discourse. This gathering is happening when society is in transition due to the COVID-19 pandemic that we're all facing. We are all living to learn anew, and that goes for all professions. All of us are learning new things and new ways to do things. And that is in all sectors of society, and even professions are not spared. As we gather here today, injustices of the past continue to linger on our heads. The global community is still viewed in the years of colonialism. Our own country still has the remnants of apartheid in the various sectors of our society, including in professions. At the end of November, we saw this in the most striking way. The rush by the Northern Hemisphere nations to close their nations' borders after our scientists had explained to the world what was the latest version of the COVID-19 variant, Omicron. Instead of them working with us to find a solution to the new variant, they decided to close us and some of the Southern African countries, to the displeasure of the entire scientific community of the globe. We are hopeful that they will reverse this unscientific decision because it affects our tourism industry, but it also affects the economy as a whole. These unilateral acts of self-preservation at all odds go against the spirit of multilateralism and global collaboration. These type of actions are backward in nature and of course extremely prejudicial. This week we have also learned of the latest unemployment figures in our country. Without doubt, these figures should concern all of us because these are not just figures, it is the lived reality of millions of South Africans. Our economic reforms need to be swift and effective and be inclusive. Part of our reforms will also entail approaching the new markets, and these markets may not necessarily be the West or Northern Hemisphere nations. The African Continental Free Trade Agreement will create the largest free trade area in the world, measured by the number of countries participating. The pact connects about 1.3 billion people across 55 countries with a combined gross domestic product valued at US 3.4 trillion. It has the potential to lift 30 million people out of extreme poverty in Africa. But achieving its full potential will depend on putting in place significant policy reforms and trade facilitation measures. As this week comes to close, the President of our Republic will have concluded state visits across several countries in West Africa, Nigeria, Cote d'Ivoire, Ghana, and Senegal. This AGM should also help us to develop strategies to include Black practitioners in the transactions that will come out of the intercontinental free trade agreements and all the transactions that are happening in our continent. It should not be that we should continue to have transactions happening in the continent and with a minimal participation of Black practitioners to make these transactions possible. The refrain Maibuye Africa is not just a rhetorical one, but it is also an economic one. Nkosi Albert Luthuli delivered in his Nobel lecture in Oslo, Norway. Among other things he said, and I quote, "Still licking the scars of past wrongs perpetrated on her, could she, Africa, not be magnanimous and practice no revenge? Her hand of friendship scornfully rejected, her pleas for justice and fair play spent, should she not nonetheless seek to turn enmity into friendship? Though robbed of her lands, her independence and opportunities, this oddly enough, often in the name of civilization and even Christianity, she shall not see her destiny as being that of making a distinct contribution to human progress. and human relationships with a peculiar new Africa flavor, enriched by the diversity of cultures she enjoys, thus building on the summit of present human achievements, and edifies that will be one of the finest tributes to the genius of man. Close quote. Distinguished guests, I have no doubt that NADEL has the capacity to pursue paths of social justice and transformation. Its 34 years history, NADEL has been a bastion of progressive loyalty. This has not been lost despite a long passage of time. The recent contribution by NADEL on how we should address the land question is yet another example of not just being lawyers, but being active proponents of social justice. It is time of lawyering that will help us unbundle. It is the type of lawyering that will help us unbundle the racist colonial domination of the indigenous African majority, which was characterized by politics and governments in South Africa for centuries. The fourth writer's submissions we made, which sought to address the myth that blacks do not have the skills or the desire to work the land in a self-sustainable way and profitable manner. It is critical intervention in a discussion which often is soiled by red herrings on how land reform can lead us to rains. Equally compelling, the exposition of whether there is a disconnect on an ideological level between the transformative vision and what has been termed by yourself as legal formalism that is guiding government's approach to property rights, and whether this actually perpetuates historical injustices. Perhaps this is a lens we need to apply across the board. Is our transformation constrained by legal formalism? The HRC conducted a survey in which they asked South Africans several questions. Two of those questions really piqued my curiosity. The first question was whether South Africans were satisfied with the democracy. The survey revealed that there's a growing disconnect with the functioning of democracy in South Africa, despite an improvement following the transition to the Ramaphosa administration. In 2004, 63% South Africans indicated they were satisfied with democracy. By contrast, in 2017, the level of satisfaction had fallen significantly to a mere 23%, with a slight recovery of 35%. When asked if South Africans trust in core political institutions, the study found that there has been declining confidence in the national government and parliament since the mid-2000s. There was a slight improvement between the 2017 and the 2018 survey rounds, but trust nonetheless remains circumscribed. Trust in national government decreased from 67% in 2004 to a low of 28% in 2017, while trust in parliament dropped from 63 to 25% over the same period. This also tells us that the reality our people are facing across the country of poverty, of abject poverty, unemployment, is something we have to confront. People are not interested in just voting and participating in a democracy. They want to see their lives changed. And I believe this AGM will also contribute to the progress of our nation. Now, if we consider that the triple challenges of poverty, unemployment, and inequality remain stubbornly with us in spite of our democratic regime, we may be able to analyze the results of the survey. The triple challenges remain among the dominant challenges facing the government in its quest to create a better life for all. For lawyers, the question is, do South Africans have faith in the justice and the justice system? I pose this question to this forum because you are all in the business of justice. You are participants in the program to make justice accessible to all. During 2018, a survey revealed that crime is on the rise and trust in the criminal justice system is declining. Therefore, it is our task with all the stakeholders, including members of NADEL, to reverse this tide of the mistrust of the criminal justice system. We all participate in the entire value chain. Now one would suspect that these sentiments remain despite very high prosecution rates for crimes like GBV in particular. And so the question I want to leave you with is what can be done to restore and enhance the institution we're practicing in the criminal justice system? Our quest to transform state legal services is something we intend to fulfill with zeal. Program Director, allow me to go into detail on this matter. Hopefully, some of your members will have interacted with some of the issues I'm going to raise. The establishment and the mandate of the Office of the Solicitor General. The State Attorneys Amendment Act of 13 of 2014 was proclaimed with effect from the 7th of February 2021 and brought about the following fundamental changes. The creation of 13 offices of the State Attorney across the country, all intended to each have the head of office of a Chief Director level. The establishment of the Office of the Solicitor General. As we are already aware, the Acting Solicitor General, Mr. Ronald Fitzisane Bandelan, was appointed on the 16th of March 2020. He is the executive officer for all state attorney offices and is expected to exercise control, direction, and supervision of all offices of the state attorney. This was the first step in the coordination of the work of the Office of the State Attorney. Because the Office of the State Attorney, when it was created, there was only one SOC, which was the former National Railways. It was aimed only to cater for the National Railways and for a few government departments. But government has grown since 1994, and the State Attorney's Office has lagged behind. We have a duty to modernize it. Hence, I want to go into detail on this matter, Program Director. The Solicitor General is not only leading and coordinating state litigation, but he is also oversees the performance of the entire state litigation services, with specific focus to reducing the state contingent liability and protecting the interests of the state. A litigation strategy and policies to implementation of the State Attorneys Amendment Act. In order to achieve the desired change within the state legal services environment, the SG has developed a litigation strategy 2021-2026 to position the Office of the Solicitor General as the nerve center of the provision of state legal services. The strategy also deals with policies envisaged in the State Attorneys Amendment Act. 5 policies to implement the State Attorneys Amendment Act have been developed, and 3 of these policies are en route to Parliament for notification, and we will be implementing soon, namely State Litigation Management Policy, the Mediation Policy, and State Legal Representation Policy were presented to Cabinet for endorsements, while the remaining 2 ones, namely Initiating and Defending of Matters Policy and the Briefing and Outsourcing of Legal Work, have been submitted to the Presidency for Socio-Economic Impact Analysis System. They will immediately thereafter also be referred to Cabinet for endorsement. The aforementioned policy seeks to redress the imbalances of the past, transform the legal services, and establish uniform procedures in the Office of the State Attorney. These policies also seek to transform the legal profession by promoting consistency in respect of the appointment of the previously disadvantaged legal practitioners, and they will operate as a transitional mechanisms while the State Attorneys Act is further reviewed and decided to be amended or repealed in its entirety. The Solicitor General has succeeded in filling 6 positions of the 11 vacant positions of head of state attorneys positions, and some of these positions have been vacant since 2012. The remaining 5 positions are in the process of being filled. I know these remaining ones are a headache for the President of NADEL. However, it is worth mentioning that the interviews for the offices of the State Attorney East London were conducted and there was no suitable candidate identified. There is process to redo the interviews and also for Mtata so that these positions are also filled. The Human Resource Unit within the Department of Justice and Constitutional Development is currently conducting a benchmarking process for the Kimberley and the Toyando office for the creation of the Chief Director positions in these offices, which were before the implementation of the State Attorneys Amendment Act, headed by the Deputy State Attorneys. The filling of 6 positions of heads of offices brought the number of permanently appointed heads to 8. This includes the process in PE. To ensure adequate implementation of the OSG's mandate, the SG has, since his appointment, fostered closer relations with different organs of state, including the National School of Governance, the Legal Practice Council, Legal Aid South Africa, the Legal Sector Code Steering Committee, the judiciary, and private legal practitioners. There has been engagement meetings with the legal profession in 7 provinces. The OSG has already convened webinars under the State Litigation and Consumption of State Legal Services with the national, provincial, and local government, as well as state-owned enterprises. The OSG remains committed to the transformation of state legal services and empowerment of PDIs. The Constitution places a critical and moral responsibility on government to create equality of opportunities to private practitioners as well. In order to respond to this constitutional imperative, the OSG has already finalized the briefing and outsourcing of legal work policies in line with Section 3.4 of the State Attorneys Amendment Act. The overarching aim of this policy is to develop legal skill through equitable outsourcing of legal work, including specialized fields. In a nutshell, the policy is primarily intended to empowering PDIs to also increase the number of black lawyers briefed, particularly also in specialized fields, and women in particular. The details of the briefing patterns are available in the Department of Justice and Constitutional Development's website. And the records clearly indicate that for the past years, the offices of the state attorney were measured in terms of the transformation of the PDIs, advocates, more specifically female legal practitioners. There have been measures on the following empowerment tools: the total number of briefs issued and the number of briefs issued to PDIs, percentages of value of briefs allocated to PDIs, percentage of brief allocated to female legal practitioners, and percentage of value of brief allocated to brief attorneys is underway. Due to the various challenges raised regarding the procurement of state legal services and non-compliance with Section 217 of the Constitution, the Office of the State Attorney is in the process of developing a new, unique process for the procurement of state legal services, given the unique nature of the services that are provided by lawyers. It's not the same as procuring a bread when you procure the service of a lawyer. So this is a discussion we are having with the National Treasury, because we are currently forced to follow the three quotation system, which is not practical for legal practitioners. In addition to that, which I have just mentioned, I'm proud to say we're on the cusp of a new era in the legal profession. Program Director, although the democratic dispensation has championed broad-based black economic empowerment to address the imbalances created by the apartheid laws, policies, and practices to promote social political equality and participation in the economy of the country, members of the legal profession do not have a sector code to guide them to address imbalances and inequality within the legal profession. The legal profession has to be reliant on generic codes. By their nature, the codes have overly broadly and as such have not been able to address the unique nature of the legal profession as a sector in the economy. As I've said on many occasions, government alone cannot transform the legal profession. It requires the collective buying of government and the private sector to ensure that the legal profession thrives in a manner which does not entrench existing privileges, which are patriarchal and white supremacist in nature. To this end, together with the Legal Practice Council, we can say that the legal sector code, which is imminent, will help us transform the legal sector to give effect to the objective of the Constitution of promoting effective and sustainable economic participation by Black practitioners in the economy of the Republic of South Africa in general and in the legal profession in particular. The legal sector code is awaiting gazetting from DTI. The code will also create a legal sector council that will, for the first time, monitor compliance with the code. The issue of transformation will be monitored through this platform. For the first time, you'll be able to track briefing patterns in local government, in the private sector, in the state-owned enterprises, and all sectors of society. I hope that this AGM will also find ways of how, as an organization, NADEL would participate to track, monitor, and ensure the implementation of the code. The council will be there to ensure that the code is monitored and it is also implemented. Because we have realized that to have codes and charter alone without any monitoring mechanism or structure, it's hollow, it does not achieve the intended outcomes. But we also have to ensure that the council that we are going to have will have enough zeal and teeth that will enable it to ensure compliance with the codes across all sectors of the economy, particularly the private sector. It is gone are the days where it must only be the Department of Justice that outlines how many people it has briefed, for what, for how much, and for who are those people. All sectors of the economy will, for now, when the code is gazetted, will have to comply. They will have to disclose the briefing patterns. And I believe this is an important weapon that members of the legal profession can be able to use to ensure that there is transformation. You will now no longer be thumbsucking the numbers of the briefings, whether it is true or not. You will have it in black and white. And you will be able to engage with the private sector, with government, with local government, or any sector of the economy for that matter, to ensure that transformation and the briefing patterns is no longer just a talking issue, but is an issue of implementation. Along with these changes, we will also be in a position to introduce a transparent acting judges appointment regime once we have concluded the case which was brought against us in Limpopo. We also will be calling on your wisdom as we move to fuse the profession into a single profession, particularly on the question of silk status and other issues related to the profession. Internal processes are still underway. We will in due course share with you policy outline on how we ought to recognize and extend seniority status to all legal practitioners, advocates, or attorneys in the country. I must pause to say, Program Director, in these 2 years, I have learned that with lawyers, you will need to test the water while you cross the river. Whether there's a crocodile inside the water, or whether there's a snake, or the water is safe, or the river is safe to cross. If you are going to want to wait for signal from lawyers that the river is now safe to cross, I have learned that it will never happen. All the policies I have outlined have been debated endlessly in all the structures of the LPC, including the legal sector code, which I believe is an important instrument. It cannot be a product where there is an unending debate on its implementation. The silk is also subjected to the same issue, and the guidelines on acting appointments for judges are also subjected to the same kind of discussions. But I have taken a posture that says that when I believe there has been sufficient consultation, we should cross the river and test the water while we're crossing the river, whether there is a crocodile or not. And we intend to implement the legal sector code before the end of this year, particularly if DTI can proceed to gazette. We will commence with implementation without delay. As we continue to navigate disruptions spurred by the pandemic, we are also recognizing the need for fundamental lasting change. The only test now is whether we'll seize new opportunities or safeguard against threats. Shifts in operations and mindsets are crucial to a successful transformation. Transformation of the profession cannot be viewed outside of the context of societal transformation. Our definition of transformation cannot be narrow and generic. In essence, it is not only about black and white, it is a lot more nuanced than that. Our debates and approaches to transformation must also extend to protecting the profession. Otherwise, sooner or later, we will run the risk of waking up to work in a profession that has been obliterated by the digital revolution and societal changes. I've once read somewhere in an article that there is now a lobola contract that you can buy from ShopRite. These are some of the examples of encroachment into the profession. There is no risk to anyone when someone just gets into ShopRite and buy a lobola contract. There's no one who will be held accountable. But yourself, you are held at very high standards. So whatever you discuss in the AGM, we hope that we'll also discuss how we continue to protect the profession, to remain, to help access to justice to society, but to also provide services that are protected, guaranteed by the profession itself. The fourth industrial revolution is here. It is a digital revolution, disrupting daily lives and business, virtually in every industry on a global scale. All professions, including the legal profession, are affected by this disruption. Big data is affecting everything from research to devising strategy or assessing the merits of a legal case. There are already solutions to many data-related challenges, ranging from collecting large amounts of data, as well as technology capable of scanning, interpreting, and synthesizing written documents. This technology is capable of providing better, cleaner, and richer data, which in turn makes it more searchable and allows for the mining of specific insights directly related to a current legal question. Better legal analytics in general means that lawyers are more able to minimize or to mine for results in increasing large sets of data. But what then will happen to the human being? In specific areas of law, analytics can also be used to track broad industry trends related to strategic planning, business development, and mining. It is clear that in the near future, algorithms may be able to sift through heads of arguments and produce a judgment. Legal technology is being used with increasing frequency to improve speed and efficiency in legal processes. Artificial intelligence is now able to significantly reduce both time and cost of a legal work. For example, the use of artificial intelligence in contract analysis, supporting mergers and acquisition processes, or contract remediation to comply with regulatory changes, like data protection legal framework is growing. As the AI market grows, the use of legal services will expand along with it, leading to better legal outcomes and improved results to the bottom line. Legal professionals may also increase reliance on AI-powered digital assistants, which will grow smarter as they process more information. This will free legal professionals to focus on higher value-added legal services to clients. But how do we ensure that this is protected and it is still giving value to clients' money, or it still gives the highest service of standard in terms of the services that is provided to clients? From adapting to technological advancement as a profession to leading the charge from a policy perspective, the profession must be leader amongst professions. I have no doubt that NADEL will continue to lead in this discourse, and this AGM will find a way of contributing into this inevitable reality of our society. As a Department of Justice, we have recently suffered a ransom attack which will have affected most of our clients in deceased estates, maintenance, and various other services that we provide. We have now been able to restore most of our services across the country, and if there are still challenges, we remain open to be alerted to the challenges in our various courts and jurisdictions. But the issue of the cyber attack has also taught us that all of us in society have to stand firm, have to stand guard, and also have to prepare ourselves while we enter into this digital revolution to protect ourselves against cyber attack. Because cyber attack is almost the same as any violent attack in society. It's the same as mugging, it's the same as armed robbery. It has the same disruptive tendency as any physical attack when it is meted against the system in our digital platforms. As we transcend into this new world, these are the realities we have to bear with, we have to stand on and respond to, all of us as a collective. And we want to thank NADEL and your members and the profession as a whole for your cooperation during these difficult times that we have gone through as a department under this attack. We know that your clients were insulting you. We were also being insulted and criticized on a day-to-day basis, but we are happy that we have been able to resolve some of the challenges and will continue to do so even today. And even some of the practitioners could not get paid because of this challenge, and some of them really insulted us. But we understood that we are the representative of the people. We have to respond in this challenge and be able to solve the problems. And we're grateful that we've been able, with the collaboration and the cooperation of the various stakeholders that we have, been able to restore the majority of our network. And I'm proud to say most of it is now working. there are isolated incidences and challenges there and there that will get alerted to and will respond to accordingly. I want to wish NADEL fruitful deliberations as we take the profession forward. Thank you very much.
Thank you, Honorable Minister. Indeed, we cannot wait for the implementation of the Legal Sector Code, and we cannot wait to see transformation happening. Thank you so much for making time and joining us despite your busy schedule. I will now open up the floor for questions and answers for the Q&A session. The mics have now been removed from where they were, comrades, so it should not be intimidating.
Is it talking? Okay, thank you so much, Esther.
Okay, don't worry. It's fine, hold it. It's okay. Thank you very much, Minister, for your time. No, I'm closing. Thank you. Thank you very much, Minister. I will now hand over to Lisa.
He's gone. He's gone.
Thank you very much to the Minister. I think it was very insightful to kind of see the process or the progress that we've made within the judiciary and the legal profession. Now we go back to the program. I'm going to then call up Krish to do his part, and then I'm going to ask you to allow me liberties to ask Dali if you would then just do closing remarks after Krish, and then we can open it to the Q&A. Thank you.
I always have to remind myself to stand upright. So if I thank you, Comrade Lizelle. So we can't deal with what the minister said. Okay. Yeah, no, the minister spoke about transformation. He spoke about the state attorneys. I thought we should just clarify a few things, if you'll allow me. You know, when we talk about greetings to our Judge President. Welcome to this meeting, Justice Benenge. And I know our comrade, Judge of the Constitutional Court, Comrade Madlanga, our Judge, and honorable guests and comrades. You know, there's so much to say. In most countries, a Minister of Justice is normally very wise and old and most experienced and provides serious leadership. And they are like second to the president or third after the vice president in seniority. When Madiba was away overseas and the deputy president, the clerk was away, Dalla Omar was the acting president. Those things are on record. And it showed the kind of strength that we had. We have a very good minister at the moment. He's young, he's vibrant, he's got vigor that we talk about as our program says, much vigor. But whether he's able to create a future for our justice system, he needs all our help. But he won't be able to take it. There is no capacity for that, no time for him to listen to us, because he's consumed with the serious crises in the country, fighting fires. And I think he still needs another 10 years of experience in injustice in this country because he's young. So when we talk about transformation, you know, we set
black people up for failure. When you transform the master's office and you put black people in there, and the master's office doesn't work, people say, look at black people can't do the work. State attorney's offices now, not when I was there. I left in 2015 and we were barely holding it steady. And you know what? You go around and you see the chaos. The same thing in the hospitals. Take the judiciary. When the courts are failing, it's not the black judges, but we transform. We tick boxes and push people up there. We are setting our black people for failure. We're setting up our black government for failure. We're making the idea of race and black to be a failure because the system below doesn't support any black person when they are put in the office. That is the reality. And it's widespread. You go and ask a superintendent in our hospital, black superintendent, coming out enthusiastic, wanting to run that office properly. They can't find equipment. There are no sponges and cotton wool. There's shortage of doctors. Everything is broken down. And people are dying in the wards, dying on the way with broken ambulances. When they go, the poor mums giving birth, there's no oxygen in the incubators. And all those medical negligence cases that are costing us at least 20 million rand, that's a summons that goes out against the state. So, when you have that kind of scenario, the state attorney's offices are seen to be a flop, a failure. They can't handle the mistakes that are happening out there in a good, solid, democratic country that is based on all the beautiful things that was set out in our Freedom Charter, that we imbibed and put into our Bill of Rights. And we launched this democracy under Madiba. We had socialists, communists, trade unionists in the first cabinet. People who knew what it meant to save water, to get workers' rights. But after the first cabinet ended, you're going to look at the kind of leadership that was brought in, and all those communists, socialists, trade unions were fired. We moved to neoliberalism. And everything that our Thomas Sankara of today, Brian Kagoro, spoke, is what we are facing. We are facing a situation where our bourgeois democratic society cannot sustain the excellent high level of socio-economic rights that we demand for all of us, for our children and grandchildren. But it's not going to come because we don't have the money. There's unemployment, poverty, and of course a global economic crisis. But what's going on? We keep saying, why are the state attorneys not doing the work? The minister is focusing on the state attorneys. Every single delict that is committed by a civil servant, policeman, doctor, transport, whatever it happens, it translates into litigation. So if you want to stop litigation, if you want a good constitutional democracy that is working properly in the courts, you prevent the litigation. You go down and you fix it up down there. So you fix up the hospitals. You won't have medical negligence issues. You tell the policeman, you dare slap a person, you will go to jail first. We don't have the systems to police the policeman. The state attorney's offices are inundated now with claims against the state, you name it. When I was there for 17 years, I just saw the rise. They started with social grants. 10,000 cases a month used to hit us in the Durban office. We bottled it up, clamped it up, all our resources were used. Why? Because poor grandmothers were not getting their social grants. The proof is your age. But the systems all around the departments could not cater for the new demands of our people. So, smart, clever lawyers who saw the way to make money. So I'm not blaming our government. We have smart lawyers. They made tens of millions of rands. We were paying them out of the state attorney's offices. There were about 12 of them. I had them named, listed. I even gave those names to the receiver of revenue. I said, do an audit on these people, because you will know they're swiping half of the money and it's not going into tax. Forget that. They didn't even bother about that. But this is how lawyers move. When we shut down, finally, and with the greatest assistance of Judge Malcolm Wallace when he was in Durban, he's now in the SCA. He did so many things to fix it up. Right. I'm going to finish in 5 minutes. Forget the Legal Practice Council and the Act, because that's like peanuts compared to the national crisis. When we shut down the social grants, some of those lawyers picked up in the Eastern Cape. Since we shut them down, and you must read the case of Kele and others versus the Minister of Welfare, there's 3 of them which talked about structural interdicts that were brought to shut down these lawyers from bringing 1,000 cases repetitive. Instead of a class action type, they made 10,000 rands per case, whereas you could have finished it in 1 case. But anyway, Wallace fixed that up. They moved to Home Affairs and all the ID documents. We shut that down. Then they moved to medical negligence. By the year 2002, medical negligence was gone sky high. We're in 2021, and medical negligence is still a big thing. Then they also moved into the police services. I mean, it was so crazy. They would have their connections in the police station, policemen, who would initiate action against the local community, and then there will be cases for unlawful arrest over a silly thing of putting the person, instead of keeping them in the charge office, they would lock them up in a cell. And clever lawyers working within the system were able to hit us with about, tens to hundreds and then thousands of these cases, which are still going on now. So what does it say? Our constitutional democracy with beautiful rights is set up for failure. And transformation is like a preoccupation. Transformation doesn't solve anything if you don't fix up the socio-economic problems on the ground. So when they ask us as a NADEL to help them out and the minister, we meet with the minister. I've dished this thing out to every minister of justice after Dalla had gone. They meet us once a year as state attorneys. You never see them again. And you recycle to the next minister who starts from scratch, trying to understand what is going on in the Justice Department. So, we need a revolution. And let me just tell you one thing. This thing about national democratic revolution, those are the kind of misnomers that every president talks about it. There wasn't a national democratic revolution. The revolution ended, or the process of revolution ended when we started negotiations. Everyone put their arms down and the revolution stopped, the process. So we negotiated. We negotiated a national transition to a democracy, not a revolution. A revolution means that we would have taken over the land and we would have taken over the economy. And we're still talking about how to do that today. So our revolution is still going on. That's why we say a luta continua. We're still fighting for those things. But we bluff ourselves, ministers and president says, our national democratic revolution was achieved in 1994. Now we are going to go for socio-economic rights, for the economic revolution. Revolution is a dream. We're still fighting the revolution. And the true revolution is to try to win back control of our economy in such a way that we can address the rights of the people of this country. And we are completely behind that process by about 20 years. And it's gone worse. Not because of the failures of our government totally, partly because of the global breakdown and the global crisis. But I'll stop there. But I want to just say the future of the LPC is in good hands for the next 3 years. We stumbled in the past 3 years, fixed up a lot of things. Janine fixed up, listed the 12 odd things that were done in the past 3 years. I counted it, Janine. And I know you're going to do a far better job taking it further because we were fighting ideological battles in the past 3 years. We were voting on ridiculous things and losing on important questions. We failed to address economic issues because the LPC and the LPA is only about regulatory issues. It's nothing about vision. The vision of what is required for you and I to survive as lawyers comes from NADEL, from equality and justice that we talk about, and about how to give the vision and to provide leadership from amongst our members to structures like the LPC. But as Dali pointed out, the system of elections to the LPC is skewed. Because if you have, and I'm not a racist, but if you have a white legal profession dominated, white dominated, and you have elections in a black majority country where whites are a small number, you are going to have a tectonic earthquake. Because the majority, you take the 5 to 10 big white firms in this country on pure one person, one vote, they can determine the future of the LPC as it has been demonstrated in the last election. With due respect to Janine, she's an exception. She fought and came through under the old election. But we are heading for disaster. Now you have to sit down and explain those numbers to our young Minister of Justice. I'm sorry, you'll be wasting your time. You'll need a lot of time with him. Thank you.
Krish is clearly passionate about seeing real transformation within the legal profession. Chris, the issues are serious. The issues are serious, and you paint the picture well. So let's have the debate. There is, as pointed out by Nolita, 2 mics. The first one is on this side, and the second one is on that. I'm going to be taking 3 questions at a time, and then I'll allow our speakers to respond, and then we'll take the next set. And I think we can cover the Q&A within 3 sets. Your hand is noted, your hand is noted, and your hand is noted. In that order, please. There's no roaming mics, unfortunately. We have an agreement, or we had a pre-discussion, so.
I'd like to comment specifically what Advocate Wolfram mentioned. He mentioned that there was the failures of the Legal Practice Council. And I'm sure, as Chris has alluded to, and I will be the first one to admit there are many challenges that we need to address within the Legal Practice Council, and we do intend to address it. Advocate Mpofu mentioned barriers to the admission of the profession, fusion, 2 exams, and the disciplinary process, and the captured by conservative elements in the leadership. I'd first like to address him on the issue of fusion. I don't know if you're aware, Advocate Mpofu, we are currently having 1 exams for pupils and attorneys, candidate attorneys, to ensure that they are on the same level so that we are moving closer to fusion. Regarding the fact of 2 exams, there's only 1 exam to write to be admitted for the LPC. Voluntary organizations have said that they have an additional exam should you want to belong to the voluntary organization. Barriers to admission, there are many. We have, however, removed, which I think was a major achievement for the LPC, that when you want to appoint a candidate attorney, you are no longer allowed to advertise that the candidate attorney must have a vehicle or that the candidate attorney must have a license. Once again, I say there are many barriers, but we are chopping away bit by bit. As in my address earlier, I also addressed the issue of the exam results, so that is also assisting with removing barriers. We've, as the new Legal Practice Council, who had its first meeting on Saturday, had accredited much more organizations to do the training, to assist with admission to the profession. We have also ensured that this admission or the accreditation is for 3 years and not 1 year as it has been before, to assist with admission to the profession. I just want to see what else he mentioned. The disciplinary process, which is rather cumbersome. We agree with him. I agree with him. I raised it in my address earlier. We are currently having to follow the Act, and we, as I've mentioned, we will be looking at that. Regarding the captured by conservative members in the leadership, the LPC has literally had 1 meeting. In that 1 meeting, that was on Saturday, in that 1 meeting, we accredited many more training organizations that we've done. We extended the accreditation period. We've addressed, or we are in the process of addressing, the communication system, the telephone system. I've mentioned the disciplinary committee. We've established a task team to look at the matters of admission of foreign nationals. We've established a task team to look at the RAF. So I will not debate that issue, but I will leave it, as I said earlier, the proof is in the pudding, and I don't think you can judge us within 1 week. Thank you.
Thank you very much, Chair. Chair, I wish to address myself to the submissions, particularly by Comrade Krish. They were too political, and I'm so interested. I wish to venture myself there, particularly on the question of access to the law schools versus the fees and so forth. Chair, the Legal Practice Act is saying that in order for you to be admitted, you must have complied with the provisions. I think it's in section 24, 25, 26. That deals with PLT, and further they go to talk about the practice management training. But it's not put as PMT, it's management training. I think it's something like that. Chair, here is my submission. Here is a student who is coming from Bizana, who was enrolled with LLB, is coming from a disadvantaged background, supported by NSFAS for 4 years, doing LLB. Now is expected to go and enroll for PLT at 17,500 fees. This particular student is coming from a single parent background, who is a social grant recipient. Now, to me, I want to make submissions that this thing needs to be addressed. It must not be a requirement. If it's a requirement, we must try to, or the leadership in the LPC and NADEL and whosoever in the profession, must try to make it a point that in the process of dealing with the access to the profession, we must be able to provide and seek ways of funding that particular program. Because this person was starting for free in a way, the entire LLB, but now all of a sudden, without being employed anywhere, he's expected to go and pay fees, 17,500 for PLT. And beyond that, there is also the PMT. And when those candidate legal practitioners seek employment or for articles or PVT, they will be asked by the principals that, did you go to law school? The same law school that is expensive. So I want to submit that this is an issue that I see it as a bottlenecking or gatekeeping in the profession. And if we're talking about access to the profession, we need to deal with it, because those who are coming from poor background are unable to access the profession because of that particular reason. As I sit down, Chair, I wish, Chairperson of the LPC, that there is also an issue that we are not very comfortable as young lawyers in the Legal Practice Act, particularly that the legal candidate practitioners who want to be advocates will be granted a right of appearance. And then those who want to practice as attorneys will be told to wait for 3 years. That is causing controversy. We are not happy with that, because these people has undergone the same training. They went to study the same courses in the PLT. Now, all of a sudden, when they are to practice, there will be segregation and oppression of those who want to be attorneys. They will be told to wait for 3 years. But those who want to practice as advocates, they will be allowed to appear immediately. So I think we are not comfortable with that, and we wish that can be addressed as soon as practically possible. In particular, coining it with the fusion you were trying to explain here of the examinations for the PVT. One last issue, Chair. Comrade Krish, I want to agree with some of your sentiments, particularly when we were speaking about the National Democratic Revolution and the national transition itself to the true democracy. But as lawyers for human rights, we have a duty to protect the community, particularly when police are misbehaving. You know, some of the cases, they are very interesting. You will find a person being arrested because he had a quarrel with a friend of a policeman. So this policeman wants to show that you can't do that to my friend. Let me arrest you. Or they are looking for me. They find it for my brother. They take my brother. Those things are happening here in rural areas. And we can't then thereof allow police to do that. We must sue them. And I hope even the justices who are in our midst will grant us these orders. Because police, they have this tendency of wanting to be brutal to the poor of the poorest. Particularly when they see you that you are vulnerable. They like doing that. Even on the road, why are you not opening the space for the police van? You try to answer, they assault you. So these things are reality. You go to our hospitals, I'm pretty sure those who are coming from the Eastern Cape, in Amtata, this time now is quarter past 3. There are people who arrived last night in the casualty ward. I'm sure they have still not been attended by the doctors until now. So as lawyers for human rights, we need to make it a point that we put government into task. If government do not want to pay these big monies, these exorbitant fees that we want for medical negligence and so forth, they must be able to provide with adequate facilities. For instance, the Walter Sisulu University is producing many doctors every year, but there is no improvement. So we have to put government into task. Thank you very much. maybe just some housekeeping rules. The first one is, please introduce yourself when you ask the question. And the second one is, can we limit it to one question? But I would like to thank Janine for the response and Tia for his opening remarks. If we then can do the third person that I'd initially acknowledged.
Thank you so much, but I'm already covered by both speakers, so I'll just sit down.
Okay, then I'm going to first ask Dali. He's got his microphone with him so he can address you from here. Dali, Janine has now responded to the 3 issues you've raised. And then Krish, Tia says legal education and the fees challenge is a barrier to access. And he also wants you to discuss or at least respond to how we litigate with regards to the community. The other 2 questions for the LPC and the judiciary we're not going to address. Is that okay, Tia? Okay.
Okay. Yes.
Next round. There's going to be 3 rounds. We've just completed the first.
Okay, thank you. Thank you very much, Chair. No, I have nothing much to say. I think I'm glad to hear that there are no problems, if there are no problems. So I don't want to get involved in that kind of ping pong. Yeah. But all I wanted to say really is, that's why I made it clear that I'm speaking from the point of view of literally a legal practitioner on the ground who's watching what is happening. I'm no longer involved in those leadership structures. And what I'm telling you is my own experience and what I've seen, what I've heard, what I've observed, and I even added what has happened to me personally in respect of something which was lodged in February when there's no progress. Where are we now? In December of the year. That's actually what has happened. So where I come from, if you are in the leadership, they say the customer is always right. Thank you.
Thank you. Krish?
Could you help me, Lizelle, just with because the sound feedback is bouncing, it's not easy for us to hear clearly.
So Tia had noted that the fees in relation to further legal education has the potential or does actually cause a barrier to entry for certain people or certain attorneys, etc. Tia?
I take it that it's a financial...
That's it.
A cost issue.
The fees,
okay.
Yes.
Fees.
Yes.
And I want to just ask you to, around about May 2004, I had written an editorial for the Day Rebus when I was on the editorial committee, and it's called The Future of the Black Lawyer After 10 Years of Democracy. Nobody reads a Day Rebus, but you can call it up and you read it. It tells you where we were going in the so-called this transformation. And now, 17 years on, everything is just exponentially gone worse for the black lawyer. So when we talk about fees, if we don't have a creative kind of approach to fix up costing and access to the profession and the impoverishment of black lawyers in general, all the young ones in particular, and wholesale graduation of law students, because of lower standards in the education, 30% pass at matric, and ministers taking the credit every end of the year to say our pass rates are 90%. Ministers had nothing to do with teaching, but that's another story. But we have to think about where the money is within society and the economy. So, in about May 2020, this time I wrote an article which was published in the Day Rebus. Nobody reads it. But it addressed the inequality in society and the Gini coefficient and the inequality in South Africa, which is highest in the world. And when I was on the LPC, nobody agreed with me. And I didn't get a single vote in support, but I wrote this article, and you read it, it's logical, it's brilliant. I'm telling
And he's
you.
humble.
Because I analyzed it properly, and I pointed out that if the rich lawyer in Sandton earns, okay, I'll take a conservative figure, 5 million a year. Okay, that's low. But the poor lawyer down in Dansane were maybe just about able to, no, they end up in debt in terms of the year-end costs. They got bank overdrafts. They're owing everybody money. And maybe a lawyer in Durban, and I'll put an Indian lawyer, will take from the trust money. But if I said it, non-Indian lawyer, I'm a racist. So the clever Indian lawyer in Durban will take money out of the trust money. He'll get caught and get struck off. But it's systemic failure. It's the same thing with the hospitals, police services, you name it. We don't start addressing this. So what did I say? And you think about it. You have to pay, say, 3,000 rands in subscription, it's going up to 4,000. And you are the poor lawyer in Dansane. The rich lawyer in Sandton is earning 5 million a year, and he pays 3,000 or 4,000. Tell me, we are a revolutionary society. We have all of us rights-conscious members of the public out in the streets. From the street sellers to the people hanging out in the taxi rank, they are rights-conscious people. We fought for that culture and made everyone know that, we can get our rights, but we as lawyers, we don't think and enforce these things. So I said to the LPC, we can get enough money to fund all these things, to reduce costs of access for PLT. We'll have a bigger budget, because when you have this Gini coefficient you look at and the rich top numbers, and we got top rich black lawyers too, so don't worry. Dali, don't worry, you don't fall in there. But when you take a proportionate amount, we're not going to skin the top rich white lawyers, but a senior counsel in Sandton probably must be, okay, take Jeremy Gauntlet. If he's earning less than, say, 50 to 100 million a year, that's a lot of money. But if we kept a subscription fee for those earning above 5 million and said you pay 100,000 rands, remember, that lawyer in Sandton, or Jeremy, he goes to London, he goes to New York, he can practice his profession anywhere because he's an accredited lawyer of South Africa. He is part of the membership of the legal profession, the regulatory force that stamps him and says you are a qualified, accredited lawyer. He has that status and he can practice anywhere. And he pays 4,000 rand for that. And he can earn 50 million a year. But our poor black lawyers down the road, and the poor white lawyers too, Jenny knows many, they have to pay the same 4,000. Now, look, Ben, we are supposed to be serious lawyers in the country. Now, you can't talk that kind of language to the Minister of Justice. He doesn't understand it. I wrote that article. And when it came to the LPC, I argued there, you can get enough money to fund us. We won't be in debt. Nobody voted for me for that. Not one, including NADEL members. Now, I'm just saying, go and look at that article, and it will tell you where we're going. Now, one more bad news for all of you. There's another issue that's hitting us. That's called indemnity insurance. It's coming. We blocked it for 2 years. And a few of us managed to convince everybody that this is wrong. Now take this logic. If you want to insure your car, you go down the road, You will say, look, I am 30 years old, I've got more than 5 years of driving experience, I've got no criminal conviction, I'm a good driver, and my premium, you can bring it down for me to the lowest levels maybe. The older you are, probably, the better record, you'll be paying less. The drunken element, the person who's just qualified, high risk, their premium will be higher. It's got nothing to do with race, please. So, that is the industry all over the world. But because we have an incestuous relationship between the Fidelity Fund and the Indemnity Fund, they gave rise to the other. It's not an independent insurance company that's competing for your business and goodwill. They are funding each other, and the Fidelity Fund needs 50 million to fund the indemnity insurance. They used to take it out of the Fidelity Fund, but now they're balancing books. We got a new legal practice council, this, that. You guys must pay. Now, sure, you need to be covered for the first 1 or 2 million for negligence. We're talking about negligence issues here. But everybody has been told, and it's a one-shoe-fits-all, that you're going to all pay the same insurance, same premium. Everybody was going to pay 600 rands a month, and then it's going to go to 800, and it's all set out in their charts. Now, you just think about this, and you see how unfair and illogical it is when you have to be paying the same amount, and listen to this carefully. 514 million rands is the loss that they sustained, according to the latest figures from the Law Society of South Africa, barely a few weeks ago. And this information, the Fidelity Fund official will give it to you. Of that 514, 410 or so million comes from road accident fund. Conveyancing is 240 million losses. This is not contingency, this is actual payouts. And the third one is estates. Now you just try and think and swallow this. 80% of the 514 loss comes from 3 areas of practice. Now I go to my comrade in Dansane who's doing criminal work. There is no negligent liability you'll come across in criminal work, but that person has got to pay the same premium as the rich conveyancers who are making pots of money. And you all are going to be asked to pay that same premium across the board. So when we started asking these, they don't like me. There's that one person in the LPIIF, and I almost came to blows because I exposed the illogic, the unjust nature of what they were doing. And they've been delaying, and they're holding the LPC to ransom. The LPC is battling to argue its case. But this is where we are as lawyers. Think about the system, how it eats into us in an unjust manner. We fight, that's what NADEL is about, equality and justice. Our LPA and LPC can only do so much, but they're only regulators. They've got no vision because that's not their job. They just got to regulate you. But we are the ones who've got to get into the LPC and talk the language, because then we can control that LPC. If it's our people who fight for justice. But then you look at the end result. You have a dominated white profession that can determine the context of the LPC. And the last point I want to make is that they work with billable hours. They will have to charge 10,000 a month, for an hour, but then they will say that no, it's got to be $10,000 here in South Africa, because that's the same rate in New York. I mean, there's a lot of funny things that you're going to work out, and we are going to have systemic inequality going worse and worse, and the Gini coefficient is going to go out of the roof.
Thank you. Okay. Because Krish has answered several questions that weren't even asked, we can only take one burning question for Dali, and it's got to be very short because we are way past our time. I know that, is that the burning question for Dali? A very short one, or I'm going to have to stop you. Okay, and that's going to be unfortunately the last question. There will be a compromise later during tea time. We will make sure that Krish and Dali sit around the table so that you can engage them.
Yeah,
Go ahead.
Chair, I think this is important to put for the record. It's just a straightforward comment. Dali raised very critical issues as well as Krish. The first one, I'm saying to the LPC, we need one vocational training for both advocate and attorneys. This whole thing about private and voluntary association forcing people to sit for 2 exams, it's nonsense, and I think it's high time that the LPC, if there's anything that the LPC should be exercising authority on, is this one. The second issue, the dominance by big firms in the voting process, I think it's correct that perhaps the way this whole thing of voting for the LPC was conceptualized is flawed. And I am saying, I'm challenging all of us here that we need to revisit that and come up with concrete proposals to make sure that that system changes, because it only favors the most of the big firms that are based in Sandton. So that needs to change. Finally, there's the issue of delegation of authority to LPCs. I'm told, and this is referred to the LPC, Comrade Janine Maybeck. We are told that authority has been delegated to provinces, but is not effective. And I think that needs to be revisited so that provinces begin to have proper authority to deal with a lot of issues that are facing the profession. Thank you.
Dali, is there anything you think you need to... Okay.
Yes, yeah.
Dali, I don't want to put you under pressure, but 2 minutes.
Oh, really? Okay.
You can thank Krish.
The chair has found her. All right. No, that's fine. No. I just wanted to, I agree obviously with what Kuala is saying, but that's why I was sarcastically saying that I'm happy if there are no problems. I think they're very serious, deep-seated problems. And those problems manifested themselves, at least in my experience, even when we were in the National Forum, which was the precursor to the LPC. And one of the most fundamental problems is what Kuala is talking about, which is that from the very beginning, that's why I used the starting point of fusion. From the very beginning, the advocates profession in particular has been maybe resistant is an understatement, hostile to the idea, to these issues that you are raising. And the attitude has always been that, look, this whole LPA thing is just a nuisance. And your approach to it must be try as much as possible to tolerate it because it's a statute, but things must remain exactly as they were before. And unless and until we're able to overcome that and ensure that there are no enclaves of voluntary associations that are going to be self-regulating under this umbrella-ship of the Legal Practice Act, and particularly the advocates profession. That is a sore point because they feel, for whatever reasons, that there was no need for all this, and therefore the attitude is to try and, just as if you do when you're avoiding tax, you must just try and find all the loopholes to ensure that nothing changes. I know this for a fact because I've been, as I say, in the National Forum, but I've also been in the leadership of the Job Society of Advocates, the GCB, and those kinds of structures. And if we want to paper around that issue, that's fine, and say that it's fine, everything is hunky-dory.
But that is the elephant in the room, and if it is not confronted, there will be no transformation.
Thank you very much. I know that, in fact, I must maybe say I'm the lucky one. I got to facilitate two distinguished gentlemen who tend to be passionate and controversial, who incite lots of conversation. I just want to be respectful to the program and to the other participants who are supposed to join. So please forgive me when I cut this short. It's only because there is other participants who have been waiting for their slot. We're going to break for a 10-minute tea break, and that's the compromise that the SG has given me so that you can corner these two gentlemen over tea. We will be back. What's the time now? It's 15:33, so we'll be back at 15:45. See you in the room, and then we'll continue with the program. Thank you very much.
I thought one of the questions was, what do you think about I see this but
Colleagues, comrades, could the driver of JRW 754EC please go to your vehicle? It's quite urgent. The driver of JRW 754EC.
Comrade, must I reconvene? Good afternoon, ladies and gentlemen. May we please reconvene? We are starting, ladies and gentlemen, we are starting. Ke romile makhangela, but it seems antirele mmereko. Okay. We are starting, ladies and gentlemen. We are starting.
It makes my life really hard if they're far apart.
Okay. Okay. I won't change them. Ladies, in this session, we're going to have a dialogue for the structural impediments to access to justice. We are starting. Joining I beg your pardon, colleagues, comrades. In this topic, we're going to deal with law as a business that must be sensitive to public interest, international best practices. Joining us virtually, we're going to have our speaker. Her name is Jean Myra. She's the president of the International Association for Democratic Lawyers. Jean Myra is a 1971 graduate of Boston University School of Law. She has almost half a century of work for progressive legal change in the United States, working to promote human rights throughout the United States and internationally. Jean is the president of the International Association of Democratic Lawyers, the president of the board of the International Commission for Labor Rights, and a member of the executive committee of the National Lawyers Guide, where she represents the International Committee of the National Lawyers Guide. She has spoken and written a variety of subjects and has devoted her life and work to fight against racism and other forms of oppression. Jean is a partner in the law firm of Myra, Mazzocchi, and Julian in PLLC, which was founded in 2015. She specializes in labor, employment, and civil rights law. She has handled numerous class actions and multi-party actions for victims of discrimination and wage theft. Her clients, various workers' centers, the New York Taxi Workers Alliance, Workers United, and other labor organizations. Ladies and gentlemen, please welcome our guest, Jean Myra.
Thank you, Memory, for that kind introduction. And thank you, NADEL, for inviting me to give a presentation on the important topic of law being a business that must be sensitive to public interest from the perspective of international best practices. Before I begin, I want to mention that 30 years ago, in 1991, I had the honor of attending a conference at the University of the Western Cape, which was sponsored by NADEL and convened by Dullah Omar. Dullah had come to the IADL Congress, the International Association of Democratic Lawyers, or IADL Congress, in Barcelona in 1990, and discussed the changes happening in South Africa and seeking an alliance with IADL. Dullah then traveled to the United States and met with members of the US affiliates of IADL, the National Lawyers Guild, and the National Conference of Black Lawyers. He reciprocated with an invitation for organizations to attend a conference on the new South African Constitution. About 30 people from our organizations attended. At the conference, there were many NADEL leaders who were in the negotiations for the new Constitution. This meeting was transformative, not only because I was able to meet my heroes and sheroes of the anti-apartheid movement, but I saw how the negotiators from the ANC were using many of the rights enshrined in international human rights treaties and principles to make a new constitution truly transformative. I vividly recall some members of the conference from the US saying that because the majority going forward would be from progressive forces, that the provisions in the Constitution did not have to be spelled out too specifically. At that time, the message from our comrades was to tell us words to the effect, we are writing a constitution not for us now as we are now, but for the future, for when we get fat and tired. We want to have future generations uphold the principles for which we fought. Not only was this very inspiring, but I realized for the first time how important international treaties and norms are for informing legal work we do. This is because the rights and duties stated in treaties like the United Nations Charter, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights, which themselves arise from the Universal Declaration of Human Rights, as well as the ILO conventions, did not arise because they are just good ideas, but they came out of people's struggles against fascism, racism, sexism, and imperialism. These principles now form a legal structure for people's movements to fight back against neoliberal corporate-dominated efforts to make people's movements feel they have no power to stop the growing inequalities within and between states. And now these principles are needed even more to protect the public interest against the growing concentration of wealth in fewer and fewer hands. Nonetheless, in the short time I have with you, I want to talk about 4 topics which I believe the public interest requires lawyers to take action, and where international law principles, many of which are enshrined in the South African Constitution, are critical to know and use. The topics I will cover are affirmative action, illicit outflows of resources to tax havens, environmental issues, and labor rights. In particular, I hope that NADEL lawyers can play a positive role in healing the wounds of the 2012 Marikana massacre. These topics I have selected are a result of discussions I've had with NADEL leaders who are members of the IADEL Bureau, most notably Max Bokwana. Let me talk now for a few minutes about affirmative action. At the conference that I mentioned in 1991, I provided a paper on the experience civil rights lawyers had in the US trying to defend the concept of affirmative action. And given that the opponents claimed affirmative action was illegal under the Equal Protection Clause of the 14th Amendment, which is one of the post-US Civil War constitutional amendments. And they were claiming that the Equal Protection Clause is colorblind. Proponents of affirmative action argued that the 14th Amendment could not be read out of the context of the Civil War over slavery, and that if read in conjunction with the 13th Amendment's abolition of slavery, such that the 13th and 14th Amendments together required affirmative steps for the US to overcome the legacies of slavery, including what we called the badges and indicia of slavery. I assume I joined the majority of those negotiating the Constitution and stated that I thought it was important for affirmative action to be in the Constitution itself and not open to interpretation or being interpreted out of the laws. I recently read an article from Professor Penny Williams, who talked about affirmative action in South Africa, and it was the title of her article is Affirmative Action in South Africa, Transformation or Tokenism. She says the apartheid government's racial allocation of resources on education, health, welfare, housing, and many other areas enshrined that Black people were locked into a spiral of dispossession, dislocation, and poverty, alienation, and deprivation. Apartheid's particularly Kafkaesque system not only racialized the availability of resources through government spending, but a labyrinth of laws and policies ensured that Black South Africans' access to resources through employment, access to property, or other private economic activity were severely circumscribed. Laws and policies which regulated movement of Black labor, access to housing, with its deleterious impact on family life, cemented the economic inferiority of South Africans. This legacy rendered it essential that socioeconomic rights could not be ignored in the new constitutional dispensation. The drafters of both the transitional and final constitution, and particularly representatives of the ANC, ensured the inclusion of socioeconomic rights as fully justiciable in the Bill of Rights. And it is this context that affirmative action is located as a meaningful mechanism to transform not only the political status quo, but the socioeconomic edifice as well. There are, of course, problems with all affirmative action programs, and most often there is criticism that the only beneficiaries are Black elites who will grow to be part of the power structure that continues in place the structural institutional inequalities, but puts more racially integrated face on those protecting the status quo. In my opinion, the purpose of affirmative action is to be transformative in society and to end aspects of segregation which have fostered white supremacist belief systems over the years. As time has gone by, there is a tendency to view discrimination as a search for individual villains and victims of racist or sexist attitudes, and to exclude from the equation the fact that attitudes and bias are societal and institutional and not merely individual. This understanding is stated in the provisions of the International Covenant on the Elimination of Racial Discrimination. The Convention on the Elimination of All Forms of Racial Discrimination, where affirmative action is recognized as a necessary transformational tool, and which states actions taken pursuant to affirmative action programs are not a form of racial discrimination. The important point is that affirmative action in South Africa Constitution was not meant to lead to tokenism, but as the Constitution itself is transformative, and in this regard, so must affirmative action. Placing affirmative action in the context of economic social rights, such as education, jobs, healthcare, housing, and other rights which promote human dignity, leads to the next topic of my talk, which can be done as a worldwide, can be seen as a worldwide phenomenon of tax avoidance by corporations, many of them multinationals, which result in illicit capital outflows to tax havens where private companies profit, but the countries from which wealth is extracted are shortchanged and deprived of the resources to meet the needs of the people. In this regard, the International Covenant on Economic, Social, and Cultural Rights is critical. The covenant, which South Africa has ratified, should be given full force of domestic law under the South African Constitution, Article 231. This covenant has two related provisions which require all state parties to devote maximum available resources with the view to progressively realize the rights contained in the covenant. These rights must be exercised without discrimination, which includes discrimination on the basis of race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. I believe a good argument can be made if corporations violate tax laws or engage in tax avoidance schemes, which allow millions or billions of dollars or rand to flow out of the country in illicit capital flows, that these companies are illegally denying the government of the available resources with which the government has to progressively realize the rights contained in the International Covenant contained in both the International Covenant and also which are in the South African Constitution. The ability of the government of South Africa to progressively and consistently with affirmative action requirements to provide education, jobs, housing, healthy environment, and medical care, to name a few, are linked to stopping or prohibiting illicit capital flows out of the country to tax havens through violations of tax laws or through tax avoidance schemes. The Business and Human Rights Resource Center has made this point by referring to tax avoidance as the missing link in business and human rights. They have noted that many companies which are highly regarded for social responsibility are involved in large-scale tax evasion. Many NGOs have made the same point about the failure of corporations to pay their fair share of taxes and the inability of countries to provide basic services necessary for the people. It has been repeatedly reported that the Global South countries lose much more money to tax evasion and illicit financial flows than they receive in international aid. By some estimates, countries lose 3 times more to tax havens than they receive in aid. Others say shifting profits to jurisdictions where taxes are lower or non-existent rob developing countries of $4.7 trillion, which is nearly 6 times the amount of official government assistance they received during the same period. In 2011, the Human Rights Council of the United Nations unanimously adopted the UN Guiding Principles on Business and Human Rights. These principles were endorsed and supported by businesses around the world. The UN General Principles set out a global standard of expected conduct for all business enterprises, wherever they operate. These include business enterprises having responsibility to respect human rights also in their business relations, which requires them, A, to avoid causing or contributing to adverse human rights impacts throughout their own activities and address such impacts when they occur. And B, seeking to prevent or mitigate adverse human rights impacts that are directly linked to their operations, products, services, or services by their business relationships, even if they not contributed to those, if they have not contributed to those impacts. UN guiding principles are the type of international law principles lawyers serving the public interest should know, and I would argue many of the provisions have been developing over the years and which were adopted unanimously by the Human Rights Council should have the status of customary law, and the South African Constitution makes customary international law binding unless it is inconsistent with the Constitution or an act of Parliament. That's in Section 232. And Section 233 of the Constitution requires the courts interpreting legislation to prefer any reasonable interpretation that is consistent with international law over any alternative interpretation inconsistent with international law. This brings me to the issue of the environment. Kumi Naidoo, former executive director of Greenpeace International, and now the global ambassador for Africa's Rising for Justice, Peace, and Dignity, said at the IADL Congress in 2014, and I'm sure he said it elsewhere, you cannot have human rights on a dead planet. The issue of the environment and countries' abilities to address climate change and are quintessentially international issues which affect the public interest. While the South African Constitution has one of the most transformative environmental protection provisions in support of people's right to an environment that does not cause harm to health or the well-being of people, and is forward-looking to future generations. Unfortunately, in keeping with the corporate approach to socialize risk and privatize profit in South Africa as elsewhere, despite environmental laws, many are not enforced, and the ability to get those responsible to bear the cost of remediation is difficult. It is likely that the government cannot afford to enforce these laws because of illicit capital outflows. The problem is especially acute in the mining sector, which in 2020 accounted for 8.2% of South Africa's GDP, with over 450,000 people employed in the sector. Recent reports have noted the pollution in South Africa's precious water resources occurs on a particularly egregious scale in areas with high levels of mining activity. The mining of coal, and particularly harmful with acid mine drainage from coal mines, polluting surface and groundwater with acid, salts, and metals. Environmental groups have raised awareness of premature deaths caused by power plant pollution, and a new study found that massive failures by the Department of Water and Sanitation to effectively regulate water licenses are the cause. Some of the companies include Glencore, Anglo American, and South 32. A 2016 investigation by Harvard Law School found South Africa had failed to protect residents had failed to protect residents from the pollution from contaminated water and mine dumps from gold mines around Johannesburg. Public interest lawyers have an obligation to future generations to address the environment in looking at environmental cases that should look to best international practices to address the failures which have come from the mining industry flexing its muscles and forcing citizens to pay the bill for through their taxes to pay the bill for cleanups. The application of conventions, covenants, and recommendations in international deliberations and even tribunals have led to a growing jurisprudence of human rights principles and remedies in environmental disasters, and legislatures and judges should consider as authoritative for their own analysis and references. One key example of this jurisprudence in this drastic time of climate change, privatization, industrial disaster is the Compendium of Human Rights Principles recently published by the UN Human Rights Council and its Special Rapporteur on the Environment, Professor John Knox of Wake Forest University. Professor Knox provided this commission, he provided a framework for human rights and the environment, which states the interdependence of human rights and the environment is an idea whose time has come. The framework explains existing, not new responsibilities ranging from providing vital information on environmental risks caused by industry to identifying and assessing any actual or potential adverse human rights impacts which corporations may be involved either through their own activities or as a result of their business relationships. Beyond these international instruments, there are corporate international instruments, and companies voluntarily bind themselves under the guise of corporate social responsibility or to secure loans from the World Bank or its commercial subsidiary lending institution, the International Finance Corporation. To avoid undertaking or authorizing actions with environmental impacts that interfere with the full enjoyment of human rights, states should require prior assessment of the possibility of environmental impacts of proposed projects and policies, including the potential effects on the enjoyment of human rights. Some of the framework principles require the development of effective remedies against those whose actions or inactions are causing the pollution and contamination of water, land, and air. Protecting the environment has often come in conflict with the rights of workers, especially workers in environmentally polluting and carbon-producing industries. Workers have a right under the Universal Declaration of Human Rights to adequate standard of living that is worthy of respecting the dignity of all workers. Workers' rights are human rights, and the South African Constitution recognizes the rights of workers to form and join trade unions and to strike. In 2012, there was a massacre at Marikana mines, which resulted in numerous deaths of mine workers who had been on a wildcat strike. The massacre is considered one of the worst massacres in South Africa since Sharpeville. The strike was complicated by the fact that there were different unions claiming to represent the workers at the mines with different political allegiances and espousing different strategies. However, whenever the state intervenes in a strike on behalf of management, the message that is sent to the workers is that your rights are not to be respected, and the threats to profits are more important than workers' rights to a living wage and the ability to use their collective strength of withholding their labor as a way of achieving their demands for such. Regardless of one's views as to who is to blame for the massacre, there is a public interest in resolving and healing the wounds of the Marikana massacre. Principles of international labor law and human rights can be helpful to do this. What is necessary is to determine just compensation for the victims and a just punishment for the offenders. Nonetheless, history has shown that social progress for workers has been achieved through collective effort by leaders with a vision for a better world for all. The South African Constitution is a beacon to the world that is truly the result of a long struggle against the ravages of the apartheid state. IADL believes it is necessary for NADEL and all progressive lawyers around the world to continue to understand that it's through people's struggles that the rights and norms of the International Bill of Rights were enshrined in such international treaties. Unfortunately, these rights have often been dismissed as aspirational goals and not critical aspects of law. Law schools do not even teach the international law or do so in a vacuum. It is for this reason that the IADL is in the process of organizing and launching a new People's Academy of International Law, which will be named for Monique and Roland Vale. Roland was a founder of the IADL in 1946. He passed away this year at the age of 101. We hope NADEL will take part in the courses and seminars of this academy when it is launched, and also to take part in its planning. I want to thank you for the time you've given me, and I hope this message has been, I hope you have enjoyed this time we've been together, and I will take any questions. Thank you.
Thank you so much, Jean. I'm going to be taking questions or comments towards what Jean has said to us. It seems there are no comments, Jean. We appreciate what you have imparted on us. We appreciate the work that you do for the International Association for the Democratic Lawyers. We appreciate you for taking your time to join us and giving us the wisdom that you carry, the wisdom of half a century of work. Thank you so much.
Thank you.
I'll be handing over to my colleague for the next session. In the meantime, we've been joined by our Deputy Secretary of NADEL. She's joined us virtually. Ms. Yugeshni Naika. We've also been joined by the Deputy Minister, Mr. John Jeffries. He's also joining us virtually. We've also been joined by the President of the Supreme Court of Appeal, Madam Maya, who's also joining us virtually. We appreciate them. Our next session, we're going to be having a discussion regarding the analysis of the contingency fees. We'll be joined by Motlatsi Molefe of the LPFF, that is the CEO of the LPFF. Thank you.
Madam. Good afternoon, friends and comrades. I wish to extend my heartfelt gratitude to the President and officials of NADEL for this invitation where I can speak to you about an issue which I do not think one needs to define for you in the first place as practitioners. To talk about contingency fees in isolation from some of what Krish spoke to about earlier, the Gini coefficient in our country, the structural breakdown in some of our institutions, and why people tend to frown upon contingency fees when they actually try to create that the impression lies or the problem lies with lawyers and the usage of contingency fees in a wrong way. is probably the biggest problem that we have to deal with when we talk about contingency fees. In this country, they are regulated by the Contingency Act, in particular Section 2, which will actually tell you precisely that you are entitled as a practitioner to enter into a contingency fee agreement with a client, in terms whereof you will obviously recover nothing should you not succeed in the matter in which you have been given instructions. But should you succeed, you will probably have to receive a success fee that you would have had to negotiate up front with a client in a clear and very simple, reasonable, and understandable manner. Contingency fees are an old story. If you have looked at tort law in America, you will realize that the essence of what you are dealing with is the balance for access to justice between the poor and the rich. It is a question of the balance that you always had to find between labor and capital at the end of the day in the pursuit of their litigation against each other, and even at an individual level. But having said that, the emphasis that people would like to make on contingency fees is the issue of access to justice. Truth be told, though, however much that is true, there are limitations to it. And the limitation is a very simple one that people do not address themselves to. It's the fact that the taking on of a matter on a contingency basis is actually so very dependent on the subjective judgment of the practitioner in relation to the possibility of success in the matter that he is taking on. That primary limitation can never ever be overcome, except where you begin to filter in the structural issues that Krish was talking about, for instance. In this country, the only time that contingency fees suddenly became an issue of discussion was because of structural breakdowns that were to be found in the RAF in particular. People understood that they could take on these matters because the RAF simply did not have the capacity, nor did it look for the capacity to ensure that what lands on its desk is, in fact, a meritorious claim vis-à-vis something that they can farm out and actually take no responsibility and accountability about it, and merely authorize a payment at the doorstep of the court. That is effectively where the problem lies with contingency fees. And that is why, in particular, around the world, in different jurisdictions, it became necessary to legislate in order to regulate contingency fees. Because in essence, what would happen is the fee negotiated without regulation could, in fact, ultimately swallow the entire damages recovered by a client in a contingency arrangement. But having said that, it is also important to bear in mind that with that introduction of the risk being taken over by the practitioner has got to finance the disbursements. The practitioner has got to finance, in instances, for instance, of the RAF, medical legal reports, etc., etc. In our country, that has led to unintended consequences as well. Instead of people talking contingency only, there is now talk of bridging finance running parallel with contingency fees. Now, bridging finance is one of the biggest problems that have landed us with the debate around contingency fees, because practitioners, and we have referred to poor practitioners, would have to go out of their way to borrow money, and most of the time at usurious interest rates in order to finance the litigation they're involved in. Contrary to what one would do as in an ordinary business, that money should actually not even touch the trust account because it is capital. It should run through your business account. But invariably, when these agreements around bridging finance are entered into, you would find at loss that such money should go through the trust account. And when the practitioner cannot account for the repayment of that money, that is the beginning of problems and striking offs and suspensions, etc. I believe, quite very frankly, that your biggest problem as practitioners is not so much the contingency fee issue. It is the abuse thereof that is the problem. If you look at what has happened around the RAF in particular, you will find that in real terms, it is technically insolvent for two reasons. One, abuse that we knew was abuse as practitioners because we knew the RAF did not have capacity to deal with these two things. Two, the regulation of contingency fees by the regulators themselves was never consistent. Simple example, when I think, became CEO of the fund some 10 years or so ago, one of the things that I was confronted with was a claim that related to overreaching. And when I looked at it, it flew directly from contingency fee agreements that were supposed to be in the common law. But interestingly enough, when I had an interview with the practitioner concerned, he indicated that his society had in fact given the green light for them to practice the implementation of contingency fees in the manner that they did, which amounted to overreaching in any event. And I asked on what basis that was done. He said it was done on the basis of an opinion. Sought the opinion only to discover that in fact there was opinion shopping forum. The regulator concerned had actually obtained an opinion that actually said you may not do it in this format except if you follow the statutory requirements of contingency fees. They were not happy with that. They went and got a second opinion, which actually validated a view that they had actually been predisposed towards from the beginning. So all I'm trying to say to you is contingency fees will always be part of this life because of inequalities in our society. Those requiring access to justice will always go to you and ask you for your services, subject to the fact that they pay you if you are successful. But bear in mind that when they do so, it is only you who has the power to decide whether in fact you are going to mislead the individual or tell them the truth about the merits of success in their matters. That's the one side of it, if you are doing it deliberately. On the other hand, it talks to your training as well. If you cannot make a value judgment that is based on the law clearly, you might end up inadvertently advising a client wrongly, but still going and taking the risk of doing the matter on a contingency basis. So it is all in your hands in relation to how you deal with contingency going forward. It is all in your hands in ensuring that you actually decide in the correct way and in a manner that does not place you in peril. Because if you take it on and you lose it, and you've put in a lot of capital in it, you are in fact in peril, unless you have got oodles of money, unless you have got the resources, unless you have got the capital to be able to write off whatever loss that is associated with the loss of that matter in court. So in short, all I'm trying to say to us is we are lawyers, nobody can define contingency fees for us. But we are lawyers and there are two decisions we need to take. If we use contingency, we must be honest and truthful, and we must have the right skills at our disposal to make a value judgment that is correct about the prospects of success in the matter we are getting ourselves involved in with litigation. All it requires is caution, all it requires is skill, and all it requires is honesty. And that is just about that, comrades. Thank you.
Thank you so much. Dr. Motlatsi. I'll only take one question. Dr. Motlatsi asked not to take questions, but I see one hand, which I'm sorry I cannot just reject. Dr. Motlatsi, it's a comment. Thank you.
Afternoon, ladies and gentlemen, comrades. Mine is just a comment. I don't know how many of us are aware that there is a movement towards changing, possibly or effecting changes to the Contingency Fees Act. It has been investigated by the South African Law Reform Commission. We at SAMLA, South African Medico Legal Association, made certain comments. So comments have been accepted. I think there also, besides contingency fee arrangements, there's going to be possible wide effect on changes in the medical legal practice claims in future. But what the Commission has decided and recommended is that contingency fees possibly be treated on a sliding scale depending on the amounts of the awards. So I want to allude, NADEL in particular, to the project 141, paper 154. It was published on the 11th of November, calling for comments to the recommendations that have been made, and the closing date is the 31st of January 2022. In fact, I would like to, and I urge NADEL to perhaps look at that paper and let us make representations. Thank you.
Thank you so much. I'm now handing over to my comrade, Nongogo, for the next session. Thank you very much.
Good afternoon. I would like to acknowledge you, President Ukesi, Justice Madlanga, JP Mbenenge, Justice Maya joining us online, and all the guests and comrades. Mine is to facilitate the, I believe it's the last session today, structural impediments to access to justice. I will invite you, Comrade Max, I'm not sure where you are, to come and join us on stage. I will start by introducing The first speaker who will be joining us online, Ms. Christine Kunda. Christine Kunda, commonly known as CQ, is an attorney and an author. She was an activist in the Black Consciousness movement during the 1970s. She spent 17 years in exile and returned in 1993. She obtained her BA and LLB degree at the University of New South Wales in Sydney, in Australia, in 1981. She set up the law firm Punta Incorporated in 1995, specializing in corporate law. She remained a senior partner until she retired from practice in 2008. She served on the inaugural Legal Practice Council until 31 October 2021. She's currently the CEO of Polosang BE Resolution Services Company, which is a professional consultancy. She has sat on a number of private and public sector boards, including the SABC, where she was deputy chairperson of the board. She has also served on the Old Competition Board as well as the Competition Tribunal, which came thereafter. She is also a writer and has published several books and 2 poetry collections. Her most recent book, titled Why We're Not a Nation, was published in 2016 by Serit Sasichaba. Welcome, CQ.
Thank you. I thought Max was going to be here with me. It looks like I'm alone. Unless he's there physically. Good afternoon, colleagues and comrades. The topic that I was asked to speak on is the impediments to justice. And I thought maybe perhaps we should start by defining what is justice, because typically I think people assume justice means access to the courts. And I think it's a little bit broader than that, because the courts are not the only, or should not be the only venue for settling disputes or for trying to, in the case of South Africa, create justice and reparations for what has happened to us over the last 370 years. I think the Justice Department has introduced, and I'm not a litigation attorney, the alternatives of mediation and other alternative dispute resolution mechanisms. But I think I want to go broader than that. I think we have a number of regulatory bodies in this country that can also deliver justice. South African Human Rights Commission, the Public Protector's Office, the BE Commission. So if we look at justice, it has to include the institutional transformation so that institutions, including the court system, can serve the majority instead of what it has done up to now, including now, serve the minority. And justice is also about finding healing for the majority of the people in this country who have been through the violence of apartheid and colonialism, been subjected to such trauma that we in effect are a broken people. And you cannot talk about justice in the absence of trying to correct that which has been done to us and heal us, because I believe that's the only way that we can heal. So I don't think we talk enough about those steps we need to take. So I think that would be my starting point, that the courts cannot be the only mechanism for delivering justice, whether to the poor people, because often when we talk about access to justice, we think of communities, poor communities who cannot afford that. But in effect, because of the structural inequalities of South Africa, even middle-class black people struggle to access court. So let me just quickly deal with what I consider then, given that broad definition, impediments to access to justice. The first thing is the current institutions of justice, including the courts, may not be the most appropriate way, and certainly the way they're structured, and I'll just try and give my view on how I think that's the problem. The current court system is, we inherited that from our colonial masters, the system. And it is designed to render justice. But if we look at one thing, how expensive it is, Mr. Matlati just talked about contingency. The reason you have to have contingency arrangement is that certain people cannot afford the exorbitant costs. And it's not the court system in itself, but it's us lawyers, those who are still in private practice. It's very expensive to litigate. And, you know, I'm not sure how many people who sit even in this room who are lawyers, if we were to be the litigants or the clients, whether many of us can actually afford to initiate action. So that's a major, major problem in a country where the vast majority of people have been impoverished. They're not poor, they have been impoverished. And so the first thing is the expensiveness. Then there is the cultural matrix within which courts operate. If you look at, for instance, the official language being English, the vast majority of this people in this country do not have English as their first language, as their mother tongue. That becomes a problem. And if people want, so theoretically in the Constitution, all the languages are equal. But in reality, institutionally, whether at universities, in churches, except the independent churches, in the court system, English is that. And English, the minute you speak to someone whose mother tongue is not English, you disempower them. So in the court system, if a client or a litigant or an accused chooses to speak in his mother tongue, then you literally have a court, the translation takes twice the time it takes. Why 27 years later have there not been steps taken to ensure, both from a judge's and an attorney perspective, and the legal practitioners who appear, that the primary language should not just be English, but should be other indigenous languages. English is not an indigenous language, but it should, African languages should be used in the same way as it should be used in universities. So that's a structural problem in itself. The other structural problem is that because the majority of black people are poor, they actually cannot afford to go to court. So while the minority can afford to go to court, the majority cannot. So injustices that occur to black people, whether in the workplace or in the community, cannot be litigated. So it's the structural inequality in the country is one of the biggest obstacles to access to justice for everyone who's poor and who's marginalized. I think we should not underestimate how that poverty impacts, but for me, we must take a step back. How do we overcome poverty? Everyone blames the ANC as if the ANC government caused poverty. It did not cause poverty. You can criticize the ANC in that in some instances they don't do enough. But or they don't spend the resources, but where would the government get the resources? Because the tax base is so small, because of our apartheid history. So it has a knock-on effect, and all of it together create these blockages to access to justice. I would like to make the following proposals, and I know NADEL, and I've spoken to NADEL, a few people. How do we provide access to justice as lawyers and organizations of lawyers? For me, the first thing that I would say is this. We should encourage the parts where the DOJ has said we are going to look at alternative dispute resolution mechanisms, such as mediation, and put far bigger emphasis on that, which is cheap, it's cost effective. We must use regulatory bodies such as the Public Protector, the BE Commission, the Human Rights Commission, where if you wish, you can get attorneys to assist with compiling complaints. But in most of these institutions, you have fairly accessible ways that you can do the complaints. And my experience in working and assisting clients with that is that they're also very helpful and accessible. So that's the first thing. The second thing I would say is organizations such as NADEL should spearhead, if you are going to use the courts, because you can use the courts, is to initiate actions on behalf of communities or individuals or groups of individuals that really give effect to the Constitution, so that you have precedent-setting, innovative litigation. That is not happening enough. So the people who are using the Constitution to stretch and defend and reinforce their rights, unfortunately, are white people who often work through business organizations or through NGOs. For example, the mining charter. They go to court to block transformation, but they also use the Constitution, and you can't blame them for that because they are there to defend their interests. The fact that their interests are at variance with the interests of the majority of the people is really not their problem. It is our problem. So for me, I would want the organizations such as the NADEL to be far more proactive in utilizing the Constitution to seek reparations for the damage that apartheid has done to Africans, to initiate litigation that gives practical effect to the Constitution, because there hasn't been enough like that. And I was reminded by a member of the National Black Bar Associations in the US, when they came, they still do that, they assist the BLA to do trial advocacy. And he said this, in 1996, he said to a few of us who were standing during a break, if you are not careful, the people, white people in this country who are opposed to the new democratic order are going to use the Constitution to retard transformation. So you have to get ahead of that, and you should use the Constitution, because the Constitution is flexible. It is a framework, and you need to use that to make sure that the rights that have been won through the sacrificing of so many people, including their lives, are not set back by the people who are fighting back against any kind of change. And that did not happen. And look at it, if you look at over the years, the people who have gone to court on issues of language, usually Afrikaans, issues of institutional change around BE, employment equity, those have been white people, and in some instances they have won. And again, the issue of how expensive litigation is, that also assists, because the intergenerational wealth that they've accumulated through apartheid have been used by them to continue to maintain apartheid institutions and apartheid ways of doing things. So for me, we have to ourselves, we can't blame them. We on ourselves have to do the opposite to advance the interests of Black people in this country. And as I say, the other issue around justice is, so access to justice is access in the first instance to the profession by Black people. There is not a single major majority Black-owned law firm in this country. This is 27 years after our democracy. Not a single majority Black firm, a large firm. When I say large, I mean 50, 100 attorneys. And that's a problem. But that speaks to a continuation of apartheid-like procurement policies by both the government and the private sector. And I understand that BE has changed some of that. So I think Black people, I mean, when I was in practice, I was a beneficiary of the government's insistence on expanding procurement to Black firms and giving preference to some Black firms, but not enough is done. And I'm very proud that during our term, and Olita knows here how we fought during the first term of the Legal Practice Council to facilitate the legal sector code, which at the moment, I don't know what's happening at DTI. We had submitted it to DTI in June. I don't know when it will be published for comment. It's a matter of great concern to me that it has been stuck there for 6 months. But I'm aware that the Minister of Justice, the Solicitor General is very passionate about this, and we have the support of the government on this. So when the legal sector code comes out, it will set very clear targets, and it has a transformation fund to assist Black legal practitioners to enter the profession and to survive and to flourish, to do more than surviving. At the bar, you see that particularly with Black women, they struggle to survive. And the system does not advantage them in the same way that it advantaged white men and women. So if we can do that, the other intervention that I think is really important is actually organizations such as NADEL intervening in litigation. And again, I want to make a reference of the mining charter application, which was fundamentally an application to block Black people from accessing mining opportunities. I think the Black Business Council intervened, but NADEL cannot simply limit its concern to what happens in the law, because those communities that are affected, those business people that are affected, they may not have the wherewithal, the means to intervene. NADEL should step in and intervene. And, you know, Mr. Motlatsi mentioned the issue of contingency fee and getting bridging finance. There is no reason why NADEL cannot combine with other similar organizations and set up a litigation fund, because typically litigation funds take about 50 to 60% of the money that is awarded to successful claimants, and do it at a reasonable 25% to advance the ability of people to litigate in the court, even though it's expensive. The last suggestion I want to make, in terms of the structural impediments, is when Europeans invaded our country and our territories in all parts of Africa, but in South Africa, in this region, because South Africa is only a state since 1910. Effectively, what they did is not just to dispossess Africans of their land and impoverish them, prevent them from education. They also destroyed, in a very systematic way, indigenous systems of governance, religion, culture. And one of the institutions they destroyed was the legal systems, because there were legal systems there were institutions that attended to resolve disputes, both here in South Africa and in other parts of the continent. The current system is insufficient to deal with the backlog. We constantly hear about the backlog in criminal cases, in civil cases. Perhaps it's time for organizations such as NADEL to take the lead in doing research into pre-colonial African legal systems, because they existed. Which of those legal systems can be utilized and brought in to supplement the court system that we have now? We cannot remove the court system, and hopefully we can change the culture of the legal court system. As I say, for instance, language is one. How can we make court actions less expensive? But in addition to that, set up other parallel ways of resolving dispute, which we already have in, say, as I say, in the public protectors or when people complain. But I think for me that is really important towards restoring our cultural and psychological equilibrium as a people, instead of being surrounded by institutions that have traditionally not been part of our indigenous systems, but we have no alternative but to use them. But we have to change those systems from within so that we blend indigenous African systems with these European systems, which were imposed on us and which we have no alternative now but to use. So I'll end there. Thank you.
Thank you so much, Ms. Kunda, for the thought-provoking input. I think the idea of decolonizing our legal system has always been an ongoing debate, and I think as part of addressing the issue of structural impediments to access to justice, these are issues that we should continuously engage on. I think what I'll do now, I'll call on Max, our comrade. He has been introduced and he's warned me not to introduce him again to speak. So thank you.
Thanks, Chair. You know, these introductions are very long. I want to answer a question that the President Nojese asked earlier on this morning. Is that question, are we sellouts? And I suspect this room is full of sellouts, if not all of us are not sellouts. You know, President Pius Langa did something interesting during the TRC. The legal profession, the judges refuse to account in the TRC. The attorney, the ALS then, the predecessor of LSSA, did a presentation in the TRC, and that presentation you will find in a small book that NADEL commissioned. And maybe Pfizer can still distribute those copies. There's an interesting paragraph in that submission by ALS, penned by Ashwin Trikamji. It's a very embarrassing paragraph, because essentially it's asking a question: where was the legal profession during the brutality of apartheid? And the collective response of the organized legal profession is that we actually didn't know that there was apartheid. Ashwin continues to say, I heard about the extent of abuse of human rights when I attended the IBA conference. And I'm afraid there's a possibility that this group of lawyers that is sitting here and all of us as organized profession, we will give an answer like that when we are being asked, when these levels of poverty were increasing, where were you? Because if you're sitting in a country where 55.4 people, 55.4 of its population are living in extreme poverty,
accounting for 30 plus million of our people in a state of poverty. If you're living in a country with a Gini coefficient of 63, meaning therefore that the huge levels of inequality have not just been persistent, that they have been increasing since 1994. Where then have we been? And it talks to what Sis Christine is talking about this structural inequality, which in the end will affect how we access justice. And I want to start, Chair, by saying the first impediment in terms of access to justice is the institutional framework, the legal framework, and the extreme sense of low levels of imagination amongst the leadership of this nation. One of the things that continues to fascinate me is these laws about BEE. How is it possible that less than 10% of the population is required to empower 92% of the population when we are supposed to be in control of resources? And I think it's critical that we begin to say, how do we reimagine the colonial economic structure that the country has? But the second thing is that many of us participate in the design of various policies, various legislative framework, which are extremely exclusionary. And many of our people are on the periphery of the economy. And in many instances, it's called the law. And the end result of that is these extreme levels of unemployment that we are talking about today, where almost 46% of our people are unemployed or not even in tertiary institutions. And there's no way many of those people will be in a position to access justice. Our role as lawyers in terms of the market distortion when it comes to fees, our benchmarks are completely atrocious. It's very difficult for me to find out how do we justify fees of 5,000 rands, for instance, per hour. Who can afford us? But at the same time, we must ask ourselves, how then do we practice in an environment of the new apartheid, where the economy puts the majority of the people on its margins? Many of our people operating between suicide and insanity. And similarly to what Christine is talking about, when we talk about this issue of access to justice, it's not only the being present in court, it's what becomes our role in ensuring that there must be access to decent work, there must be access to decent housing, there must be access to food, so that we don't just talk about elevation of poverty, but we mean it when we talk about the need for the complete eradication of poverty. How do we talk about access to reparations, access to education? And in the end, how then do we enforce those rights by ensuring access to courts? The two responses that you will generally find, one is the various liberal ways which assumes a functional society, where many of the law firms will have pro bono sections, which is essentially about guilt cleansing, rather than being part of the day-to-day struggles of those people that we're supposed to assist. We need, Mutlatsi, the simplification of this contingency fee arrangement, because it can be a critical matter, but we have complicated it because we have designed it in such a way that it's not meant to serve those we seek to protect, but for continuous accumulation for ourselves. It's many years now that the judicial system we have done away with. I think we need to go back and say, how then do we relate to the legal aid services in our country, and how do the ordinary lawyers play a role in that regard? Whether civil matters in their majority must be dealt with by the legal aid. A greater cooperation between the organized profession and other institutions like the law clinics at universities. And in the old days, there was even an extraordinary efforts where we will have partnership with Transnet, where the trains will stand in various areas of our country, and for a specific period of time, our lawyers were working on those trains, providing the necessary advice and support. The issue of public interest work should not only be left in the hands of the Legal Resources Center on the liberal side or AfriForum on the right-wing side, but I think we need a greater number of progressive lawyers that are part of the public interest litigation. But even those of us that are teaching law needs to make sure that the younger generation of lawyers, public interest work is part of their DNA. We haven't spent enough time as NADEL, Justice Madlanga, to have a serious discussion about what becomes our relationship with the Chapter 9 institutions, and how do we work with those Chapter 9 institutions and ensure that they fulfill their responsibilities. When I became part of NADEL here many years ago, Henry Lerem, the one that has just spoken here, will attest to this. Mr. Lerem made a mistake. I don't think him and his wife has ever hosted so many black people in his house. And he decided to host this NADEL PE and Districts AGM. And his wife was very friendly, saying, "You're all welcome." And I remember Roland says, "We will show you when we appreciate being welcomed." Mrs. Lerem by 9 o'clock really was fed up with us because we've been there for the whole day and his fridge was empty because we really showed how much we were welcomed. But it was the time that NADEL had established advice centers up to Grafrenet, because it was important for us that even the farm workers are able to access us. And those were the difficult days when we were not able to charge the levels of fees that we are charging, but we were able to be part of the day-to-day struggles with our people, and they were really appreciating us. And I'm wondering what happened to us today when we are unable to do that, because we have to answer the question, in whose benefit is this democratic dividends? Whether, Comrade Nokesi, are we on course to meet the demands of our Constitution, of healing the divisions of the past, establishing a society based on democratic values and justice and fundamental rights, whether we are part of improving the lives of our people to ensure that they are able to reach their potential. My question is whether we are on course to do that. So my point, Comrade JB, is to come back to that spirit that you guys inspired many of us as young lawyers to join NADEL as a progressive lawyers organization, not that is self-serving, but that knows that it is important that we ensure that justice is justice for all. It's important, comrades, that we undertake these tasks so that we are not answering the question in a similar way that Ashwin Trikamji answered. many years ago when I was invited in Namibia in solidarity with the Zimbabwean lawyers, and everybody was blaming the government of Zimbabwe. It was really about lambasting the government of Zimbabwe, but unfortunately nobody checked my speech. So when I went to speak, I spoke on behalf of the Zimbabwean government and the poor people in Zimbabwe, because I was saying when the sun was shining, many of the lawyers in Zimbabwe spent all their time shifting and shuffling shares between white capital and ZANU-PF oligarchy. And whilst doing that, the numbers of poor people were increasing. They increased to such an extent that that country was not able to cope. And when people rose up against Mugabe, Mugabe joined the poor people against white capital and against the lawyers. I'm afraid if we don't act quickly, the poor people in this country might also reject us. Thank you very much.
Thank you, Comrade Max. I think at this stage, we will allow a question and answer session on those issues raised by my two panelists. Thanks, Prof. I'm noting you, Comrade JB. Okay. Comrade Makanyela.
Thank you. Comrade Makara is intimidating me here. The Joburg complainants, can you just look forward, Chief? Thanks. It was just on a lighter note. I have 2 points to make. That perhaps in the input of Comrade Max, relatively some of the fingers are pointing at the attorneys, and to a certain extent that they have abandoned that obligation to our communities. But before I get there, I just want to say I agree with that point of the access to our courts. In fact, physically, Ramex, physically, if you go to the villages, people can't go to court. I mean, a human being, because there is no bridge. The rivers are overflowing. They cannot even access those offices of the lawyers that are operating in those spaces. So it's that issue that was raised by Krish, of social issues that need to be addressed before. Systematically, we are going to come back next year, raise the same issue. We'll come back that other year. Prepare yourself, that will always invite you. Even if you say you retire in your active service, we'll call Max. Max once talked about this issue. Come, talk to it. Because there are these social issues that are there. They create that gap. So before one can go to an attorney, whether cheap one, but there's an issue for him to leave his house because there's no bridge, there's no car, there's no road for them to access those services. So that is the reality. That is but one. Then 2, there's an issue about the interpretation of the statutes and everything else. Inherent concurrent jurisdiction of the courts. If you want to know how the Eastern Cape is structured, you know that in the border of KZN in Margate, that is Bizana. So that Bizana would be falling under Mthatha High Court, which is 3 hours from Bizana. Grahamstown High Court, Makhanda High Court or Grahamstown High Court pronounced itself on the issue of the foreclosures. Somebody has been paying for this house, as a government employee, has been paying for this house for the past 18 years, defaulted for 2 or 3 months. The bank leaves Mthatha, comes to Grahamstown. You talk about somebody who defaulted for 3 months. It means this person cannot afford to pay for an attorney closer in Bizana. That attorney must pay for a correspondent in Grahamstown. Now, in the agreement, it talks about the jurisdiction of the magistrate court. But the big banks, because those are the capitals that you're talking about, they've got that muscle to access any court anywhere in the world. They choose to go to the High Court. Now the matter runs to the SCA, because now an interpretation must be the question of is it inherent jurisdiction? Because what is it that stops the High Court from dealing with this matter? Again, what is it that stops Grahamstown, not Mthatha, the one that is closer to the person, to the most needy person, from dealing with this matter? It does not only end with practitioners, as well the laws, the lawmakers, when they create this, it's more like really they are in the comfort of their air-conditioned offices, there by the Sentin. They have no idea of what is actually happening on the ground. Thank you.
Thank you, Comrade Makangela. Comrade JB.
Thank you very much. My comment will be based only on 2 points. Firstly, a point that was made by Usis Christine Kunta, and then secondly, the one that was made by Comrade Max Wakwana. Starting with Sis Christine Kunta, she mentioned that access to justice is not only the competency of the judiciary, in other words, the courts. That raises immediately the question to say there are lobby groups in South Africa. The big question is, what role is NADEL playing to ensure that there is access to justice to the marginalized, the poor, or the poorest of the poor? And I want to come to the point that was made by Comrade Max Bakwana to say the advice centers where attorneys volunteered to go and give free legal advice. I once made such a point in a meeting which was held, I think it's in Rosebank. And then the big question was, is it really still time where you will find lawyers who will volunteer their legal work free of charge? But it's not yet uhuru. Many people are still suffering. And then there are a lot of challenges. And yes, we are, as the Freedom Charter was saying, among others, that the people shall govern. We are governing. But when you look at the socio-economic rights, many people who were not having those socio-economic rights are still battling in terms of land. People have submitted claims before the 31st of December 1998. Most of them have passed on. Their children took over, and then some of them also have passed on. The second generation is still battling. It's still battling with those claims that were submitted before the 31st of December 1998. And then also the reopening of the land claim, which was attempted in 2014. In 2014, you will recall that there was a big challenge, and then that reopening of that window was put on hold. Now, is there something that NADEL can try to fast track it? I remember the president, when he was giving the State of the Nation address, said that process will be finalized before the end of this year, 2021. But one doesn't hear where the process is at the present moment. And then in conclusion, I promise that I will be brief. in conclusion, I once attended a seminar organized by the Pretoria branch of NADEL. There was one professor, I forget his name, who said, in South Africa, the reality is we don't have the three arms of the state, namely the legislature, the executive, and the judiciary. The professor said, in fact, we've got 4 arms of the state in South Africa. It's a sui generis set up. By the mere fact that we've got Chapter 9 institutions, Public Protector, the Human Rights Commission, and specifically the Human Rights Commission, when you look at what was the intention of the legislature when it was established. Section 184 talks about the functions of the Human Rights Commission. And then among others, it says the Human Rights Commission has powers, or the power, as regulated by the national legislation, the South African Human Rights Commission Act 40 of 2013, necessary to perform its functions, including the power, I want to emphasize, to take steps to secure appropriate redress where human rights have been violated. Those are, in other words, powers that the marginalized people need not go to a judiciary for legislation, but there is an institution, an independent institution, one of the state institutions supporting constitutional democracy. But I want to state this to say the South African Human Rights Commission needs some hands, needs some support, needs to partner with organizations like NADEL. NADEL, which initiated the creation of these institutions. We spoke about the establishment of a public protector or human rights commission to say we need to deploy or task our members to occupy those institutions so as to realize the dream of the founding fathers and mothers of NADEL. Thank you very much.
I see another hand. It will be my last round, so I notice only 2 hands, so I will hand over to you for your question or comment. Thanks.
Thank you. I'm a bit vertically challenged, so I hope you're all going to hear me. I'm Onesimo Mkumbuzi from Tata branch. Mine is just one thing. I haven't heard of someone speaking about the issue of the former University of Transkei, that is Walter Sisulu University. There has been a decision that has been taken by the university that the LLB degree is going to be moved on permanent basis to the East London branch, meaning that in Mthatha it's going to remain only on the part-time basis. Maybe it's going to be taught once or twice a week, only in the evenings. And you know that that may end up removing it altogether. We know what we've been through before when the accreditation was taken away and all of that was rectified. Now, it seems to me that there's this issue of wanting to do away with everything that's good that's happening in the former Transkei. Others may recall that not long time ago, our court wanted to move appeals to the Grahamstown court. We fought for that, and then it did not happen. There was also another issue of wanting to move the deeds office to King Williamstown, bearing in mind how many towns that the High Court of Mthatha services. Also, we fought for that, it did not happen. We're not sure if they're not going to bring that back again. So now my issue is, what is NADEL going to do about the issue of LLB degree being moved on permanent basis to East London, knowing very well that there are many institutions, they've got your Forte and many others, but now it seems that our government, to put it to put it better, our government, it seems that they do not want us to develop in that part of the country, not talking about many other things, the development and all those things that are not happening, but my issue is on those things, that what is NADEL going to do about that? I don't think we should be quiet. Thank you.
Thank you, Comrade Onesima. Yes, Comrade Sipa.
Thank you, Comrade Chair. Comrade Chair, mine is just to deal with the NADEL existence as a human rights organization. And I'm looking at our report, the Secretariat report, and the other reports. Chair, if we say we are a human rights organization and we talk about access to justice, and our reports do not reflect that, it means that our existence is beginning to be questioned, and in fact, we should question ourselves about our own existence as a human rights organization. Chair, I propose, therefore, that the standard report of the Secretariat should indicate the work of the NADEL on the year that is under review. On what work have we done on the human rights, or what projects have we been able to achieve? And the second point, Chair, that if we do not ensure that on our agenda as NADEL, the decolonization of a justice system is not toppling up our agenda. And we might as well stop to call ourselves as a human rights organization. Chair, I'm raising these things understanding that if you have a case that occurred somewhere in 2016 and it's still pending in court today, and what do you talk about is that access to justice. We know that justice delayed is justice denied. Thank you, Chairperson.
I think, I'm not sure if Ms. Konde is still available online. I would like to give my panelists just a final shot and reflect on the comments and the questions that have been raised. Over to you. I think you are muted.
Okay, sorry. I just wanted to respond to Max's issue around BE and the fact that it's actually not 10%, it's 7%. That's the number of the latest 2020 figures of white people, and white men would probably be about half of that, which is 3.4. So the problem is, it's the nature of the deal that was struck in 1994. So we really have to comply with that compromise and do institutional transformation piecemeal. I agree with him. It is absurd in a normal sense, but it's also not absurd in the context of the compromise, because 1994 was a compromise. It wasn't a revolution. And unfortunately, probably this generation, the next generation, will have to participate in that institutional and transformation initiatives that we are busy with, which is sad. But ideally, what should be the case is that Africans, who constitute 80.9% of this population, should be the one in control of the economy, like it is in other countries, where indigenous people run the economies, even in other parts of the continent, in West Africa. But we can't do that. So BEE and employment equity legislation, it's the best kind of intervention that the government has made, because in the absence of that, my view is that white people have absolutely no intention of giving up the power that apartheid gifted them with, and therefore we have to, through the government and through the efforts of non-governmental organizations, Black organizations, do the best to do that institutional transformation and restructuring, and BE is one of those. So unfortunately, yes. But I think it's also not just BE, it's employment equity, and as I've urged NADEL and all other lawyers to do, is to participate in stretching and giving practical content to the Constitution, because the Constitution is a theoretical document. It has to be populated and given substance by our own effort. No one else is going to do that for Black people. All the NGOs, the white NGOs, white-run, white-funded, Western-funded NGOs, there is not a single one that have called for reparations, not a single one that is geared to move forward land reform, and that is normal. Why should they do that? We are the people who should be doing that. We can't look to them to do that for us. So that's my comment. Chair, thank you.
Thank you. Comrade Max, Monica. Thank you.
Mrs. Christine, I'm going to come to Cape Town, and we have to talk about what you are raising. I do not understand why will we not pass regulations that whoever owns the new PPEs or anything that comes with the new energy business must be 90% Black. There's nothing in the 1994 agreement that says we can't do that. It's because of our cowardice. Simple why we can't do that. There is nothing that says the land that is there and we cannot proceed with its distribution, and instead we keep on having conferences and workshops and all manner of things. I suspect it's our cowardice that is dealing with that. The government and the Deputy Minister is on the line. The government is coming from the 4 West African states, and our president was saying they've made deals. What's wrong to say the person that will be responsible for those transactions will have to be 90% Black lawyers? There's nothing in the 1994 agreement that says we can't do all of these things, because I think the problem is not the 1994 arrangement. The problem is ourselves that are still sitting on wheelchairs because we've got a suspicion that we are disabled. But the key thing is for us to abandon the wheelchairs and get out of the wheelchairs and direct this economy in a manner that has to be properly restructured. Onesimo, that question you raised will be answered by Nokesi in respect of the LLB and the University of Transkei. But I think it behoves on all of us to relook at this issue of legal education in our country. It comes back to the issue I was raising earlier on, that we are now producing lawyers that can write. We are producing lawyers that can read. We are producing lawyers that can count. But we are producing lawyers without social consciousness. It's a disaster for the future. So we need to relook at that framework. And when we go to all of these universities and say this architectural design of a transformative legal jurisprudence, does it exist? So I think as Comrade Nokesi is engaging with you on all of those things, it's critical. I think, Makangela, when you raise the issue of these structural deficiencies, you know, there's something that are really, really frustrating. If you look in front of this building, there is oil tanks there that were condemned in 2003 that are supposed to be removed so that you can give this city a possibility to develop. There's been a number of investors that will come to Kucha and say, we will move all of these things. But the impact of regulations, not understood by those that are in government and in parastatals, and ourselves not engaging them to making sure that investment is done in a manner that is not confused. That will help us grow this economy. But the economy is stagnant because there is no imagination in terms of what, in reality, we need to do around those matters. So I think that when our government talks about investments, I think we should be in the forefront in ensuring that the policies on investments are very clear, the benefits on investments are very clear, the regulations around investments are also very clear, because in the end, we need to produce a society that grows the economy, because the possibility for us to respond to all of these structural deficiencies will be the matter of a growing economy. But just the last point, Makangela, that you raised, I mean, you must speak to this comrade here in Danga. When there was this big problem of people locked in places like Diepsloot, when people couldn't access food, it was inspiring to get the NADEL branch in Johannesburg themselves going to those communities and then making sure that we not just sit on the outside as lawyers, but we engage with those people in a meaningful way. So, and I think that's what is possible from all of us as NADEL if we abandon the wheelchairs. But the point that Comrade JB raised about land claims, etc., you know, there's an advocate that was sitting there in the corner. We've been doing one matter since 1998. Today, that matter, so the various generations of the claimants died many times ago. So when I was speaking to the recent claimants, they don't even know how this thing started in the first place. But in the end, you have the landowners that were there, not supposed to be paid anything else, but get paid millions of rands. And you still left the land undeveloped, and you still left those communities not having obtained their land. So for me, is this issue of this hesitancy and this cowardice in all of those of us that are in the forefront, that are supposed to be dealing with these issues. Because the whole issue of dispensing justice doesn't require popularity. It requires bravery for it to have a positive impact. Thank you very much, comrades, for inviting me, and have a good conference further.
Thank you, comrade. We will close this session, but it raises a lot of issues that I think we need to debate, and probably we'll find time to have a resolution on some of these. But access to justice is not just formalistic. We need to deal with poverty. We need to dirty our hands as lawyers. We can't just be on the periphery. I think on that note, I will call, I'm not sure where is Comrade SG, or are you coming, Comrade President, just to close the session so that we move on to the next session. Thank you so much.
It's difficult to leave my wheelchair. Max, leaving wheelchair is not an easy thing, because really you believe that you are disabled. I think that's a very strong statement. Comrades, I think the program for the day has come to an end. Now, essentially what that would mean is that we are going to get to the program of NADEL as an organization, the closed session. That closed session, because the time now is 20 to 6, we should be starting. I was trying to establish if we can't have dinner now and then come back and proceed until we finish everything. So at this stage, I'm just waiting for the SG to inform us about that possibility. But let me take this opportunity and thank all our speakers, all our guests. We have been really informed through your informed, well-researched and counseling advices. We have been enriched. By the time we go back home, I have no doubt that we will say we are a different person than when we came to this conference. It was because of you. NADEL conference has since become a calendar in the legal profession because of the quality of the discussions, the quality of the information that we get. That definitely will empower us as we take resolutions. We will be concluding our resolutions on Saturday, that is tomorrow, and we believe that all the inputs that we have received will inform those inputs. Lastly, Justice Madlanga, I just have to acknowledge this. You have been with us. In fact, always, you are always with us. And I must mention that you have helped us in terms of our constitutional courses that we have been conducting throughout our branches of NADEL. We really appreciate that. Many members of this organization, once they join the other side, they seem to say, we have nothing to do with you. Some people, we just last to see them when we signed the nomination letter. I remember you were even reluctant to go to the bench. We have to beg you as an organization to take twice. You went there, how old were you? 35? 30, I mean, he was 34 when he took up the position as a judge and went all the way to the Constitutional Court. Because when he left, he was acting in that court, he was a judge of the SCA. I mean, really, it's such a kind of contribution, of sacrifice that we're expecting from our people. This is easy to say we must sacrifice, we must sacrifice. Everybody says that language. But if you ask what is the meaning of this serve and sacrifice, they don't know that. I mean, an example of that. Thank you very much. And I would like to also make a special word, give a special word of appreciation to President Maya, who has joined us. President Maya, it's not that she gave me her library when she joined the bench in 1999. She actually came and delivered a speech in the conference of NADEL at Kipton Park. She remained with us. And every time, those comrades in Bloemfontein, I must say this today, our branch there in Bloemfontein will confirm. She allowed our branch, our members, to actually use that court on special activities of the branch. When I went there, I addressed the branch at the Supreme Court of Appeal. That court some years ago, that court some years ago, in fact, I know it from Kombo, say, yo, Bloemfontein is a slagpan. That's how we knew it. I did not want even to go to drive past Bloemfontein because I know if you set your foot there, you will be slaughtered. And even when you go to the court, at the Supreme Court of Appeal, your counsel appears there. You were told that there are instances where you will not even be allowed to say, I appear for the applicant or for the appellant. By the time you appear, what nonsense is this? What do you think is this case? What are you thinking about this? The other one is saying, have you read paragraph 65? Why is just thinking, where is paragraph 65? Where is paragraph 100? People were literally scared. If once the matter is said to be in Bloemfontein, they will go all over the country looking for a lawyer who can be brave enough. I think when I see the comrades from Free State making the Supreme Court of Appeal as a place where they can actually take the young practitioners to hold their own meetings there, it changed the picture. It changed. We appreciate Justice Maya when you come here. And this thing of being with the president of the Supreme Court of Appeal, hey, I always tell at home and say, hey, I was in a very important meeting. Why is it important? Even the judge who is in charge of other judges was there. Deputy Minister, the Deputy Minister is like, in fact, he's a member of NADEL. He has never abandoned us. He gave me a task which I feel, because we're discussing about the issue of briefing and the big firms and our complaint about big firms. He said, you know what, not just can you do one thing. Can you organize yourself just to pretend and do this big firm there in Mthatha? And what we'll do, I will stand by myself and make sure that the government work in particular goes to that firm. I think it was in 2017 or 18. There's not even a move towards that. Each lawyer that I've met said, yo, Aibo, are you, what are you thinking? Me, join another firm. How can I go and share my 50,000 there? There's one fellow, I won't tell you, you will never know who this one was. They had a partnership. They have been friends from school. They went to articles, they started the firm. One of the partners secured work from, I think, the Defense Force. No, he secured work, let me not say somewhere. At the time, the work, there was payment then of, I think it was about 500,000. The other partner started not to go to work. What is happening? He said, hey, I'm worried. I've got work which gave me 500,000. Now I must share with somebody who was just sitting, walking around. Please do everything. Get rid of that man there. That is the kind of challenges which are associated, of course, with this structural arrangement that we're talking about. Minister, we are always pleased when you are with us, and I believe that tomorrow you will be here. Madam Kunta, thank you very much for your participation. I was reading that book that you wrote. Actually, you sent me that book, and then I have to read through. And the things that you're saying today, they are there in that book. And I was starting to say, In these debates that we have about transformation, no one has ever attempted, from our perspective, to define what is this transformation. Everybody adopts a shortcut. No. In that company, there are no black people there. In that institution, we want more black people there. We want more black. I mean, you can have 100 of them. If they are black, right-wing minded people, it's just no work done. We are hoping that we have a foundation. We have people that are orientated, are ideological orientated, some people that understand the directions that we want to take as a country. So when I read your books, I do understand very well that you do understand exactly what we're talking about. It's something that you live. Thank you very much to you. Comrades, as a conference, you have been well behaved, and we are so impressed. It's quite clear to me that we are determined to resolve, to deal with all the challenges that we are facing. You want to renew your organization. You want a fresh NADEL. You want a NADEL that is invigorated, a NADEL that will go out and not only talk on these matters, but take an action. So we are very much pleased with the level of participation. You have been keeping on time. It was us really who delayed in the morning. 8 o'clock this morning, everybody was just here. So that is very important. On that note, I must announce that we will break now. The dinner will be served at 6:30. I think it's on this side, in this hall, will be served from 6:30. All delegates will then be expected back to the hall at 7 o'clock. So you will have your food for 30 minutes. In that additional 30 minutes, we have another. So we're breaking for an hour, and we'll come back at 7 o'clock. So the meeting at this stage is officially closed. Thank you very much.